Good morning. Do we call them in now? Yeah, please. Huh? Say? Oh, so we need to deal with that first as a committee. Okay. Okay, I thought I would deal with that as part of the. Yeah. It's uniform. Yeah, it's not. So, Mr. Lehomo first, and then Mr. Mhlanga. Asifuna uqala ungekafiki. In case you pull a blade on us. Hayi beqala ngekafiki. Honorable members, colleagues from Parliament, members of the public, colleagues from Auditor General, good morning, and thank you very much for being here today. So this is our second week of the Road Accident Fund Inquiry. There are some differences between the way that we're going to proceed from here on and last week. Last week we were receiving briefings from the Road Accident Fund itself, from the National Treasury and the Accounting Standards Board, from the Auditor General, as well as a Special Investigating Unit. Because those were briefings in order to help the committee to orientate itself around many of the issues and the rules that we're going to be dealing with, it was not necessary to swear anyone in. We are now entering the phase where we're going to swear people in. And today we have 2 witnesses. In fact, we've got a total of 3 people appearing today. Mr. Lehomo and Mr. Mhlanga are appearing before us now, and then Mr. John Modise will appear after lunch to traverse issues that are overlapping. What we are going to be dealing with this morning are issues pertaining to the procurement of close protection services. And to be specific, we were informed that the security, the policy at the Road Accident Fund kept that benefit at 480,000 Rand per annum. That amount was exceeded, and we will be looking into that issue. And the 2 witnesses that we've got here today, this morning, and the witness that is coming on later will provide information on that issue. The witness that is coming later on, Mr. Modise, will also deal with other aspects of procurement that the committee is seized with, but we don't need to deal with that now. So the way that we're going to proceed is that we'll deal with the security issues first, and then we will ask these witnesses to stay on, so that in the afternoon, if there are any issues arising out of Mr. Modise's testimony as it pertains to security matters, then they are also available to either refute or confirm those facts, so that the committee is well served in that way. So by way of process, there will be a swearing in, and I will ask, not right now, but I'll ask the Parliament legal team to explain in terms of the rules what needs to happen, and swear the two witnesses in. And then, because this is being streamed and the public does not have the benefit of the affidavits, I will, for the first 15 minutes, just assist the witness to pull out some key issues out of the affidavit, so that the public, when the members start asking questions, the public is able to follow what is going on. The way that members I suggest we proceed today is the following, by way of questions. We won't take questions in batches in the manner that we normally do. Each member will get 10 minutes to have an exchange with a witness, uninterrupted. And then, once we have gone through that round, we will then be able to, if there are any questions outstanding, members will get a further opportunity to do so. But what we did during the briefings, if you recall, we would sometimes take one member after the other, and the questions would be answered as a group. I think we need to afford members the opportunity to ask follow-up questions immediately, so that there is an exchange. The reason I am proposing 10 minutes is I'm taking account of the time. So if each of the members here, and maybe one or two that are coming, have 10 minutes, with some breaks in between, that will take us to about 2 hours or so, just with the question time or so. So that's how we will proceed today. And the only thing I would like to ask the witnesses and the members is that try and answer as specifically as possible the question that is being asked. And also for the members, let's try and be as specific as possible with the questions that we are asking. So may I then please ask firstly, let me ask the witnesses to introduce themselves formally, your full names. And then I will ask Ms. Ibrahim to just take you through the rules of Parliament and what's expected, and then that you swear to tell the truth and nothing else but the truth, or you affirm. Thank you. Please, each of you, you just give us your full names.
Good morning, Chairperson, and good morning, honorable members of SCOPA. My name is Matome David Lehomo, a former Road Accident Fund Security Manager. Thank you.
Thank you very much.
Good morning, Chairperson and the members of SCOPA. My name is Muntu Kosi Dakon Mhlanga, a former Physical Security Manager at the Road Accident Fund.
Thank you very much. Ms. Ibrahim, may I hand over to you?
Thank you so much, Chairperson, and good morning to yourself, the honourable members, and Mr. Lehomo and Mr. Mhlanga. In terms of the National Assembly rules, specifically Rule 168, witnesses that appear before a committee of Parliament enjoy certain privileges, and so I'm now going to read that out to you. Those privileges are in terms of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004. So I'll read those privileges to you, and then I'll ask you to please take the oath, as you've indicated is your preference thereafter. Mr. Lehomo and Mr. Mhlanga, you've been invited to appear before the Standing Committee on Public Accounts to provide information in relation to the committee's oversight inquiry into the Road Accident Fund. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in the proceedings. Please be aware further that in terms of Section 17(2) of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. As discussed with you prior to the meeting starting, you indicated that you would like to take an oath. So I'm going to start, please, with Mr. Lehomo. So if you could please raise your right hand and then repeat after me. I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, sir. You're now duly sworn in. Mr. Mhlanga, we're going to do the same. If you can raise your right hand. I swear that the evidence I shall give
I swear the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth,
nothing but the whole truth,
and nothing but the truth.
nothing but the truth.
So help me God.
So help me God.
Thank you, Chairperson. The witnesses are now duly sworn in. Please note that you will be sworn in for the duration of the proceedings, including if you are asked to come back this afternoon. Thank you.
Thank you very much, Ms. Ibrahim. Just for housekeeping purposes, the affidavit, the main affidavit is from Mr. Lehomo, right? And Mr. Mhlanga, you have read the affidavit of Mr. Lehomo. And where you are mentioned in it, you confirm that his version of what he says about you is true, and you are here to expand on any part of the affidavit that pertains to you. Just use the because it has to.
Yes.
All right. Thank you very much. So that's the first thing. The second thing is that as we proceed here, so all answers are directed at the chair. So the members ask through the chair. That's the first thing. The second thing is that because the event is being streamed, so it's very important that you are audible on the mic so that the people outside can also pick up the sound. Otherwise, they keep coming into the room to say that they cannot hear. Just so you know. The final housekeeping issue is for me to ask Mr. Lehomo if you've got a copy of the affidavit in front of you.
I have a copy, Chairperson.
If you could turn to page 17, which is the final page, just to confirm that that is your signature.
Chairperson, this is my signature.
Right. So thank you very much. So I'm just going to take a few minutes because I don't want us to read out the whole affidavit. And then I might ask you to just explain terminology because sometimes we might not be familiar with certain things. So I will just ask you sometimes to expand on one or two things so that our understanding of what you mean is the same, right? So the first part of it just deals with your background and overview in this affidavit. You joined the Road Accident Fund in May 2003 as National Security Manager. What does the role entail?
Chairperson, the role of a National Security Manager entail management of physical security, information security, the occupational health and safety, and the role is was responsible for the security of RF offices nationwide. Thank you.
Thank you very much. So you say in paragraph 10 that you maintained an active SSA security clearance throughout your rough employment. SSA, I'm assuming that means State Security Agency.
That is correct, Chairperson.
Can you explain how that, at least the process that you went through in order to obtain the clearance and what it means in terms of the job that you do?
Chairperson, when one undergoes the State Security Agency vetting, one is required to fill in a form called Z204, which is a State Security Agency form. And after that, then the State Security will then conduct some interviews. They will conduct their own investigations and issue, depending on the level of the risks that they would have found within a specific organization or the person responsible for that position. They will then issue a security clearance so that to ensure that that person does not have access to the information that they wouldn't necessarily have to have access to.
All right, thank you very much. So there is also something called, so if you can just switch off the mic when you'll get used to it. So when you finish speaking, just switch off. So you mentioned that there is a RAF security policy aligns with the minimum information security standards and designates SSA as custodian of information security. And then you say SAPS accordingly conducted, upon the appointment of the former chief executive of the Road Accident Fund, conducted a threat assessment which you initiated in accordance with the policy, which found no direct threat to his safety, both at his residence and at his office. I would just like you, for simplicity, because I don't want us to go through line by line through the affidavit, just explain to the committee the level, why you initiated the threat assessment, firstly, and secondly, the level of security accorded in your experience, because I see you joined in 2003, so you had been at the Road Accident Fund for quite some time. Just explain the type of security arrangements available to a chief executive of the Road Accident Fund. So it's why did you initiate it? And secondly, just explain the level of security accorded in your experience to any chief executive of the Road Accident Fund.
Chairperson, the threat and risk analysis, which we normally refer to as the security assessment at the Road Accident Fund, is governed by the security policy. And how we conduct it, as soon as we are aware of any appointment of a chief executive, it can also be any other employee for that matter, we will then issue them with the Z204 form to commence with the process of vetting. So that process will apply to any chief executive officer. So that is a standard process that we follow for any other chief executive officer that comes to the Road Accident Fund. And this particular, the policy itself is in compliance with the minimum information security standards, a document which was approved by Cabinet in 1996. So that is where everything comes from as part of the information security audit. And this standard, Chairperson, is applicable not only to the Road Accident Fund, it will apply to SOEs, and it will also apply to government institutions. And the key driver of this, the process, is the State Security Agency, Chairperson.
So that's the why you initiated it. So can you explain the level of security generally? I mean, do road accident fund chief executives arrive there, look after themselves, or how are decisions taken around what level of security? Because there's an assessment by SSA for a clearance.
Yes.
Then there is a threat assessment. So I was asking about the threat assessment. Why did you initiate a threat assessment? And what did that result in by way of the arrangements that you then have to make for the chief executive?
The threat assessment was initiated. For starters, the information security. SSA is the custodian of information security, and SAPS is the custodian of physical security. So therefore, when you need to determine a level of threat against any individual, you will then write a request to the South African police, which we did, to assess the threat level against our CEO at the time. And the SAPS responded, and they came to conduct interviews with him, and they will also conduct physical assessment of the office to determine the level of threats at the office, and they will also conduct that physical assessment at the residence of the particular person, in this case, the former RAF CEO. So that happened, and thereafter they issue a report. In terms of this report that they issued, the indication was that there was no direct threat against the former road accident chief executive officer.
Just remember to switch off the mic. No, that's fine. You'll get used to it. So what I want to know, however, because the road accident fund is a complex environment, multiple stakeholders, lots of people being unhappy about one or other thing, the size of their claim, how long the claim is taken to assess, etc., from individuals to institutions that may or may not be happy. Is it that, therefore, there has been instances where the chief executive officer just has to look after themselves? I'm trying to understand the implication of the SAPS's assessment. Does it mean you may not provide security at all, close protection services for the chief executive, or you are directed to, you are guided to still provide security in one way or another?
A security assessment, Chairperson, is a baseline for any security, any provision of a security measure. In other words, you cannot just decide to say, I provide this particular measure, and then the question is based on what? So the security assessment will then at least will be a baseline to provide any security measure in any government institution.
So did that mean for you? And I'll come to you, Mr. Mhlanga, if you wish to come in. So does that mean the chief executive officer then, at least in as far as the threat assessment from the SAPS, should not be provided with any security at all? Is that the implication? That's what I'm trying to understand.
That is not the implication, Chairperson. The threat assessment, if I may just give an example, there are instances whereby you find that you request the SAPS, and they might perhaps experience some delays in terms of coming. And as a security manager who's fit for purpose, you are then, because we can also do risk assessment on our own, but we normally depend on the on the SAPS one or the private one. However, until SAPS come to confirm, the type of security that you may assign at that point will be on interim basis, pending the final assessment by the SAPS.
All right, thank you. I don't know if you look like you wanted to come in, Mr. Mhlanga. I'm trying to understand. The specific question I'm asking is, if SAPS, because all of this threat assessment has been done, and they said there is no direct threat, how does policy guide you then? Does it mean the chief executive officer cannot be afforded security by the organization at all, or does the organization still have discretion to provide some level of security? That's what I'm trying to get to, because I want to know what were you then going, what steps were you going to take following the threat assessment from SAPS?
Okay. Honorable members and chairperson, when it comes to the security of the CEO, actually all the employees of the RAF, not particularly only the CEO, if there is a threat discovered or after risk assessment has been done, and then we found that there is a threat, or the report comes back saying that there is a threat against an individual, then a security arrangement is made for that particular individual, either being a CEO or any other employee. So when it comes to your question, Chairperson, there is no specific security measures that were, like I would say, dedicated for the CEO, except if there is a threat risk assessment done, and then the information or the report says there is a threat, then we then provide. So the only security that you will get, it will be the same as other employees at the Road Accident Fund.
Okay, in other words, there is no security put in place. If the SAPS says there's no threat, then there is no security put in place. That's what I'm trying to get to, colleagues.
Chairperson, perhaps let me answer it by being specific to the case of the Road Accident Fund.
Yes, that's what I mean. In the case of the Road Accident Fund.
So what in this case, what happened is that after the SAPS has concluded their assessment, then there was another threat against the CEO, whereby the vehicle was broken into somewhere in Pretoria. And then we had the case number. So based on that, that is the only way where you can then say, well, you write back to SAPS. When you write back to SAPS to come and review the assessment, that's when my senior manager Brian Furness said that I must rather do a private assessment on the CEO based on the second threat and the legal advice that was sought then, just to be specific to this case, Chairperson.
All right, thank you very much. So basically, your version then is the chief executive is parked somewhere in Pretoria. So I'm assuming that the chief executive was not in the vehicle when this happened. Am I correct?
Yes, Chairperson.
Yeah. So the chief executive was not in the vehicle. He comes back to the vehicle to find that it has been broken into, reports this back in the company, and then your Mr. Brian Furness in paragraph 14 instructed you verbally to engage a private security company to conduct a risk assessment. So that we do not tell a long story, the members can see the affidavit for themselves. You say the private security company produced a report recommending the provision of close protection. And based on this report, Mr. Ian Barrell, you then prepared a business case. It does explain the process that you went through. So just tell us in brief what the recommendations of the threat assessment by private company, one, and secondly, what was the basis of your recommendation in paragraph 16, which is for 1 driver and 2 protectors.
Okay, Chairperson. So the private security company produced a report recommending the provision of close protection services for the CEO. And based on this report, the Chief Human Capital Officer, Mr. Ian Barrell, and I prepared a business case for the consideration of the board, which recommended 3 protectors consisting of 1 driver and 2 protectors. So this approach was based on, remember, Chairperson, I said my senior manager said we must rather go private, as was the case with one former road accident fund chief executive officer, whose protection. But then the difference here was that the former chief executive officer had the same complement, 1 driver and two protectors. However, he was using his own vehicles. So the close protectors were using his own vehicles. They were not using the road accident fund vehicles. Something that, because I was told that we must follow the same process we followed with the former. So my understanding was that we are procuring these services, and then he will then, in the interim, this was just an interim measure whilst we await the subs to review their assessment. So the approach was based on the case study was the one of the other former chief executive officer. That is what we were following, and that is what informed these particular numbers, Chairperson.
Sorry, switch off the mic. So you say you asked SAPS for a review of their initial threat assessment. What did they say upon review?
Chairperson, up until I was removed from office, they hadn't come to conduct that. And remember also, the other reason is that there was a security specialist who was seconded to the road accident fund. So in other words, as soon as he arrived, it seemed like he took over everything. So from that point, in other words, from June 2021, Chairperson, I was no longer involved. I was sidelined.
All right, thank you very much. So I just want so we'll jump a bit because the members have got the affidavit. You've got it as well, and you can refer to it if any of the members ask. You are saying there was a board resolution, therefore, that basically kept the allowance as a fringe benefit at 480,000 Rand per annum. This amount would cover at most a minimal security detail, e.g. a rotational driver with protection officers for travel to and from work. So basically that was the resolution of the board. Was this, just tell us how this was, who communicated this to you and how was it communicated?
Chairperson, the resolution was issued, and I think the secretariat at that time of the board communicated this to the security and to Mr. Ian Barrell, who was then the executive chief human capital officer. I think he was in acting capacity, Chairperson. So it was communicated to him, and eventually it came to myself, obviously through through the senior manager facilities, the one who then said we need to engage the private. Chairperson.
So how was this private security procured? Who did it? Is it you? Who chooses that security? Can you describe the process of procuring that service? Or you were not involved in that either?
Chairperson, I was involved. The process entails you then prepare the memorandum. It's what we call a business case. In this instance, is to the executive management to say we need to procure this particular service for these particular reasons. So this business case was then prepared, and after approval, and I cannot recall now who is the executive who approved it, Chairperson. So after it was approved, as a department, we then come and do do what we call MTS. The motivation to source, MTS. I'm sorry, it's just the terminology. I wanted to get it right. We do the MTS, motivation to source, and as soon as that MTS within the department, and normally it's me who will approve it. Mr. Mhlanga will normally prepare it as a physical security manager. But remember, the MTS is not a new document. It's a document that comes from the memorandum that is already approved. So now we are now just processing this thing. So as soon as the MTS comes and is signed, is then loaded. In other words, it activates the supply chain management process. Supply chain will then get this approved request for them to source. So in that aspect, we are not involved. It's the supply chain that then engages the security companies. But Chairperson, I should state that there are instances where, because they are not experts in everything, they will come to the business, the department or business units to say, if you may assist us with maybe other suppliers that you know. But we are not involved in terms of who to be appointed and stuff. The SCM will then conduct their own process, and then in this instance, they then appointed a supplier who was not part. The supplier who conducted this security assessment was not a contracted supplier with the RAF. It was a new supplier altogether. So that is the process, Chairperson.
Okay, can I just ask, why wouldn't the Road Accident Fund, if the previous CEO had security, why is this outsourced? Why are these, don't you have permanent staff in the security department who can perform this function?
Chairperson, as I said, any security measure, including close protection, the baseline is security assessment. So, as of 2019, before the acting CEO was seconded to the Road Accident Fund, there were no internal close protectors. So it's an outsourced service altogether, Chairperson.
All right. No, thank you very much. So, Mr. Modise will come and speak to the procurement part of the security contract when he appears this afternoon, along with other procurement matters. So you then also talk about the introduction of a security specialist. To save time, can you just take us through what happened there, broadly speaking? The specifics we can canvass with the members, but just tell the story in a few minutes. When did this happen? What did it mean for your job? Who this person was, and what role they played in your observation in the work of the Road Accident Fund?
Chairperson and honorable members, in May 2021, I received an email from Mr. Brian Furness informing me that a security specialist will be joining the Road Accident Fund on secondment from the Passenger Rail Agency of South Africa, PRASA. To my surprise, PRASA at the time was mired in security challenges, which were publicized in the media. So it was puzzling to me that PRASA could spare a security specialist to Road Accident Fund. Moreover, no formal supply chain management process or recruitment process was disclosed to me for this engagement. To the best of my knowledge, the arrival of the security specialist did not follow the normal hiring or consulting protocols in the human resource or supply chain departments. I was not aware of any secondment agreement or advertisement and recruitment process for the post, nor was I aware of any supply chain process to procure the services of a security specialist. According to the security policy, provision, the Security Department is responsible for background screening of all service providers, and HR is responsible for background screening of all non-executive personnel. In this case of this security specialist, it was not clear whether the security specialist was sourced as a consultant service provider or as an employee, as his level nor status within the RAF was not disclosed to me nor to any other person in my department.
Sorry, so let me ask. So you're saying that, so let me ask this question. In the ordinary course, if anyone is hired to perform security work, are you saying that that should either be done by you or that person should report to you? So you are saying this person was not hired by you. Did they report to you in the course of their daily duties? Did you ever have a meeting with them to discuss the work that they would be doing, given that you were a manager, you were overseeing the role?
Chairperson, this person did not report to me. He came, simply put, he came above me because he came already dishing out instructions.
Was there ever a meeting where you were introduced to them together with the staff? Firstly, who did they report to the best of your knowledge? And secondly, was there ever a meeting where you were introduced to your new colleague who's working in security?
Chairperson, I was not even aware on which day will this person arrive. And there's no any person above me who introduced this person to us. This person just walked in and then he wanted to know what is the status of the security of the CEO. Why is the CEO not having security? What are the delays? So that's how it happens, Chairperson.
Did they say who they are? I mean, just tell us about that first encounter. That's what I want to understand. Was that the first time you encountered him? What was that interaction like? I just want to get a sense, because when you say he came above you, there has to be a day when you spoke for the first time. So we want to know how that conversation went. Firstly, in your own experience, Mr. Lehomo, and then I'll come to Mr. Mhlanga.
Thank you, Chairperson. I was proposing that Mr. Mhlanga take that one because the person actually was received by him up until I then came to meet him.
No, that's fine. Start with you. The affidavit is yours. Start with you, the first day that you met him. Tell us about that encounter. Then we'll come to Mr. Mhlanga if we need to.
Thank you, Chairperson. So I was actually called by Mr. Mhlanga that there's a gentleman who arrived at the reception. And then that is the gentleman that we have been notified of by Mr. Fennes that is coming. So that's the call that I received. And there was no official meeting in the first week, perhaps. If there were any other meetings, all the meetings happened, if he came on the 2nd of June, so the meetings would have happened perhaps there around mid, when he's now arranging the staff meetings.
Mid what? Midweek?
Mid-June. Mid-June, apologies. Mid-June, where he would have arranged a meeting with the security staff to give marching orders.
Okay, so when did you meet him? Just tell us about that first, or you never met. I'm trying to understand when did you meet him? So when he came in, he was introduced. I just want to know on behalf of the committee, did you, unless I missed it, you're saying you were told that he's at the door, that you knew that he had arrived. I'm assuming that you are saying you then did not have a meeting then until later, or did you have a meeting when he arrived? Because you are head of security, right?
That's correct. I'm head of security, but we did not have a meeting, Chairperson, when he arrived. If there is a meeting that would have taken place, it would have been after 2 weeks.
No, so don't say if. Please help us here as the committee. Don't say if. Say he arrived on such and such a day. The first time I met and spoke to him was around a week later or whatever, right? And this is what we discussed. So it feels like you're not going to the specifics, and I think it will be helpful for the committee to know, when did you meet him for the first time? What did you discuss? You don't need to know to remember everything, but we want to get a sense.
Chairperson, I think, in fact, the first thing that happened, let me mention this. I received a telephone call from him. The reason being that at that time, it was just after COVID. So I was mostly working from home. That is what is causing this, me and him not meeting that way. But then I received a call from him saying that he will need a security administrator, someone to assist him in his office. That is the call. The first interaction with this person was through a telephone where he requested me, he want a security administrator, he want to be assigned one person to assist with secretarial duties. That is the first telephonically, and then I returned to the office to work full-time at the office, and then that was maybe after 2 weeks.
Right, so you asked for a security administrator. Did you immediately obey? Just tell us as if you're telling a story. That's what's going to make this go quicker, right? Just relax and just tell us. So he tells you he wants a security administrator. Do you ask him, is there budget for it? Please just give us a sense normally of the conversation and just some of the process you went through until you met. Because you say in your affidavit that you were sidelined and so on. So we just want to know, at which point did the authority for various things move from you to him? Without reading every line in the affidavit, we're trying to get so that the members can then engage you. So just relax, just tell the story as if we are, you are relating a story to someone else, then it's going to go quicker. The members have got your affidavit. They can refer to specifics and you can answer with respect to that. There are a couple of things, and I'll hand over to the members. I just want to understand how you guys were interacting with one another initially. Then we will go to the issue of the suspensions when you're completely out of the way and so on. And then we'll give the members an opportunity to ask questions. So just tell a story.
Chairperson, during the telephone call where he says he is looking for a security person to assist him in his office, I then suggested a lady that I knew, because he's not asking us to hire somebody new, Chairperson and honorable members. He's asking to be assigned one person who's already within the team from the in-house security personnel who are hired by the fund and not by the private. At the fund, Chairperson and honorable members, we use a dual mode. There are private security contracted with private service providers, and there will be in-house security personnel who are employed by the fund directly. So he was asking for one of those in-house personnel. And I then suggested a particular lady whom I know that has experience in admin work, because she was working in my office before she went to join the operations team. But to my surprise, I think that was the first. I was surprised when he said, and I'm gonna just quote it as is. He said, "Agabatu owadi." And then I was left empty, Chairperson.
Can you just explain for the members who want to understand what that means?
Yes, Chairperson. In other words, the lady that I was suggesting is a member of the ZCC. So they normally cover their head all the time. So me coming from Limpopo, for me, it's not something new. I grew up understanding the ZCC, respecting the ZCC and stuff. So I was shocked to hear a person says, because I was answering the two.
No, just say what that. Just translate.
Yeah, it's the thing that covers the head.
No. What was he saying? I don't want somebody who wears it. What was he saying?
I don't want that person that covers her head with that. Yeah. That is what it means.
That's what we wanted to know. Okay.
Yes.
All right. Okay, carry on.
Yes. And then I said, no, if that is the case, then that is the person I know that she can do the work, because she's been doing it, in any case, in my office before she moved to another role. So from that point, I was very surprised, and I started to ask myself, now, what kind of a human being am I dealing with now here? So by the time I went back to work at the office, this had already transpired, and then he went on to choose another person that he preferred to work with from the security team, one of the ladies, and then he then worked with that lady. But at that time, Mr. Mhlanga was the one who was mostly handling everything with him, because I was then sidelined.
Okay, that's where I wanted to get. So how were you sidelined? Did he say, I don't want to talk to you anymore? Or he simply didn't talk to you anymore?
Chairperson, he did not tell me he doesn't want to talk to me, but you could see, because you will hear there was a meeting, you will hear there's a security committee that has been established, but as a security manager of the organization, I was not even part of it. And then you will hear there are certain documents that has been signed, and then you are not even aware of. And most of the things I was hearing from Mr. Mhlanga, Chairperson.
Okay, let's just bring Mr. Mhlanga briefly here. So can you just tell us your own experience of dealing with a security consultant? Just from the beginning, and then cite a few examples and so on. I don't want us to belabor every detail. The members will ask questions, and you've got the affidavit. Just tell from your own experience. So Mr. Lehomo says, he would hear about meetings and so on. Tell us about your first interaction, and just characterize the rest of your interactions, especially where it pertains to whether Mr. Lehomo was involved or not, since he was your boss.
Thank you, Chairperson. Upon arrival of Mr. Msiza, of the specialist, of which is Stephen Msiza, I received a call from one acting senior manager in learning and development, advising me that there is a gentleman from PRASA coming to work in the security department. Then, since I didn't know anything about either the advert or procurement process that had been followed, I then called my national manager, of which it was Matume, it was Matume, and then telling him that there is a gentleman here, I've been called, then and advised that there is a guy who's coming to be in the security environment. And then then he advised me, because Matume was not at work during the COVID period, he advised me that I must send that gentleman to Brian Furness, who will host him. So I did that, and then Brian advised that we must do access for the gentleman, and then I did that access thing for him. And then after 2 or 3 days, he then started asking for policies that we have, documents within the security department. When I asked, he then said he's part of the executive of the RAF. So since I didn't know or saw any of the adverts, and then even when I checked with Brian Furness or Matume, with Brian, there was little info that would come, but with Matume, he didn't even know about that. But however, after because from time to time he will call me into his office that he was provided for by the RAF facilities management. So from time to time he will call me to have engagements about security, because then I was then advised that the gentleman is coming to assist in the office of the CEO. So in my understanding then, okay, because it's at the executive level, or because he called himself executive, though at a later stage I saw that he was a specialist. And then he was more concerned about the security of the CEO, because from time to time we will talk about why the CEO does not have close protection, why this is not happening, why this is not happening. So he asked for the policies, then he said he will start restructuring the security, of which if there is any restructuring in the organization, since Matume was a national manager, I think that kind of information would have either came from him or there should be an engagement with him. So most of these engagements happened just after Matume returned from working from home.
Okay, so in short, so you were getting instructions directly from him and not from Mr. Lehomo, who is your manager. Is that the long and the short?
Yes, Chairperson.
Okay. I just want to move then quickly to the bypassing of SCM processes and board authority. So you had received, Mr. Lehomo, the in-writing confirmation that the chief executive must be provided with security. There is a rotational driver and close protection officer. So I think it's a total of 3 people. The security, the SCM, were then going to procure that security. Now, you are saying, Mr. Lehomo, that despite the board's kept allowance of 480,000 per annum, the security specialist arranged more extensive and expensive executive protection for the CEO. In short, how did you get to know the cost? Firstly, so how did you get to know the cost of how much it was then going to cost versus the instruction, or at least the in-writing information that you had received?
Chairperson and honorable members, when the specialist arrived, we had already embarked on the supply chain management process of 480,000 per annum. And when the security specialist arrived, there was a service provider who was contracted for the Durban regional office. And to my surprise, I was told that the CEO's close protection has been finalized and that company has been appointed. So I come to know about the cost because at my position, I was the cost center owner of the security cost center. So the invoices, now they start to flood my office for signatures and for payment processing. That is how I became to know about, because then the first invoice, I start to see that it's already way above what we were actually working on based on what the board had approved. And it went on like that because we were, and then, yeah, that's how I came to know, Chairperson.
Okay, I just want to deal with a specific aspect. So you say in paragraph 37, this was now 150,000 per month. And then you say there was a fuel card for a hired BMW 5 Series used for the CEO and hotel accommodation expenses for close protection when they traveled. These costs were charged separately to the security department's facilities and management cost centers. So I'm just trying to understand, was this 5 Series used permanently, or was it when the chief executive traveled? And how does this compare to what had been the case with the previous chief executive, whom you've said also had a security detail?
Thank you, Chairperson. The previous chief executive, as I said, used his own vehicles. But in this case, this new supplier from Durban Regional Office will have, in other words, the specialist procured close protectors, procured the vehicle. It comes, in other words, the whole deal came with the hired vehicle of this BM 5 series. However, the petrol for the vehicle and stuff was taken from facilities management. So the petrol that was being used in this hired vehicle was being procured from outside of even my department. So that was an additional cost. And I also came to know the hotel accommodation expenses because I was the one who was supposed to, the SCM people will then send me the invoices to be paid. And they were coming in very fast every week.
Okay, just in short, so it came with the whole deal, BMW 5 Series and so on. You had said earlier on the previous chief executive, they were close protectors, but they were using his personal vehicle to go to and from work and so on. So I'm assuming, and please correct me if I'm wrong, when the chief executive would travel for business, then the road accident fund would hire a vehicle for them. Or you don't know. I just want to know because the chief executive, for instance, of the road accident fund has to come here to Parliament on occasion. All of them have to do that, right? So am I to understand that this 5 series was to take the chief executive from home to the office and to business meetings of the road accident fund and so on, number one. Number two, that unlike before, there was a fuel card that was paid for by the road accident fund. Previously, there was no fuel card that the chief executive was entitled to as part of the security package.
Chairperson and honorable members, with the previous, we never had to deal with anything that pertains to the travel of the CEO or close protection of the CEO. It was just business as usual. We were just doing our normal security duties to safeguard and protect the RF assets. And then with this one, the new one, we found that this vehicle is mostly used where perhaps when the CEO go to other provinces, but it's not actually using flights and stuff. But where flights will be used, then there will be also a vehicle hires. So it was only used for that purpose around Gauteng and stuff. But where they will be traveling, like for instance, we would have went to Durban and other far areas, they will then hire other cars as well. Thank you.
All right. No, so answer this question specifically. So I assume the chief executive had his own car already. When this new arrangement kicked in, did he continue to use his car, or did this become the car that he used, not the vehicle that he had before?
The 5 Series became the car that was used. Thank you.
Okay, that's what I wanted to know. All right, we're nearly done. So the members will traverse the issues of the suspension and so on. They are in the affidavit. I just want to also clarify, which I think the legal team did with you, which is we are not reviewing the HR process here. The only thing is we're looking at it for completeness because you are no longer there. You believe that the disciplinary process was as a result of all of these matters that we are traversing, but we will not be saying whether you should have been, suspended or not suspended and so on, because that's not our role. The processes that are running have to run their course, or the organization has to make its own decisions about these matters. So I just want to be clear. So that's why I'm not dealing with this specifically now, but it's in the affidavit. I just want to talk about the restructuring of the security leadership. So you are the head of security at the Road Accident Fund. Did you take the decision for the restructuring? Were you consulted? Did you play any role in that?
Chairperson, the only role that I would have played, and in this case with Mr. Mhlanga, was when the security specialist asked us to assist him with the security strategy. That is the only role that I've played. But in the key meetings where decisions were made, we were not involved.
All right. So in other words, the security specialist or consultant then became the person, in your experience, that was responsible for the restructuring. I'm assuming your interactions were with him throughout the time. So he became the person that was dealing with the restructuring. And you say in your affidavit here that you were suspended for an alleged mismanagement of a contract by a service provider, and that you believe that this suspension was linked to the time that the job was advertised and the lowering of the requirements. Can you just take us briefly, and this is the last thing I'm asking you to do, just take us briefly through, this is the second last thing, we're gonna get to the security clearance, just that period. So was a new structure announced, etc. Just take us through that period in brief.
Thank you, Chairperson. So, so just before our suspensions, there was a senior manager role which emanated from the restructuring, and the position was advertised, if I recall, just within the same week after the position has been advertised. We were placed on suspension, and whilst I was on suspension, I saw that the position has been re-advertised. Now, this time with lesser academic qualifications. The first one had a degree as a qualification requirement, and the reduced one had now a diploma. And I knew that myself and Mr. Mhlanga would actually qualify for the first one because we are now level 9s, and the requirement was level 7. So then it gave me an impression, and when I look at the kind of charges, the kind of money that is been spoken about, if I may just highlight to members, the contract which we are suspended for, the total value of the contract is approximately 201 rand. This is
201 rand?
201, yeah, 200,001. So this is the amount that we are now been told that no, we mismanaged that contract. It was just a 6 months security maintenance system. And obviously during COVID, we would have saved a lot of money on the same contract because the contract runs this way. When the service provider come to service, the rate was about 4,000 rand per visit. So we reduced the number of visits. That's how we came to the saving of this money. And then we paid.
No, the amount is in the affidavit. So you 127,650 was spent, and 73,888 rand was a 36.7% saving for the road accident fund. So that is the charge. So basically, your contention is that the charges were baseless. The members have been provided with further information in the pack, so we won't dig into that. But basically, the only claim that you are making here at a high level is that you don't believe the charges had merit, it coincided with your period of suspension and you could not be part of the selection process because you were on suspension and you were overqualified, at least by way of academic qualifications. You met all the criteria and above the criteria that's needed. Is that your contention?
That's correct, Chairperson and honorable members.
Okay, let me just ask as a final question. What is your status now, Mr. Lehomo? Are you still employed by the Road Accident Fund? Where is your case right now? What's happening?
Currently, my case is pending review at the Labour Court. That is what is happening, because the Road Accident Fund are non-responsive with regard to issues like this. Your attorneys will write to them, they will not respond. That is the current status, Chairperson.
Okay, so who won the round at the CCMA, the last round? What did the CCMA rule in the matter?
We went to the CCMA for Mr. Mhlanga's case, which I was a witness as well. And Mr. Mhlanga got the award to be reinstated with full benefits. However, when he was supposed to go back to work, he received a letter from the attorneys.
No, he will talk for himself. I'll ask him just now. Just talk to your case.
Mr. Mhlanga won the arbitration award, Chairperson.
No, I mean yours. I was asking about your case. Mr. Mhlanga is here. We'll ask him to speak to his case. What is the status of your case with the Road Accident Fund?
My case is pending a review at the Labour Court, because the Road Accident Fund, currently they are non-responsive.
Okay. Explain this. So the CCMA ruled in your favor or not? We want to understand why it is at the Labour Court and the Road Accident Fund is non-responsive, as you say. Just simplify this for us. Just tell us. I went to the CCMA said this, and now the matter is at the Labour Court for this reason. I just want to understand.
Thank you, Chairperson. So I received a letter of dismissal on the 9th of May, 2024. And then the letter says they are backdating the dismissal to the 16th of April. That is 21 days backward. And then I went to the CCMA with that. And the CCMA commissioner said, he ruled, in other words, they ruled against me. They said the employer was correct to do that. But then then there was...
The employer was correct to dismiss you?
To even reverse the dismissal date, Chairperson.
So both were correct. So your dismissal was correct and the reversal of basically the backdating of the dismissal was correct. Is that what you are saying? I want to understand what the CCMA said.
The main issue, Chairperson, that we were, in other words, you go to CCMA and then there will be many points that are raised by attorneys to delay, to frustrate the entire process. And then we went for the issue of the backdating. And perhaps, Chairperson, if I may not dwell too much into that, because it's something that I still have to deal with when it goes to court.
Okay, so you are dismissed at the moment from the Road Accident Fund.
That's correct, Chairperson. I'm still dismissed.
Thank you. That's helpful. Mr. Mhlanga, what's the status of your case? Just give us a brief history. How did your case proceed and where is it now?
Okay. On the internal RAF processes, I was taken out, meaning I was dismissed. Then I took the matter to CCMA for conciliation. Then the parties could not agree. Then we went to arbitration. On arbitration, I got an award for reinstatement with full benefits. And then when I was about to go back, I received a letter from the attorneys, of which is Malachi attorneys, stating that RAF, as their client, they were instructed to inform me that I must not come back because they want to review the case. So the review, the process for the review was initiated, but however, as advised by my attorneys, they advised me that RAF did not, there is a process that they did not do. But however, as it stands now, I've instructed again my attorneys to instruct RAF to reinstate me. So I'm waiting for the outcome from that instruction that I've issued.
Okay. The only ruling that is applicable right now is that you have been reinstated by the CCMA. The Road Accident Fund has indicated that they want to appeal that decision. Is that correct?
That's correct, Chairperson.
When did the CCMA make the ruling?
The Chairperson, I think around March 2024.
Okay. Since March 2024, have you heard anything back from the Road Accident Fund by way of taking the matter further?
Yes, there were documents that were being shared amongst the attorneys. Yeah, that's how far I know.
Now I'm saying, so has there been a court date? So there's been no hearing at the Labour Court for now.
Okay. When Chairperson, when it comes to the issues of court dates and whatever, my attorneys have been writing to the RAF with regards to getting the court date, because they are the ones who are reviewing the arbitration. So they are the ones who must get the court date. My attorneys have requested the court date. It has not been afforded till to date.
So are you still on suspension, or have you been dismissed?
Chairperson, currently, as far as I know, with a reinstatement, I'm the employee of the RAF, except if the Labour Court or any other institution changes that.
Are you getting paid?
No.
Okay, so let's just put it like this. So the Road Accident Fund, as far as they're concerned, have dismissed you. You have won your case at the CCMA, ordering your reinstatement. The matter has not proceeded further. You are basically still a dismissed employee. They are not paying you, but you only have an award from the CCMA that says you must be reinstated. It's been over a year since the CCMA decision, and there have been no further developments in the case by way of a court hearing. So there hasn't been a court date, and there is no hearing that has taken place at the Labour Court.
That is true, Chairperson.
Right. Okay. No, thank you very much. So thank you very much for that. Is there anything, Mr. Mhlanga, that because you've accepted Mr. Lehomo's version of the affidavit as yours, is there anything that you believe is important for the committee to know that we did not canvass in this exchange with Mr. Lehomo?
I think we have covered everything, except if the honourable members ask some questions.
No, the honourable members, believe me, will ask a lot of questions, so don't worry. There'll be time to get through. So members, honourable members, what I'd like to suggest, as I did in the beginning, 10 minutes per member, uninterrupted. But can we please, so what has happened before with some members is that I think I misunderstood to say that 10 minutes is for the member to speak continuously. It's happened with some. The 10 minutes is for the entire exchange between the member and the witness, right? So can you please, we'll start on my left, and then when we come back, we'll start on my right. So we'll keep changing back and forth so that we are fair in the distribution. So the time is 10:21 now. It's going to be 10:22 soon. Honorable Beasley, I will stop the clock at 10:32. No, yeah, I'm starting this side. If you don't want to ask, so it's 10 minutes. At 10 minutes, genuinely, I will have to stop the member. So the questions must please be concise. And may I please ask the witnesses, just be specific in your answer. Don't speak for 5 minutes, because it then eats into the members' allocated time. Honorable Beasley, over to you.
Thank you, Chair. Thank you to both people for appearing today, and just welcome. How many staff were in your security team?
Honorable Member, we were about 16 members nationwide.
Okay, thank you. And then, sorry, just to note in your affidavit that up until your dismissal, there were no really adverse findings against, no complaints against the security team per se, and as such, in your opinion, why do you think in that case was it necessary to bring in an outsider when there were no adverse findings within the security team? What do you think is the rationale behind bringing a security person in?
Honorable Member, how would you know? I don't want to speculate, but based on the fact that the former CEO and this particular person were together at PRASA, that might be the reason.
Sorry, Chair, should I be looking at you? I'm still like...
Just carry on,
Okay.
Honorable Beasley. I won't interrupt until your time. The only time I'll speak is when I say your time is up.
Okay. And do you know if the security expert, was he paid as a consultant? Was he on the payroll? Was the money paid to process? So how was he actually paid?
He was not on our payroll from the Security Cost Center, Honorable Member.
Sorry, so you don't know if he was an employee or a consultant or was paid to process. You don't know how he was actually compensated.
That's correct.
And then this Mr. Furness, was he your direct reporting line?
Correct, Honorable Member.
Sorry, it's going quite quick. And at any stage, did he advise you of the new security gentleman who came? I presume it was a gentleman. Did he advise you that he was coming across, what his role and responsibilities were?
Correct, Honorable Member. The email just said there will be this person who will be coming to work in the office of the CEO in the near foreseeable future.
So he didn't expand on what his roles were, the reporting lines, the interaction between you and you. He just sent an email saying this gentleman's coming.
That's correct, Honorable Member.
And then when he started interfering, did you at all raise any concerns with Mr. Furness at all in terms of your reporting structures, just saying, what is going on?
Yes, I did, but then the indication was that the person is working in the office with the CEO, so we must support him, and then we must give him what he wants. That was the indication, Honorable Member.
Thank you. And so in terms of the 150,000 that was paid, was that similar protection that the previous CEO got?
It's not similar. The difference is that the previous CEO was using his own cars, and then we were not paying from the security cost center. And then with this one, it was a different ball game altogether, because we were supposed to handle all the things, payments of hotels and everything.
And then the risk assessment that you guys had, it came back that there would be 2 protectors and 1 driver. What did it actually end up? Do you know how big the protection actually became?
Honorable Member, a risk assessment will not necessarily indicate how many people, members. It will indicate if there's a threat, at which level, if there's a risk, at which level. It wouldn't necessarily indicate, dictate how many members. Thank you.
So the question that I'm trying to ask is, when the RAF was paying 150,000 Rand a month, how many protectors did that include? So it went from 2 protectors and 1 driver. What did it go to?
No, it was honorable member in Chairperson. The numbers were 3.
So it was 3. So it went from 40,000 rand a month to 150,000 rand a month, but the number of protectors didn't increase. Am I explaining the question? So the previously he had 2 protectors and 1 driver. With the new arrangement, how many protectors did he have?
Chairperson, the numbers for the ex-CO was still 3. So the same as the previous CEO.
Okay, so the question I'm trying to ask is that we were paying, or RAF was paying 40,000 rand a month. It went to 150,000 rand a month, but his personal protection actually didn't go up in terms of the number of people protecting him.
Chair, let me just assist. I think where they're getting confused is a 40,000. So the communication from the board, and I've stopped the clock, Honorable Beasley. The communication from the board is that 480,000 per year is to be allocated to security. When you divide 480,000 by 12, you get 40,000. That's the 40,000 is referring to. So in other words, the amount on average per month was about 40,000. You are saying it grew to 150,000, right? So that's what Honorable Beasley is trying to ascertain here. That's all. So 150,000 versus 40,000. Isn't it so, Honorable Beasley? Okay, so that's what he's trying. So please ask the question again, Honorable Beasley. I'll resume the clock, but that's what he's asking.
Okay, the 40,000 one, as I understand it, let me just clarify that one never kicked off. Remember when the specialist arrived, we had just embarked on a SCM process to procure for that 40,000 per month. And then the understanding is that it was going to depend on the quotations that we SCM receive. If the cost was higher, for example, then it means the whole process would have went back to the board for ratification. But there was no service, perhaps, Honorable Member, there was no service prior to the one that commenced with 150. Thank you.
Okay, so in your understanding for the 40,000 per month, do you think the service would have included 2 protectors and 1 driver?
Yes, Honorable Member, because this was approved as a fringe benefit in our view.
Okay, so the 150,000, did they itemize how it was actually made up of how many protectors, how many drivers? So at the end, whilst you were there, how many protectors did he actually have? Was it still the 2 and the 1?
When it commenced, when we paid this 150, approximately 150, it was just the 2 and 1. But after 3 or 4 months, it was then increased again.
So did anybody question why it went from 40 to 150,000? I mean, who signed off those invoices? Because you're getting 2 and 1, now you're paying 150,000 and you're getting 2 and 1. So who would have actually approved those payments?
I asked the security specialist. I actually asked him because I told him this would have went to the board for approval, Chairperson. I said this would have went to the board for approval, and then he said no, that's not how it is done. He does have approval, and then he gave us the memorandum which was approved by the acting COO then, Miss Maria Rambauli, with those quantities that were procured. And at that point, I immediately thought, but this was irregular.
Chair, is that my time? Okay. And then later you mentioned that the 150,000 got more. Can you just expand on that, and how much more did it actually become?
Can you come again with the question?
In the affidavit, it said the 150,000, the scope became bigger and bigger, the invoices became more. I think it's on page, it's paragraph 41, I think, of the affidavit. These costs kept on escalating as more resources were added up until my suspension. How much more above the 150,000 did it become?
At that point, we were already isolated, so we couldn't see. But what we can see is now the personnel and additional cars that are coming in from time to time.
Okay, so you don't have a quantum of how much it went up from 150,000.
That's correct.
Thanks. And then are you...
Final question, Honorable Beasley.
Thanks, Chair. Is the security consultant still employed at the RAF? When I say employed, I mean, we don't know, is he still there?
He's now sitting at a senior manager position, security.
Thanks, Honorable Beasley. Over to Honorable Neil May. So what we'll do is we'll take Honorable Neil May and Honorable Bila and then take a break and then come back and continue with Honorable Dagmo. Please, Honorable Neil May, we're going to start counting now.
No, thank you. Good morning, Chair, and good morning to my colleagues and everybody present here. Your affidavit that I have perused says that you have managed to maintain an active SSA security clearance throughout your RAF employment. Now, in paragraphs 56 and 60, you state that during your tenure, you never saw proof that the former CEO held top secret security clearance. And in late 2021, when the SSA asked the RAF to submit a list of executives and their security status, a draft response prepared in your unit asserted that the CEO had top secret clearance. My question to you is that you refused to sign the SSA letter because you had not seen the CEO's security clearance, although it is stated that from his office, that says that he has one. And yet the security specialist signed it instead, stating the CEO had top secret clearance. Did you ever subsequently see documentary proof of that clearance? And if not, on what specific basis do you question the accuracy of the letter? For example, records you checked, the custodian who confirmed non-existed, or feedback from SSA. And I know that that letter, the vetting of the senior officials were asked. I have the list of the senior officials that were supposed to have gone for a security vetting, and yet they're not vetted. In your opinion?
Well, I came because I saw the email from the office of the CEO that indicated that he does have a top secret clearance. But then I wanted to verify it myself with my own eyes before I signed the letter to the state security. And the other indication I can put to members is that at that point we had already initiated the process to vet the CEO, because the security clearance, honorable members, is not a transferable document. It's a risk-based document that you cannot necessarily, without the authorization of the state security, take it from one institution into the other. So I only became aware when I was on suspension, when there were deliberations in this house, with the road accident management, where the issue of the security clearance was discussed, and it came out that, in fact, the CEO did not have the top secret clearance. That is one. Two, the security specialist just recently attempted to charge the manager at the Road Accident Fund head office. This will be the employee who prepared this draft letter, who prepared for him this draft letter using the email from the office of the CEO. So after the parliament, this house asked them questions. So there was an attempt where this lady was sent a notice for suspension letter that she must explain herself why she misled the security specialist. So he wanted to challenge her, to suspend her. And in that letter, it's clear that the CEO does not have a top secret clearance from the specialist himself. Thank you.
No, thank you very much. The next question is, who is the security specialist? Can you name him? And does he or she have a SSA clearance?
The name of the security specialist is Mr. Stephen Modise, and I do not know whether he has got a security clearance or not, because no background screening was done when he was introduced to the Road Accident Fund.
Thank you. Coming back to the screening of the security specialist, generally one belongs to certain associations, or do you by any chance have any information with regards to the security specialists' qualifications and associations to any bodies, security bodies? And is he placed, as I heard earlier, in the CEO's office? Is he, by any chance, is there any information that links him to the CEO in not only in the workplace, but maybe out of the workplace?
Chairperson and honorable members, in this question, I will only deal with the part of qualifications and associations with either SIRA or any other security association. Then my colleague will deal with the other part of the question. So when it comes to SIRA association or whatever, when every year in the Road Accident Fund, there are subscriptions that we do for all security personnel, that we used to do for all security personnel, where we'll pay subscriptions to SIRA. So as far as I know, the last time when I was at Road Accident Fund, there was nothing that was produced to say this gentleman is fit or is registered with any security regulators. So on that, I don't know whether he's registered or not. And then when it comes to his qualifications, it happened during my hearing at internal hearing at the Road Accident Fund, when he was cross-questioned under when he was questioned, he then said he has, when he was asked about his academic qualifications, he said he has got a national diploma in human resource management and other police like SAPS certificates. And then again, the same question was asked during the arbitration. Even during arbitration, when that question was asked during the hearing, I was still on suspension and the advert went out and then it was frozen. And then when it was asked during arbitration, by that time Stevens Msiza was already appointed as a senior manager. And then the answer was similar to the answer that he had given during the hearing, saying that I've got human resource management, a diploma, and certificates of SAPS. Yeah. So that's how far I know in terms of his academics or accreditations.
Thank you. So his relationship with the CEO, we were in the boardroom during a session where we were preparing that particular security strategy. And right at the end, he then indicated to us that no, this thing of, because we were asking him questions, we couldn't comprehend the approach that was used. So we were asking questions and he said, no, I've been doing this thing with Collins, referring to the former chief executive officer. And then he said, we've been doing it in other institutions where we were together. So it will seem like they were together not only at PRASA, it will seem like they were together at other institutions as well, where the CEO was seconded. And then he said he came to know the former CEO when he was the bodyguard. So Stephen Msiza, when Stephen Msiza was the bodyguard of the former ANC Youth League president, I think it was around the 2010, around there. So that is how he said, because he spent most of his time in Limpopo, he then came to know Collins then. So they've been doing this restructuring thing in many other institutions where they were together. That is what he told us. Thank you.
Sorry, Chair, if we could just say, sorry, who was the ANC chief president, youth league president at that time?
Sorry, can I...
No, you just mentioned, I'd like to know the name of that person.
You'll get your chance, Honorable Atkinson. Can we... Yeah, otherwise we're going to get chaos. Honorable Nilmay, your final question, and then we'll move to Honorable Bila. Just keep that question, Honorable Atkinson.
No, thank you. My final question is then because of your security operation and any company, and I know from municipalities, if you have a security section, the head of security must have the relevant qualifications and be a member of CIRA. Am I right? Which in this case now makes it that the RAF is non-compliant with regards to security. Is that correct?
So I can ask you, Honorable Nilmay, to say what CIRA is for the benefit of all of us.
Thank you. It's the Security Association. I don't exactly know the exact words, but I know you'll be able to say it's all security guards, all security operators have to belong to yeah. It's C. It's P. It actually starts with a P.
Can I
PS.
Can I assist the okay? Chairperson, CIRA is private security institution, regulatory authority. Yeah. P stands for private, and then S security institutions, regulatory authority, industry. Yeah.
Okay, please answer the question that she had asked, which was, just ask again, Honorable Nilmay.
Because of if in any company or municipality or security operation, if you obviously have guns and you have, I think there is ammunition in that establishment, right? Therefore, the head of security should be a member of CIRA, if I'm not mistaken, and the other bodies that they should belong to, which now makes it, if this person that is heading up security does not have the relevant qualifications, are they now non-compliant? And what are the ramifications if they are non-compliant? Thank you.
Thank you. So just so you know, so Honorable Neil May is making an assertion, and then she says, if I'm not mistaken, which means she's not sure. In your answer, please basically explain the framework that would make anyone who is in that role compliant with policy or any other standard that is applicable. I think that would help the rest of the members.
Thank you, Chairperson and honorable members. For any person doing security work must be registered with the body, of which is SIRA. So if we are not registered with that body, the organization or that person is not compliant. And then even the organization that provides security, like Road Accident Fund, Road Accident Fund must be registered with SIRA as a security service provider. So if that is not done, that organization or RAF, if it's not registered, is non-compliant. But however, as far as I know, because I was involved in the process of making the organization to be registered, so I know. Road Accident Fund, when it comes to being registered with SIRA, they are compliant. But the individual, I'm not sure.
All right, thank you very much. Your time is up, Honorable Neil May. Honorable Bila, and then when you're done, we'll go on break. Thank you.
Thank you, Chairperson, and good morning to everyone. My first question will be from paragraph 25, where it is indicated that in May 2021, Mr. Lehomo received an email from Mr. Fennis informing him about the security specialist who will be joining them. I just want to check what exactly did the email from the senior facilities manager state about the security specialist secondment? Who was copied on that email? And what did it say about the start date, the duration, and the paying public entity?
Chairperson and honorable member, the email was, I think it was just a two-liner that said there's a Stephen Msiza who will be joining, who has been seconded, that was the wording, from PRASA to work in the office of the CEO, responsible for security of the CEO. That was the email. Thank you.
The second question is about the security committee. Who created the security committee and who was the chairperson at that time? Who were the members of that committee? And was there terms of reference or minutes that you have? Why were you, as a national security manager, excluded in that committee? If we can check.
Chairperson, I was not involved in the matters pertaining to the security committee, so I've got no information whatsoever. Yeah, safe to say that the committee itself, it will emanate from what Msiza informed us as a strategy that has been approved, although he did not necessarily share it with us. So I would actually think the committee emanate from there. But also in the policy, there's a requirement to establish a committee, which before this other one was established, Mr. Mhlanga was responsible for the other one before the arrival of the security specialist. Thank you.
Before the arrival of the man of the match. Thank you so much. The third question. I know it raises concerns to you as you have been underlined by that time. To whom did you raise concerns about security specialist and clear status and authority? And what responses did you receive?
At that time, let me just say there was nowhere to go, the way the situation was. I didn't find anywhere to go where I could actually get these issues resolved, because if this person is working with the CEO. Where else can one go?
You also mentioned the downgraded qualification requirements. In your view, would the downgraded qualification requirements yield the recruitment of a fit for office person, or is a degree necessary for performing the role?
Chairperson and honorable members, as a standard at the Road Accident Fund, the position from task 12 to whatever task, to I think senior manager, task 18, the requirement is a degree. So toning down the qualification is not in line with the standards set by the organization. So then chances of getting a fit and proper person are lower.
Chairperson, do I still have buying power?
Oh yeah, you've got lots. You've got more than 5 minutes, Honorable Bill.
Okay, thanks. I think this will be my last question. I will give the remaining minutes to Honorable Madun. Before your suspension, Mr. Lehomo, did you have any adverse findings or performance issues on record?
No, our performance was always excellent in terms of our performance reviews. Our health and safety reports were posted in the annual reports of the Road Accident Fund, reported to Parliament annually. You can check, Honourable Member, from 2020 backward. We were performing par excellence. Thank you.
Honorable Chair, can I add on that? Just to add on that part of performance, even during our suspension, when we were on suspension, when RAF paid bonuses, we paid bonus. So when it comes to performance, we're far ahead. The same organization that suspended us paid us a bonus.
Thank you. Honorable Bill, am I correct in saying you are finished? That was your last one.
Yes, Chairperson, I'm done.
Thank you very much. So that was 6 minutes. So thank you very much. Honorable members, it's 10:54. Can we come back at 11:15? 11:15. I note Honorable Maduna is looking suave today. I don't know if you guys noticed. I mean, he's ready to go to Dubai, Honorable Mhlanga. He is on his way to Dubai. or London. Yeah. It's an old joke here in the committee, don't worry. He looks very superior today. He looks very superior today. Maybe he's going to court. Thank you. Thank you, Thank you, honorable members. We resume at 1:15. just say, just for the witnesses. So, in your answers, just try and stick to what you have personal knowledge of or something that you saw. If you don't have first-hand knowledge of something, in other words, you heard from someone somewhere, it becomes difficult for us to verify here as the committee. So even if you've heard a rumor somewhere, it's best not to yes, it's best not to share that, because otherwise we still can't verify whether, I mean, we might need to start asking a million questions. So just stick to what you know, what you read in terms of what you observed, etc. So I'm not saying this to scare you, but you know, because then I'm going to ask you a follow-up question. Where did you see that? Oh no, I heard from my cousin. You don't want that situation, right? Because your cousin is not here. So if we can stick to things that are within our personal, or that were said to you by someone, then at least that's within your personal knowledge. Okay, honorable members, thank you very much and welcome back. Honorable Dagmo, I'm going to give you, I noticed that Honorable Bila donated her time to Honorable Matuna. Yeah.
No, thank you very much, Chair. No, that was a correct decision to donate the 5 minutes, because, as you know, I'm an alternate, and I'm sure that the honourable member will be able to use those 5 minutes better than me. But through the chair, I would firstly like to greet Mr. Lehomo and Mr. Mhlanga, and thank you very much for being here to help the work of this inquiry. I think very often when we talk about allegations of corruption or poor governance, we don't always understand the impact that might have on the actual individuals. So I would like to ask both Mr. Lehomo as well as Mr. Mhlanga at a personal level, and we've heard where your respective cases are. One, facing a possible appeal, even though there was a CCMA finding in the one instance and the Labour Court. Can you just tell us and tell this inquiry, how has what has happened at the RAF affected you personally and your families?
Thank you, Chairperson. Thank you, Honourable Member. These actions, I think the way it affected me personally and my family is that, if I may just put this, I do have three girls. 2 are at tertiary institution, different tertiary institutions in Pretoria, and I'm not funded by any. We don't have any bursary, so I'm funding their education from my pocket, myself and my wife. So it has been very, very, very tough, honourable members. And our last born is actually at high school, and there's no one who's helping us. It's me and my wife who has to make ends meet. You will have your home loans, all the loans that you can think of. So it really has affected me in many ways, in terms of credit, in terms of the health. It has done a severe damage, honourable members. Thank you.
I ask Mr. Mhlanga to respond. Can you just indicate, so when was the last time that you actually received a salary from the RAF?
Honourable Chairperson.
I'm first just finishing up with Mr. Lehomo,
Okay,
before I come to you, Mr. Mhlanga.
The last time I received a salary would have been it was end of March 2024.
Okay.
Because then end of April 2024, they didn't pay my salary, and at that time, I was not even aware that I was dismissed. Can you imagine taking your kids to school and it's payday and there's no salary? And you try to find out from the employer, which prides itself as the caring employer, by the way, and nobody's answering you. It's the 25th, up until the 9th of May, you then receive this letter that you've been dismissed. And at that time, the damage has already been done because you were not expecting that your salary will be stopped that abruptly, Honorable Member.
No, thank you. Thank you for that. So since then, you've been without an income. You haven't been able to secure any employment elsewhere.
Honorable Member, I then decided, because after the RAF dismiss you as a security, they will then run to SIRA. Our offices are, by the way, in the same precinct. So they will blacklist you. So as I'm sitting here, my SIRA status states that I'm a dismissed person. So no employer will ever want to look at your CV, because part of verification in our security is that your SIRA must be in good standing. So now, as we speak, I'm blacklisted, which means I cannot secure a security-related job. Okay. But what I did, I then, with Mr. Mhlanga, of course, we then looked at into a new environment where we can perhaps try and make a living. And we then entered the property market, where we then became estate agents. And that is how we tried to at least something. Yes, very slow. It's not like your formal employment, because that one, the RAF cannot blacklist you on that one. Thank you.
Okay, no, thank you very much. Mr. Mhlanga, through the chair, could I ask you also to respond to the same question that I asked Mr. Lehomo? How has this affected you at a personal level? I know it's maybe a bit difficult, but I think very often we don't, as members of parliament or members of the public, always see that when there are allegations of bad governance, targeting of employees, corruption, how that can actually affect someone's personal life. That is a cost of the way things happen. So could you just share with us briefly your own situation, how it has affected you?
Thank you very much, Chairperson and honorable members. Actually, that one is touchy, because almost similar to Mr. Lehomo, one lost a lot with this conduct that have happened, or with the dismissals. One, I've got kids. My daughter, even like this year, started a tertiary, and my son is doing his grade 12, which means next year I must make sure that he goes to tertiary to study, like I did, because I can't have a child that is not having qualifications. And in that process, I'm the one who was responsible for the family, my family at home in Pongola. I'm the one who, after our parents passed away and all the other parents passed, and I'm the one who was responsible for taking care of them. Though I still do, but not at the same magnitude that I used to do. There were a lot of other responsibilities that I had, unfortunately, with this. Yeah.
And when was the last time you received a payment from the Road Accident Fund? Because I was also following, the chair was asking about your labor cases and so on. We heard about the CCMA, which this arbitration, which effectively put you back at work, and then we've also heard why that hasn't happened. But are you still getting a salary from the RAF?
Honorable Chair and honorable members, I'm not getting any salary.
Since when?
The last time I received a salary, it was July 2023. So,
okay.
Yeah, but though it's not like a right way, like a formal way, but there are other means, like Mr. Lehomo has alluded. We entered the property market. We tried, though if you are new in that market, you are coming from a different environment, it becomes difficult. And then again, I just want to add one part. I've applied for several positions, of which I was called in one of the interviews by the SIU. When I was supposed to go, I couldn't go. Reason being, I must go and explain myself, who I am there. I must go and say, I was dismissed at RAF, what. I was called in the interviews in the office of the Chief Justice. I went there. When I came out, I was so embarrassed on myself. Because the questions that were asked there, I had to explain myself that I'm a dismissed employee or person. I went to the University of Free State. They offered me a position after I've explained myself of my dismissal. But because of the conscience that I had, I decided to decline that position and sit at home. Because from time to time, I must deal with this thing that someone somewhere decided.
Dealing with minutes here. How many minutes?
No, you've got 0, but that's your last question that you're asking.
Did that all take 10 minutes?
Yes,
Okay,
but it's okay. You can ask your last question, and then when we...
This is an important question, might have a follow-up. Mr. Msiza, we understand, is the security specialist who is referred to here. Now, I would like to ask, are you aware or can you confirm that at one stage Mr. Msiza was the personal bodyguard of Mr. Julius Malema?
Honorable Chair, in one of the engagements that we had with Mr. Msiza, he told us that he was once a close protector to Julius and Honorable Malema, and again the former deputy president. So as far as we know, that's what he had once said to us.
And my last question, Chair, then, I'm sure my colleague next to me will follow up. I know my colleagues here were asking around issues of qualifications. Do you have a copy, or could you provide this committee with a copy of the CV of Mr. Msiza, the security specialist?
Honorable Chair.
So can I say, we can ask for that from, is it fine, because they're no longer there? Would it suffice for you?
Yeah, that's fine. Sorry, Chair, I just wasn't watching my time, so I will I withdraw now.
That's fine, but we can ask for it. I don't want to speculate. I think it's been provided in the bigger bundle, but we'll check, which is in the memory stick.
Thank you. Thanks once again for being here, colleagues. Thank you.
Honorable Maduna.
With my 14 minutes. Thank you, Chair. No, thanks, Chair. I think I will also have a couple of very short questions. I think one, I just want to check the CEO before, well, the CEO that we are talking about, Mr. Letswalo. His close protection, did it only accompany him from the office to home and from home to the office?
Honorable Member, Chairperson, through you, the security was there for 24/7. However, the one that we were sourcing before the arrival of the security specialist was that one of home office. So, but the one that was procured was I can call it a 24/7, 24-hour protection.
Sorry, can I just suggest, so listen to the question carefully. Don't anticipate where the member is going. Answer the question the member is asking. The member is asking you about the previous CEO's security. He's asking, what did it entail? Confine yourself to that. And then if the member wants to ask about the next CEO's security, he will. If he doesn't want to, he won't ask. So don't try and preempt where he's going. Just answer about the previous CEO's security detail. I've stopped the clock, Honorable Maduna, for while I'm talking. Thank you. So please answer the question that he asked. If you can repeat it, Honorable Maduna, for...
No, thanks, Chair. I wanted to ask the previous CEO before Mr. Letsoalo, what did his security detail entail? Was it just a company from work to home and from home to work? And on top of that, did he get any upgrades at home in terms of the access and so on? And was his family, the previous one, not Mr. Letsoalo, was his family also having bodyguards and so on?
Honorable Chairperson and Honorable Member, the previous CEO before Mr. Letsoalo did not have close protection. It was Mr. Eugene Watson, so he did not have close protection. The one we were referring to with close protection was not there before Mr. Letsoalo. He was there. It was Mr. Jacob Modise then. So he was there way before Mr. Letsoalo came. It's the one that we were told to do a similar arrangement, Honorable Member.
Okay, thank you. I must first put it clear that the Maduna Protection Services, I don't know them. So it's very important that I do that.
I did not want to personalize it, Honorable, but I did wonder, especially given how you dress today.
No, I don't know.
I thought
them.
maybe the guy is the owner.
I don't know, Chair. So I want to check. Now, when you did the assessment on Mr. Letsoalo, you are given a verbal instruction to prepare or to source a service provider that will do this assessment. Is this the way that you usually operated, Raf? That at that time you operated just verbal instructions?
Well, as far as I understand, verbal instruction is still an instruction, Honorable Member.
So this was a normal practice?
I would say it was, because if you are being instructed by the person that you report to and they tell you to do something, they expect you to come and give them feedback on what they instructed you to do. So from that sense, it becomes normal in my view, Honorable Member.
On the 11th of June, 2020, there was a proposal that was prepared to source the service provider and eventually was appointed on the 15th of June. Who prepared this documentation? It's usually a memo for that requested for deviation.
Can you please be referred to a specific one, Chairperson?
When you were sourcing the Maduna Protection Services, who prepared the request?
I prepared the request to source the service provider to conduct assessment.
So you invited a quotation from different service providers, or you specifically identified? I'm hoping my brother here.
Chairperson and honorable members, as I alluded before, the process, in our case, we prepare a business case, and then once it's approved at the executive level, we will then prepare what we call motivation to source, MTS. And once it's prepared, it's then loaded on the system, and SCM takes over the process. They run with it, and then they invite suppliers to send quotations. Depending on at that time, I think the threshold for RFQ was 500,000 rands, but it has been increased, as far as I understand, to 1 million currently. Thank you.
Okay, no, thanks. I think it's clear.
Sorry, Honorable Maduna, it's not for me, and I've stopped the clock. I really do need to understand that you are answering specifically. So there were two tasks performed. One was getting a security consultant or some other company to do a threat assessment. There'd been the one from SAPS, and then that one said there is no threat. Then a private one had to be secured, which produced the report that said you must provide protection. Then there was procurement of the service itself, right? One is threat assessment, the other is. Did SCM do both? Or was the first one chosen by you? I think that's what Honorable Maduna is asking. I just want to be sure that when you say SCM took over, you mean getting the company that's going to do the threat assessment. Am I correct in that understanding?
You are correct, Chairperson.
All right, thank you.
What is the name of the company that was sourced from Devon office that ended up providing the service?
The name of the company, Chairperson and Honorable Member, is Mjaeli Security.
According to your knowledge, did this go to board for approval?
Chairperson, we were extremely isolated at that point. We couldn't access any other document.
The secondment from PRASA, were they paid as a consultant according to your knowledge, or they were employees, they were seconded as the normal secondment process? And you generally, when RAF or when any secondments were happening, were you in any other way, given that you were heading the security there, involved? For instance, in the secondment of Mr. Litswalo.
We were not involved, Chairperson.
So given that the vetting, you had to sign into the vetting report. So how did it happen when you had to look into someone that has been seconded today? For instance, I noticed that in the vetting report that we have, almost everyone is acting besides Mr. Litswalo, maybe until one other executive. So I just wanted to check, what was your role in ensuring that these people have been vetted for top secrets and so on?
Chairperson, the vetting before Mr. Litswalo came, let me just say so. People on acting positions, that process on its own, just to have people on acting positions and for a shorter period of time in executive management does disrupt the vetting process, because vetting, a clearance is issued specific to a specific position. So if this one in 3 weeks is acting here and 4 weeks they have been placed somewhere, it does frustrate the vetting process. So, but before 2019, when Mr. Litswalo came to RAF, vetting was done because all executives would have been given the 204 forms to fill, and we would have sent their information to the state security for vetting.
My second to last question. I want to check, when you signed the invoices of the Durban-based that was providing service, you said that the acting CEO of that time provided something in writing that this has been approved. Was it normal to you that the COO overruns a board decision?
It was not normal, Chairperson.
But you continue to sign the invoice nonetheless?
In my submission, I said we were already on eggshell. So when you are given invoices to pay and you are shown documents that are approved by your executive, and you don't know whether, that's why I said I did not know whether Mrs. Maria Rambauli had the authority from the board, because in some instances the board can issue a delegation of authority. So, but nothing was ever shown to us except that particular document. Hence, we continue to pay as instructed.
Is my assumption correct that as a user department you need to have some sort of an approval for a payment to be made?
That is correct. A memorandum which is approved at the highest level.
Okay, no, thanks. I think it's clear. Lastly, in relation to a dismissal, you speak about the system that was a minor component of the contract that was not working, I think around the biometrics and so on. At RAF in general, the control environment, is it normal for you to pay for services or for a system that is not functional? At that time, was it a normal practice that when someone is contracted to deliver a particular service, and then there are certain components that are not working in it, was it normal that you nonetheless make the payment?
Okay. Honorable Chair and honorable members, I will say, as you put your question, the contract, not that the services were not rendered, the amount that we are paying for that contract is for the daily visit. As they come to the work, do their rounds, the contractor, then we pay for their service. In an instance where there is something broken, it's when they will send a quotation with a 15% markup or whatever a markup that is written on the contract. Then we'll use that to repair. But however, the contract design was a daily visit, like that on that day visit, then we'll pay that amount, a fixed amount. Whether they've done all the work or they've done minor, but the daily amount will be paid. On the issue of a small component or one component that maybe is not working, it was because during COVID, the government issued instructions that even biometrics must be switched off. So they were switched off, but the visits by the service provider did not stop. The only thing we did was to reduce the number of visits. Thank you.
In my 14 minutes.
No, you've got 2 more minutes.
Oh, no, thanks. I want to check, Chair. Did you find it, Mr. Lehomo, did you find it normal that I believe you made the business case on the 11th of June, but the appointment was made on the 15th of June. Was this normal? 4 days later.
On which paragraph? I don't know which.
I'm saying on the threat assessment, on the service provider, Matuna's services. I'm saying it appears to me on my notes, you made the business case or the request to SCM on the 11th of June and the appointment was made on the 15th. Did this appear normal to you?
Yes, it appeared normal because most of the things that related to the former CEO were done on emergency procurement. And then it's not us who procure. We load the motivation to source, and then the SCM will go out and source people if they can find a supplier within 3 days, because that's the maximum. If they find a supplier within 3 days, then they can appoint if the supplier is above board.
No, thanks. No, Chair, I think in this last 2 minutes,
it's now half a minute. But
this half a minute. Lastly, I wanted to check, because I see in my questions here, there's something very important that I'm forgetting. The assessment would have said that, would have noted that there are some weak controls around access. I believe that they also meant at the home of Mr. Lutswalo. And there were recommendations of upgrades. Were there any upgrades from the side of RAF that were effected at his home? And when he was obviously out of this threat assessment, were there a recommendation of armored cars?
No, Honorable Member.
No, the question has two parts. One is about the former CEO's, Mr. Ritwalo's home. The other one is armored cars. So when you say no, are you answering both or?
Chairperson, yes, the no is for both questions.
Thank you, Honorable Maduna. Honorable Atkinson.
Thank you very much, Chair. And I think a lot of what one would have questioned has already been asked. But anyway, I just want to express my appreciation to the two gentlemen here today and to express my sympathy for you for what you've had to go through, for your response to the question earlier about the personal impact it's had on your life. So I'm truly sorry for what you've had to go through. I'd just like to ask Mr. Lehomo, you mentioned the fact that the board has the ultimate responsibility for the CEO's security. Would they have been aware of the appointment of that service provider from Durban? I mean, would they be aware of that deviation and the appointment of that new provider to take care of the CEO's security? So it should be something that the board would know about, wouldn't it?
Chairperson and Honorable Member, I don't know if the board was aware of that appointment, but they would have been aware of the procurement that we were doing to the tune of 480,000 per annum.
Right.
But that one of 150, I'm not sure if the board was aware or not aware.
Okay. Were you then not involved in the procurement of that increased contract, the one that went to the company from Durban? The one that would cost 1.5 million a year, that's the one I'm asking about.
Yes, Chairperson and Honorable Member, we were not involved.
Okay, all right. Do you know the name of the company from Durban that took over the security?
Mjaeli Security Services.
Okay, thank you. And then going back right to the very beginning, you mentioned the fact that there had been a break into the CEO's car in Pretoria, which appeared probably quite a random event. Was there anything else that happened? I mean, did he mention the fact that he received threatening calls? Was he being followed by anybody? Had he received any death threats? Was there anything that you were aware of apart from that break-in of the car?
Well, I'm only aware of the two incidences. One, the break-in, and the second one was the vehicle that came into the precinct, drove around, and drove out.
Okay.
And then we were called to be told that that is a threat against the CEO. But Mr. Mhlanga was directly involved in that one. Perhaps he can shed more light on that one.
Okay, if you could, please. Thank you.
Honorable Chair and honorable members, on that incident, I was called in the morning. I can't recall the date and time. Then I was told that there was a car that drove in at night, and then they took security cell phones and whatever. And then it drove in, drove out. When we checked on the cameras, yes, we could see it's a Hyundai car. It looked grayish. And then after that, then there was an allusion to say the CEO's, there's a threat against the CEO because cars can come in and drive out. So that's far what I know.
Was it more an issue just about the fact that cars could drive in or drive out, or was it about that specific car? Did he feel threatened by the occupants of that car, or was there something about that car that was particularly threatening to him?
Though I wouldn't know whether the CEO was in the premises or not, but on the investigation that I was still doing with regards to that incident, people who were affected were security personnel because the one at the access point was his cell phone or the two-way radio was taken.
Okay.
And then they drove in, drove out.
So it could have just been petty theft, basically, or it could have just been opportunistic crime rather than specifically targeted against the CEO.
I wouldn't know.
Yeah, okay, well, that's fine. Right. And then the other question I wanted to ask was, Just to confirm that Mr. Stevens Msisa is the one that's referred to as the specialist that came from PRASA. Okay, so it's one and the same person. Are you aware whether he did receive a security clearance or not at all in your time there or after? As kind of the acting head of security as he became, did he receive a security clearance from State Security Agency?
Honorable Chair and honorable members, I don't know.
Don't know.
Yeah.
Okay. Would someone in that position be have access to top secret documents at all?
Yes.
Okay, thank you. I think it's probably a question that's worth following up on to see whether he did. And is he still in position at the moment? Is he still employed by Road Accident Fund or holding an acting position there?
He was appointed as a senior security manager, Chairperson.
When was that?
During my hearing, Chairperson and honorable members, he stated that he was appointed on the 1st of July, 2024.
Okay, all right. And I just see someone sent to me something from the CIPC just to show that Mr. Stevens Msisa and Mr. Collins Letswalo are joint directors of a company. Would that be required to be disclosed in any way if you hold directorships together in a company or anything in the organization? Someone just sent me something from the CIPC to show that the two of them were directors of a company, the sole directors of a company.
Honorable Chair and honorable members, on that, at RAF, when I was still there, I don't know now, every year as employees, ethics department, I don't know whether it's still there or what, they will send us a declaration of interest that all employees must declare their interest, whether they've got businesses and whatever, and then the sole approver for that will be the CEO. In case you do have a business interest, then you write your executive summary or your memorandum to the CEO requesting that you be granted a permission to run a business. So as far as I know, I don't know whether it was declared or not.
So what would happen if the CEO had a company? Who would he declare that to then?
Honorable member, I wouldn't know, but as far in terms of hierarchy,
Yes,
he will have to declare to the board.
All right. So would the board get sight of those declarations by the various different people in the organization? Would they be aware of the various approvals that have been given about people who are running businesses outside of RAF?
Chairperson, I think, we will not know what happens at the board level.
Okay.
Safe to say, Mr. Stevens Msisa was not screened by security nor by HR, as far as we know, when he was seconded.
Okay.
Yes.
All right. Chair, I think, speaking to our Scopa Chair, I think it might be worth requesting copies of those declarations just to see whether Mr. Letswalo and Mr. Modise declared their joint ownership of a company. I think there's an ethical situation there as well. I think you might be aware in the last couple of weeks there was a lot of publicity in the Sunday Times about the abuse of Mr. Collins Letswalo's security detail, about him carrying, about the security officers taking a son to Mhlanga to a wedding, I think it was, and various other things. While you were employed, did you ever see what could be termed as an abuse of the security detail, where it was done for private purposes, or was it purely for his job as the chairperson of, or as the CEO of Road Accident Fund?
Honorable Chair and honorable members, as far as we know, most of the transactions that were happening will happen outside of we're excluded. So we wouldn't know whether the car was used for personal or business, but yeah.
Honorable Member, Chairperson, I was informed by Mr. Mhlanga about one security officer who was supposed to be posted at the residence as the home of the CEO. I think you can explain that.
Okay. Honorable Chair and honorable members, it happened in one of the days where I think there was renovations in the office of in the house of the CEO. So I was asked by the specialist to say, I want to take this guy to the house of the CEO, so that because there was no one in the house to look after those renovations. So, but in terms of using personal or more special on the cars, my previous answer still stands.
Thanks very much.
Thank you. Yeah, no, okay, thank you. You were bang on time. Thank you very much. Honorable Mhlanga. No pressure.
Thank you, Chair, and thank you to the witnesses for presenting themselves. I have a few questions. Mr. Lehomo, you said you've got 19 years experience with RAF. Can you confirm the years of experience you have with RAF?
Yes, it's I think when I was dismissed, I had 20 years experience with RAF.
On the security environment?
That is correct.
All right. In terms of the your affidavit, the policy relating to the security assessments, you're saying it's aligned or prescribes, it's aligned with SAPS and SAA dealing with those kind of matters. And by assumption, I assume that it does not make a provision for a private company to be consulted. Is my assumption correct?
It is aligned with SSA and SAPS. However, there are instances where we also can use private, depending.
All right. Let's answer specifically. Does the policy make a provision for a private consultant to be procured or services to be procured?
Yes, there won't be any problem if we use a private company.
Yeah, yes is sufficient, because when you say then there won't be any problem, it's as if it's not in the policy, it's a gray area. So if you say yes, it does provide, that is sufficient. So between the two, which one would generally take precedence, or it will depend on circumstances? I'm asking this because there was a risk assessment by SAPS which said there was no risk, and then there was another assessment by a private company that found that there was a risk. And in your affidavit, you are saying that Mr. Brian, I don't know if I'm pronouncing it right, but instructed you, despite the SAPS risk assessment, for you to then engage a private security company. And then you further say to do a risk assessment as we did when close protection was sourced for the former RAF-CO. I think that's the one preceding. So it means as a practice, you had engaged before Mr. Letsoalo or with the services of a private security company to do an assessment. Is my understanding of that correct? That as precedence before you had used it? That's the first question. The second question is, if they are contradictory, or if you have never engaged with that in the past 20 years, you can say so. But if they are contradictory reports, which one will then take precedence? Which one would you then operate on the basis of?
Just to explain what transpired, in this case, we requested the SAPS to conduct assessment. They came, they conducted assessment. There's no risk. But then there's a new threat. There's a vehicle that's been broken into. So, which means by the time the SAPS was conducting their assessment, these other issues were not in play. So, after the new threat, then we write back to SAPS to say, please review this. There are threats that the CEO is reporting. we request you to come and review. But then the processes of SAPS, normally, they will take longer. They will take really longer. So in the interim, whilst that happens, that's when we get the private company to do this assessment so that we can then issue, at least protect him with interim measures whilst we are awaiting the subs to come and do the main one.
All right, no, thank you. That suggests that there was no contradictory reports at any point. It was one report, a new issue happened, and another report through a different procurement process was then produced. So I'm clear on that. I just want to understand, what were the circumstances around the procurement of a private security company in the former CO before Letwalo? Why was it not SAPS and an SSA issue? Because you are saying that you had done that before. I mean, why not a SAPS one? Or was there a SAPS one in the first the previous CO?
Chairperson, the first one was not necessarily done by myself. It was done by the manager who was reporting to Mr. Brian Furness. That's why it will be Brian Furness that says, do it as we did for Mr. Modise. So it was done by the security manager before me.
So you were in the department. You said you were there for the past 20 years. So now there is a manager that reports to Mr. Furness. Can you just give me the picture of that hierarchy? So where are you in this value chain? I want to understand what could have been your role in the previous incident, or are they a totally different department that you had nothing to do with, or if they are within, because if it gives you authority or if it gives you an instruction, it tells me that it's within the hierarchy of your reporting lines. And then it means that this would have been done by your department. Forget the fact that it's RAF, your own company, but it would have been within the confines of your department. Can you just briefly explain to me that so that I move to the other questions? Mindful of time, thank you.
At that time, Chairperson, I was a senior security officer, and then I was not involved in the executive protection.
All right, okay, no, that's fine. Mr. Letwalo, when he was here, he made statements of, I think 2, if I'm not mistaken, attempted assassins or assassination on him. Besides the car that you mentioned issue, car broken into and the driving around car. So you are saying you have no knowledge. There are no reports or anything that ever came to your attention about any other attempted assassination besides the 2.
That's correct.
Thank you. The last or second last question I want to ask, you're saying that the security issues of the previous CEO were not handled in your department, the funding of it. I think you said something like that. You can correct me if I'm wrong. You said the previous CEO used his own vehicle. The security was handled in security management. I don't know. Can you just clarify where was the funding coming from of the previous CEO, and did it come with the change in organizational structure, and how did it come about that the funding now for this CEO comes then from your office parts of it and a petrol card from somewhere else? Can you just explain briefly that part, and then I'll come to the last question. Thank you.
Thank you, Chairperson. The security of Mr. Modise was not, the invoices were not processed by the department itself. We could only assist with technical expertise in terms of him assisting him to source the supplier, and then from there he took over, and then he did everything on his own. Whether it was paid by the road accident fund money, or it was paid from his own pocket, or it was a fringe benefit, those are the areas that I wouldn't have known at the time.
As a person in the security environment, and I would regard as an expert, qualification and experience, which process would you say is legally valid? I mean, in terms of handling the security detail of executives at RAF or anywhere else, between you and a central place in security management handling it, and it being handled mysteriously somewhere where you don't even know?
Chairperson, I think personal security is personal in nature. So to avoid a risk whereby everybody is aware of the itinerary of the CEO and the itinerary of the CEO and stuff like that, I think to me it will be a risk. So I'll rather say it can, because it's personal security, it can rather be divided. The security department on its own must protect the entire RAF personnel. That is our job. We focus on the entire assets of the organization. And then when it comes to the personal security issue, I think then that was how I understood it when the security specialist was seconded. That's how I understood that. Then he will just handle only close protection with specific looking into the office of the CEO.
So just a quick follow-up on that. You are saying that the handling of the security detail in your department, you feel that it was a risk for the CEO. And then the appointment of a specialist would have been an intervention to mitigate that risk, so that private or close protection then reports directly to him and not to you, so that you are not aware of all the itinerary. Is that what you just said now? I want to understand it.
As a matter of fact, I did text the former CEO to say, based on the risk of this thing going back and forth within SCM, and now it's becoming known to everybody, rather you have, because this is personal security, and then we had an opening position of task level 12 at the time. And then I said, we do have an opening of task level 12. I suggest that you rather have a dedicated person that handles your security, who can then liaise with you directly. That was my proposal to him, Chairperson.
Thank you. Last question, Chair.
Last one, yeah.
Definitely. To Mr. Mhlanga, I just want to understand. You said you have now instructed your attorneys to act on the deviation of RAF from the order of the CCMA. Why has it taken you so long to act to issue that instruction? Because there was a clear order of reinstatement issued by the CCMA, which was clearly defied by RAF. And why was there no follow-up action on the defiance? I mean, timelessly, this is an order that's a year old now.
Thank you, Chair, and honorable members. At first, we did send like summons to RAF to make that order, to enforce the order. Then RAF wrote to my attorneys saying that they are in a process of reviewing. So we waited, and then even my attorneys advised that because they've alluded to the process of reviewing this matter, then we need to wait up until I think now it's October. Then we'll then revisit if they've not given us the date and all other necessary documents that are required. Thank you.
Thank you very much. Thanks, Honorable Matlala. Honorable Mende.
Now, thank you very much, Chair. Good afternoon to everyone, and good afternoon to the brothers. I want to believe, I think earlier on the chairperson did try to make this distinction, to believe that your main grievance and the reason why you presented yourself was that there is an unfair labor practice that you have identified, and you feel you were removed in the department, or rather at RAF, unfairly. Am I correct?
That's correct as well, Chairperson.
Thank you very much.
Chairperson, on that, I will say yes, is in two ways. There is this process that is.
Chairperson.
Thank you very much.
Chairperson, on that, I will say yes, is in two ways. There is this process that and then there is this other part that that affected us directly of unfair treatment.
So, Honorable Member, let me just stop the clock. So, I want to characterize my own comments properly. So, my point in the committee earlier was that we are not here to review their cases and determine whether they have been fairly or unfairly treated. The only reason this is traversed, this is put in the affidavit, is because in their view, it relates to needing to remove them so that these things they allege can basically go on. So I'm just basically a version of that. So I just want to be certain that we made it with pains with other witnesses as well to say we can't deal with your personal matter here and you can't win your case here. You've got to win your case elsewhere. So just to be clear. Thanks, Honorable Member. I'll restart the clock.
No, thank you, Chair. Point taken. No, Mr. Lehomo, given everything else that has been asked and the experience thereof which you have within the security sector, paragraph 22 up to paragraph 24 of your affidavit, I just want you to take us through something. You commenced the procurement for 480, and then it didn't yield positive results to the satisfaction. There's an operative word I want us to delve into. To the satisfaction of Mr. Litswalo's expectations, meaning which, if I'm correct, he was making certain demands. And then he ultimately sends you a message that it's taking too long and the risk is becoming higher. This is him asking you as a person who has taken the thing. Now, 24, you then say something that's confusing. I was reluctant about this procurement because it was not clear whether this was a personal fringe benefit for CEO or operational expense for the RAF. Kandi, what was informing you when you started? Because all of a sudden you undid everything on a confusion that you were not sure of what you were doing. What is it that you were instructed to do and that which the CEO, in his understanding, you were doing? Unpack that for us.
Chairperson, paragraph 24, perhaps I was trying to summarize my state of mind through the entire process. That from the time I was told to commence this process, I'm saying my state of mind always had these doubts that, is this what we're doing? What is this? Is a fringe benefit paid to the CEO? Or is this something that the RAF must pay? You know? So it was just an issue of here explaining my state of mind throughout the entire process. Not that I was not going to procure for him. Remember, it's not even me who procures, it's SCM. Had SCM processes found a supplier, a reputable supplier, to render the service, then that process would have went ahead. So I'm trying to explain on 24, there was a doubt in my mind. Even that doubt is still in my mind, whether this is a fringe benefit or not a fringe benefit, Honorable Member.
Okay, now I'm confused. You said the board approve 480, and the board made reference to the previous employment of these services, or rather services that were ever provided to a RAF CEO before. Was that the case?
It's not the case, Chairperson and Honourable Member. It was not the board that made example of the previous CEO. The board approved security for the CEO, and then they kept it at 480,000 per annum. So that was what the board approved, 480 per annum as a fringe benefit.
Now we're getting somewhere as a fringe benefit.
Yes.
But it confused you later on. So how was this fringe benefit going to be utilized in terms of this provision of security?
From my end, I did not know, but I was told to source security using the same board resolution.
So you were sourcing not knowing whether RAF is gonna pay or the fringe benefit is paying. I'm not understanding. I want to get to a point where, because we need to break down this 480, but I want to understand, what was your understanding of this fringe benefit ultimately?
What became from the instruction of the senior manager, what became clear is that we need to source the supplier, and then that supplier will be managed by the security department, which means once we have sourced that supplier, we will be responsible for processing and payments of the invoices. And then the 480, Honorable Member and Chairperson, the 480 comes from the three people, close protectors, one driver and two
protectors.
Yes. So there was a time when we did, because the CEO referred me to the security manager then at the Department of Transport, our mother body, to say, let them assist you with how they did this thing at transport. So I spoke to the gentleman, and then he indicated to me that no, here we use on pay as you go. That's how he called it. So in other words, if somebody is going somewhere, they do a risk assessment and then they assign for that particular moment. It is not something, but it's not something that is done like the way I was expected to do it at RAF. And he would have also given us some few suppliers who are contracted with RAF, with the Department of Transport, my apologies. And then those names were given to our SCM to then contact as well, so that they can be asked to also participate in this process of RAF. So some of the invoices would have then come back indicating that at that time, the salary will be, it was about something estimated to be around 15,000 rands per month. So that is what this 480 comes from. It's from three people who earn about 16,000 per month, and then you then come to around 480. That's where it comes from. So that's part of the exercise that was undertaken through SCM to see how the companies that are contracted with transport will charge per person.
Yeah, we're getting. So what were the demands of the CEO? Because you're saying it didn't yield the results to the satisfaction of the CEO.
The result relates to when SCM will advertise, will send out a request to companies to submit proposals, quotations. Then according to the time, it's merely on the time factor that he felt it was taking too long. So his expectation would have been, maybe it will be done in December. And then he sent me a message in January saying, no, this is too long. And there was, yeah, that is on the time factor, the expectation.
Was he unreasonable?
I think he was not unreasonable in this instance.
Precisely because there was a threat.
Yes.
Thank you. Now let's get to these salaries you just mentioned.
So, Honorable Member, I know you said you hate the 10 minutes, and I'll allow you 2 more questions. Because we're over.
Explanations are too long.
No, yeah, I've recognized that. So 2 more questions, and then.
Okay.
Can I ask that, like I said, just answer specifically the question the member is asking?
My opening was on the unfair labor activities that have taken place around your lives. And get me right, I hear you and I see you. But we need to also be fair on the processes. Now, you just mentioned that the salaries would be 1560. This is close protection office. A CPO close protection. I want you to take us through what kind of close protection is this? Is this just a security guard, B grade, for as long as they are registered with SERA, or is it a security guard with high technical training to protect, as well as armed security to protect? Similarly to the driver, is this a driver who just drives, or is it a driver with advanced driving, trained in a high-risk environment to be able to identify and pick up danger and run away and all of those things? And if that's the case, who determined the bracket of the salary? Because if that salary, that's not protection in terms of the salary brackets. It's not high risk protection.
My understanding was that should there be a cost that exceeds, because the benchmark was based on the companies that provided the quotation at the time. But the understanding was that should there be a cost that exceeds what was kept, we will still proceed. It has happened in many other instances where people they go out on RFQ or tender, and then with the kept amount, but the responses becomes higher than the set amount, and then it goes back to the board for ratification. So this was not necessarily. Had we received a quotation that says 800,000, because this is the process we were following just before the specialist arrived. Should, for example, if we received that says 800,000, we would have then just went back to the board to say, yes, we went out as you have instructed us, but this is how, these are the people that we have found, and the board would have taken a decision from that point, Honorable Member.
So the price that you are then giving us and telling us that it looks suspicious to you, the 170 per month. Is it 170? You're saying the
150.
150. 115.
150.
Yeah. I don't want a page because it makes sense. So you then went to break down the 480, and the 480, I can tell you now, it can't give you high protection services. I lead myself. At some point, I was offered high protection services. That amount you can't pay for high protection services if you want to protect someone at a higher risk environment. Now, the 150, how do you arrive at you had cut the cost, the 150 is unreasonable for high protection?
I'm not saying the 150 is unreasonable. I say the 150 was far higher than the money that the board had approved. So because of that, it would have went to the board for ratification. I'm not contesting the amount of 150. I'm just saying the board, as instructed, they would have received that particular proposal of Mjaeli and approve it that way.
Okay, Honorable Member, your time is like way expired. But with your permission, I will carry on this line of questioning, right?
Please.
In my sweeping. So let me do that. Okay, so let's start at paragraph 21. Sorry, I may be wrong. I think it's paragraph 19. It's on page 4. If we can go there. Page 4, paragraph 19. The RAF board adopted the business case as presented. So you presented a business case and passed a resolution approving close protection for the CEO limited to an amount of 480,000 per annum. So as I understand, you went to a private security analyst, let's say for ease of reference, to analyze a threat. The private security analyst comes back with a recommendation because the board is seized with the matter, right? And I think for the context of the members, the discussion around the protection of the CEO is part of the contract negotiations for the CEO to become permanent, I think. Right? So it's part of the contractual negotiations. And this information you will see, it's in the memory stick. I'll just ask the colleagues to say under what section so that you can find it. So let me provide the context. They're negotiating the contract of the CEO, and it gets stuck on this matter. So the security team is asked to then do an assessment in light of the break-in and that kind of thing. So you go and you get there, so you do the assessment, you ask someone to do the assessment, and the assessment comes back. I think it would be useful to Honorable Mende and all of us to understand when the board gave the 480,000 rand number, did you feel that it matched the level of threat, level of protection recommended by the security company? I think that's where we'll get to that. So, because when Honorable Beasley also said 40,000 a month, I started doing the calculations for 3 people. It's a penny, right? So let me rather ask this question, and it might not be for you to resolve. The board will come here and answer the question. So this is not a trick question. When the board comes back to you and says 480,000 per annum, do you go, yes, we can work with that? Or do you say, oh, I don't know if we're going to find anybody at this price? Just tell us what you thought of the board limit at 480,000. Did you raise any objection? Did you feel it was not enough? Did you feel it was enough? Keeping in mind that you had previously, for Mr. Modise, had procured the say. So what did you think of the 480,000?
Chairperson and honorable members, my understanding was to go out on RFQ, request for quotation. That is not our terrain. It's SCM terrain, and then based on, they will normally select 3 suppliers.
No. So I'm asking a different question. I get all of that, and please don't feel pressurized. I get all of that. You are the security expert. You said yourself that the SCM people are not security experts, right? In other words, you would have some input in determining whether these are fly-by-night people or they are proper people, right? I'm assuming in the normal course. They wouldn't just get a list and you accept it, whichever it was, without your involvement. What we are trying to understand is that when you got this number, 480,000, they said, that's your limit. And that's a number that gets given to SCM. I just want your own thoughts. Did you think it would be enough, or did you think it would not be, in light of the feedback from Maduna consultants or whatever? That's all I'm asking. If you didn't have an opinion, you can say so, but just confine yourself to the question.
I thought it was not going to be enough, Chairperson.
Okay, so we know that. Did you raise an objection? Did you say, look, what did you do? Did you say, we'll see what we can do, but I don't think it was going to be enough? We just want to then get your state of mind as you went out. So what I'm hearing you to say, even as you pass this to SCM, you appear to think that you're not going to find that level of security for this kind of money. Is that your...
Yes, Chairperson, that's correct. And the idea was that we go through the SCM process, and then the board, if we find a higher supplier, the board will have to ratify.
So in other words, you would then get bids from SCM, and SCM would come back to you and say, look, we can't find anybody for this level of threat at this money. So we now need the board to authorize a higher amount so that we can procure at a higher price, basically, because we can't cover the threat with this kind of money.
That's correct, Chairperson. That's where we were.
Okay. So let's then go back to your affidavit. So I need to Honorable Mendes' questions. So when you say in paragraph 2, so the fringe benefit, Honorable Mendes, and I've just asked the team to provide guidance where it is, it's the board that decides on the fringe benefit things. We're going to ask them why when they get here. But it's the board that decides it's a fringe benefit and so on. So when you say in paragraph 23, this process, however, did not yield positive results that satisfies Mr. Litswalo's expectations. So Honorable Mendes was saying, please explain that. What was his difficulty? Was it that the security is not good enough, or was it something else?
Chairperson, my understanding was that it was taking too long for him to be issued with. Remember, at this time, he doesn't have close protection at all. But the approval has been there, but he doesn't have close protectors at this time. So the expectation is that it was taking too long for him to be issued with close protection.
Okay, can we just understand, so when did the incident in Brooklyn happen? Because when he says this to you is on 19 January 2021. When did the incident of the break-in in Brooklyn, which is the one that kicked off the private security assessment, do you know? It doesn't have to be a specific date. It can be a month and a year.
Please allow me to check. Don't take too long. Well, the incident, Chairperson, was reported to me, I think, the incident itself is 11/2020.
So it's November 2020, and Mr. Litswalo writes to you in January. So 2 months later, Mr. Litswalo says, this is taking too long, right? That's what I understand. So you had already asked Honorable Mendes had already asked you if you thought that his complaint was unreasonable. about the length of time it was taking, and your answer was, it's not unreasonable.
It's not unreasonable. The frustration was from the SCM side, the delays and everything, yes.
Okay, all right. I hope that we've cleared that little point. So I just want to then take us through logically. Let me just understand because what's going to help the committee understand where there might be a deviation, and we'll ask to just make sure the RAF provides us with the information. In Mr. Modise's case, were any of you involved in getting his security?
No, Chairperson.
I was still a security officer in Durban, so I was not involved.
So you were not involved, okay. In the case of Mr. Watson, were you involved in the decisions in the threat assessment of Mr. Watson? He came after Mr. Modise. He was between Mr. Modise and Mr. Litswal. Was there a threat assessment done on Mr. Modise? Mr. Watson?
As far as I recall, there would have been a threat assessment done and vetting done, yes.
Okay, but you were not involved in that?
With Mr. Watson, I was involved.
Okay, so when you say there would have been, it gives the impression that you don't know, you think that it must have been done. So if you know, it helps the committee when you say, yes, it was done, not it would have been done. I know English is not our first language. I know what you are saying, but it's important for the record that we say what we mean. So what you're saying is that the threat assessment in Mr. Watson's case was done.
Chairperson, yes.
What was the outcome of that threat assessment? What did it say?
I do not recall, but what I can say here today is that Mr. Watson himself, he said, he would say he doesn't prefer to have bodyguards, and he was just that person. So I mean, it has been 3 years since I left that office. So I don't recall everything, Chairperson, at this stage.
So the question I'm asking is, so for example, the organization may decide that I need to get security and I decline. All I'm asking is that because you were involved, did the assessment recommend a close protection for Mr. Watson? That's all. We're going to get to his decisions or his preference. I just want to know what the threat assessment said.
No threat, Chairperson.
Okay. When there is no threat, what is then the decision? So, because I want us to separate his personal feelings from company policy, you understand? Okay. So, with a threat being 0 for him at that point, right? You would then have taken no further steps, and Mr. Watson would have then needed to drive himself from home to the office and to meetings and to the airport and so on.
Correct, Chairperson.
Okay, yeah, so let's leave his feelings aside out of this, okay? So I just now want to understand the process, and Mr. Modise will assist us as SCM head later on after lunch when we deal with this. I just want to say, so in your understanding, what would have happened is that you already had a suspicion that you're going to battle to find someone to pay. Are you saying that the process then would have been to present back up the chain, because it was a board decision? The board needs to review its own decision and maybe change the amount to something else or authorize. So that's what would have needed to happen.
That's correct, Chairperson.
All right. When did your involvement with this matter end? Did you get a chance to escalate it up? Also, in fact, let's go to the paragraph concerned, because I think that's going to help us in terms of the process. We're nearly done. I want to get to Ms. Rambauli's. Okay, so just before we get there. So, before you received the invoices that you say amounted to 150,000, following the procurement of Mjaeli Security, did you send communication back to Mr. Fairness, I think it is, so that it can be communicated to the board that the limit they've provided is not enough? Were you in that position yet, or you had not yet received feedback from SCM?
When the specialist arrived at RAF, when he changed this and sourced the Mjaeli, there was no any other time to. In other words, I did not even go to. I couldn't have went to Brian to verify, because it was clear that this person is coming here to deal with the security of the CEO, so he's taking over.
Okay, so to the best of, I just want to clarify one thing. So the process was taken away from you at that point.
Yes.
The only time you interacted with it again was when you were signing the invoices, that's all.
That's correct, Chairperson.
Okay, I then just want to understand the context of your, so you say in paragraph 39, can we go there? That's page 9. Let's go to paragraph 39. You say, I raise concerns about this irregular expenditure and deviation from board authority. So in other words, you're saying the board gave us a limit of 480. When I look at the invoices that I'm signing off, they exceed 480, right? When I cautioned the security specialist that his approach was not in line with the board's resolution, he produced an internal memo approved by Ms. Maria Rambauli, the acting COO. It purported to authorize the expanded security arrangement. Just tell us what it said. You don't need to repeat it verbatim. Just tell us what it... So you saw the memo, I'm assuming, because you say he produced it. What did it say?
Yes, I saw the memo, and on the memo there will be a quotation attached from the Mjaeli company that specifies the cost. I will not be specific in terms of the cost, but then it will specify a vehicle, to specify the human resources and stuff. That's what I saw, and the memo itself will just explain sourcing of a protection to source service provider to protect the CEO, and then it was approved by Ms. Rambauli.
Okay, we will ask Mr. Msiza and Ms. Rambauli to account for the portion that you were not involved in. So I'm just wanting to understand that you did sign invoices. We will also just ask to see those invoices. I'm just going to say on the security clearance issue for the members, in the memory stick are also correspondence between the Road Accident Fund, but I've asked for ease of reference for the members that this be emailed to you. I think it was emailed some time ago, about an hour or so ago, so that you don't need to look hard to find it. The short version is that the SSA never received a form or documents for the chief executive of the Road Accident Fund at any point. But that's something we will have to take up with the staff member who was sitting at the back there. I forget her name, who told us it had been done. So we just need to close that gap with both the former CEO and that person, because the former CEO had told us that he has clearance, and then in May but the members can see the entire correspondence. There's about 5 on the memory stick, but I've asked for it to be uplifted. So as I said, that I'm not going to ask you to speak to things that you were not directly involved in. We've got about 15 more minutes. And so I'm going to allow the members who have follow-up questions, 1 question each. I saw you, Honorable Neil May, for a follow-up. And then Honorable Mende, you've got a follow-up as well. Honorable Neil May.
No, thank you very much, Chair. The follow-up question I have is the threat analysis, the threats that the CEO had received. other than the car that drove into the premises, did a U-turn, took pictures, if that's what I heard. Were there any SMS threats? And what kind of threats did the CEO receive to have that kind of security? Because if you're actually saying that at the end of the day, a car that was armor plated, bodyguards, somewhere there must be some kind of physical threat that would have come via telephone, a cell phone, SMS, to that point. Do you have any knowledge of that kind of threat other than a vehicle and a theft in a parking lot? I know quite a lot of my other colleagues have had their laptops stolen out of their vehicles at a car park, and I'm not referring to anybody present, but that doesn't mean that that's a threat to the person. It could be just theft out of motor vehicle. So because of the kind of security that was requested, and there must have been a report from the security company, what kind of threat? Can you give us some indication of this high-level threat against the CEO to have this kind of security? Thanks.
Chairperson, perhaps I should explain that the other vehicles were procured after we have been dismissed. I think she's asking about the armored vehicles and stuff. We were not there.
No, so can I just ask, Honorable, so can you just please, and members, what would help is if the questions are concise. When the question is long, I think the witnesses get lost. I think Honorable Nilmay is just asking whether that you know of any other threats. She makes reference to SMSs and so on. So I think that's the nub of, that's the center of Honorable Nilmay's question. Were there any, apart from the break-in, were there any other threats that you became aware of? Then she made an example about SMSs and so on. That's the question.
No, I was not aware of any other threat.
Chair, it's the evidence I'm looking for. What evidence was there that security company gave you, which then said there was a threat? There must have been a report. That is the information I'm looking for.
So, as I understand, Honorable Nilmay, a report was produced by Maduna. And it is on the basis of that report that the board took a decision to allocate 480,000 as a fringe benefit. So that had been canvassed. So I just want to know if you're asking about the nature of the threat contained in the report. If that's what you're asking, then you need to put it like that so that it's clear.
Yes, Chair. It's the nature of the threat I was looking for. So there has to be some evidence that must have been produced to say why the CEO needed that kind of security. And then I used examples. Did they find any other SMSs, messages?
Please go ahead. Let me ask this question. The report from Maduna, did you see it?
Yes, during that time, yeah. I don't have it now, but yeah, I saw it.
What did it say in substance? Did they give a basis for saying there is a threat? Did they explain the reasons why they are saying protection must be provided?
Yes, that's correct. Normally they look at the inherent threats for the position, such executive positions.
No, I know that. So just say, in this case, this is what they said.
they said the RAF must consider protecting the CEO, but they wouldn't go to as far as saying how many people or how many cars and stuff.
No, it's a different question. So for example, remember the members don't operate in your environment. We have never seen, well, maybe the members have, but a threat assessment, we haven't seen it. We don't want to make assumptions about what it says, okay? We just want to know if there were specific reasons given for the recommendation. That's all we want to know. Did they say, we think that the CEO's car may be broken into again. We think that he may be shot at while going home for these reasons. That's what Honorable Neil May is trying to get to.
As far as I recall, Chairperson, they said the threat, there is a threat, there might be a threat, especially when the CEO commute from home to office. That was to the effect of the report, but I cannot now recall all their recommendations.
Okay, I think I'm not certain if the report is in the memory stick, but we'll just try and locate it. So it appears that you don't know, you cannot recall the reasons given, because that's what I think the members are trying to get to. Or do you know, Mr. Mhlanga, at all? Did you interact with this report?
Honorable Chair, no.
Okay. Honorable Neil, may I get the nub of your issue? We'll just make sure that report is available. I think it might be in the memory stick, but let's Honorable Mende, you had put your hand up, then Honorable Atkinson, and then Honorable Mhlanga. So in that order. So I'm following the order in which the hands went up.
Thank you, Chair. Paragraph 35, Mr. Lehomo. You are saying then they deviated. We have already agreed on the 480 and its capacity to render proper services. Now, considering what you have highlighted earlier on of the satisfaction, and rightfully so, you're saying it was not unreasonable for the CEO to be telling you that it's taking too long because it has been over 2 months and people die. Now, here on paragraph 35, you are saying the deviation process was not followed properly. Is it wrong under these circumstances to appoint someone who's already in the service of your company? Is it wrong?
Chairperson, we had security service providers in 5 offices, head office, Pretoria region, Durban, Cape Town. So there were other service providers. So my issue here was I do not understand why Durban regional office service provider, because we had other service providers contracted to the RAF. That was the issue.
So was this particular service provider not contracted to RAF, but in a different province?
This was contracted to RAF in a Durban regional office, and the service was for the head office. So I would have actually thought perhaps a head office supplier would have been used, but we could have just motivated to the board as to the reasons. But my issue was why the Durban regional office supplier and not the head office supplier or the Johannesburg office supplier?
So, Honorable Member, can I just ask Mr. Lehomo to just on your own version? So can I read, just switch off the mic, so can I read that paragraph? So I said earlier, you can, to refresh your memory, look at the affidavit, right? In the affidavit, you do not raise, so you say in paragraph 35, your issue was the issue of that there was no open tender. But you are not mentioning that now when Honorable Mende is asking. So that's what makes the conversation challenging for us because you answer, we look at the affidavit, we don't find what you are saying. You know what I mean? Right. So, firstly, I now need to understand whether you're changing your mind about paragraph 35, because that's the difficulty that we now have. And you can read it. So, like I said, the affidavit is there for you you can refer to it. But when you give an answer that appears to be different to your affidavit, of course, we're all gonna wonder what's going on.
Like I said, Chairperson, the issue was with me because we were still following the 480 process, and suddenly there is this memorandum that is approved for the Durban Regional Office to render the same service. So that was just, for me, it was just problematic on that note.
Last follow-up, Honourable Member.
Okay. Now, here again, and the entire section D, my brother, given what you have explained, I think the entire section D, if you were to go back and revisit it now, and you are not in court, you're not going to be arrested for this. The entire section D, I think it's very emotional. All of it, I wanted to go to, 37. In addition to the 150 per month payments mentioned above, the RAF incurred further expenditure to support this VIP protection, a fuel card, a BMW, accommodation, and all of those things. These costs, here is where, these costs were charged separately to the security departments and facility management costs. And they all paint as if then now this cost of providing security was unreasonable. That's how I'm understanding it, that it kept going high and it was not reasonable. And is now contrary to how you understood the breakdown of what is a cost per CPO and a highly advanced skilled driver. Because also again, you are referring and comparing this cost to a cost of someone who provided his own vehicle. Mr. Zibi brings his own vehicle, he then gets Ntombi and Devin to work, then there's no cost of a vehicle because he brought, but he doesn't bring his own vehicle, so these people must drive him, you understand? These people must drive him. So how was this vehicle and the petrol going to come about? What was your understanding then? If you are excluding that particular cost to this total cost of protection.
The issue here was that we were working on the capped 480. And then when the same service is procured, we then find that the invoice is approximately 150,000 per month. So that is actually the issue here. It's not necessarily, there is a allocated amount. Then it's not about is it enough or not enough, but there is an allocated amount. And then, but when the service is procured, that amount exceeds this one. So that is where the challenge was.
But the COO then covers with a memo on that, COO of the company.
That's correct, and I'm not even aware of the delegation of authority, whether she got it from the board or she did not get it from the board.
All right, no, thank you very much. We will canvass that separately with that, like I said, we will ask Ms. Rambauli, and also, we've also got the benefit of the board's own records, and the statements of the former chair now in July, but that's for the committee to deal with. Honorable Atkinson.
Thanks very much, Chair. And I did ask at length earlier about whether there were any further issues, apart from the breaking in the car and the car driving around the complex as well. So one thing I wanted to add was the CEO himself claimed that he was under threat because of the reforms that he was bringing to the Road Accident Fund, because of the changes he was making. Was there any further explanation based on that, on the reforms? Because he felt that there were people who wanted to stop what he was doing, and therefore he was under threat because of that. So in your mind, was there any examples given or any reasons given because of that, because of what he stated?
No, Chairperson, I was not aware of that.
Right, thank you. Honorable Mhlanga, and then we'll break.
Thank you, Chair. I just want to check, Mr. Lehomo, what is your role in the processing of the invoices?
We use what we call the subsystem. So they will load everything on the system, and then you release that the PR for the invoices to be paid. So
What's a PR? Sorry to interrupt. We always want to understand acronyms. What's a PR?
Oh, purchase is a purchase requisition. But just to go direct, my role is to approve, is to sign this invoice so that it can go to finance for approval, after having satisfied myself with other attachments relating to that service.
All right, so in this particular matter of the cost, you did that process. You were the one who then approved.
The company will send invoice, and then the invoice will eventually come for approval, and then yes.
Yeah, the last one is the simplest answer. Yes. So I want to understand from your side, because you seem to be suggesting that this would, you knew and you questioned that this would be unauthorized irregular expenditure. I think it's yeah, I raise concerns about this irregular expenditure. That is what you say on paragraph 39. So I want to understand then, if despite you knowing that this would have not been a pre-approved condition, and this would have been an escalated cost, you still proceeded to release the purchase orders, which would have been acting on an illegal instruction, illegal for the lack of a better word, because you are saying that you are aware that there should have been a ratification of the amount because it was not the initially approved amount. And you raised the concerns, but despite all of that, in your own exercise of responsibility to your duty, you proceeded to release the purchase orders. I just want your take on that. And that is the last question. Thank you.
Chairperson, when I raised concerns, it was before I saw the approved memorandum. So after I've seen the memorandum, which was approved, then I was satisfied to process the invoices, although there was this one doubt, whether the approver had the relevant authority from the board or not. Thank you.
Chair,
the real last one.
The real last one, yes. Because you in your position, you were a national security manager, right? So you have seen the memo, and you seem to have you have clarity of process. So you've seen the memo. You do not know if it sources its own authenticity or legality from a board decision, which is the legitimate structure that will then reverse its own, approved process. But what mechanisms did you do to vet that memo, to check if it comes from an authority from a board meeting before you process? Because you're dealing with a very delicate function that speaks to releasing funds or authorizing a purchase order. So what mechanisms did you put to alleviate that doubt that you had? Because you had your own doubt that this may not be in line with the board decision. Thank you.
As alluded before, Chairperson, the doors were closed for me at that time. Once the specialist arrived, there was no way where I could go and get assistance.
All right, thank you very much. So honourable members, I will suggest we break. And Mr. And this is, Mr. Honourable Matuna. So Mr. Modise is going to come. We're going to swear him in. Mr. Modise traverses the same issues, and we are going to ask them to stay and be available to ask for us to ask questions. Right? So can I ask that we do that? Because in completing the story, Mr. Modise is the SCM person. So he's going to answer. Then our story is going to be somewhat complete. I mean, not totally complete, but somewhat complete. And then they will still be here to answer questions. Gentlemen, thank you very much. I know talking for long is exhausting, so we're going to take a break of 55 minutes. We'll be back here at 2. And honorable members, thank you very much. We'll be back here at 2 o'clock. Honorable members, good afternoon, and thank you very much for being back in time. Are you ordering us something, Honorable Isaac? Are you quickly ordering us something for the committee members? Are you speaking to Mr. Delivery? No. Oh, okay. I thought you were telling them where to deliver. You can order something though for the members. Okay, members, put your orders through for your favorite poison. Get 4 for the committee. Honorable Mente was saying we need transportation. I think maybe she would get here very quickly. She had a Lamborghini to get here. Okay, honorable members, thank you very much. The committee is very serious, talkers, but sometimes, you have to have some fun at some point. Otherwise, it gets depressing. So, Mr. Lehomo and Mr. Mhlanga, before we swear in Mr. Modise, I just want to clarify something, and you can speak from there. The microphones work just the same, right? Just want to clarify something you said earlier on, right? So, am I correct in my understanding that if you work for one government entity and you get a security clearance, when you move to another entity, you don't take that security clearance with you. You must be cleared for that specific entity itself. Is that so?
Yes, that is true.
Okay. How does it work? So basically, it's within entities. Does the same apply to the job that you're doing? So if, for example, you were head of supply chain, I'm making an example, and as a result of your job, there's a threat. Well, let me ask about the threat assessment, sorry. When a threat assessment is done in one entity, is that also transferable to the next entity that you work for? Is it linked to the job that you are doing? So in other words, if I was CEO of ESCOM and then I leave and I become the city manager of the city of Johannesburg, does that threat move with me to the city of Joburg, or does a new threat assessment in light of the new role need to be done?
Chairperson, the new threat assessment need to be done because the assessment is risk-based.
Okay, relative to the job. Final question from me, and members, in your memory stick, I think it's section 5. I'll ask the team to just put out something on the website, on the group, just to point you specifically to the folder where it is. This is why I'm asking the question of Mr. Lehomo and Mr. Mhlanga. So in 2021, the Road Accident Fund informed Parliament, I think it was, that the chief executive had top secret clearance. And then later on, in part of the bundle of documents that we've also received in the same folder, the chief executive does not have, basically the form was never submitted. I just want to be certain, and if you were not involved in 2021 or 2019, 2021, I'm assuming you would have been involved at the time. Was there a time, to the best of your knowledge, where the chief executive, the former chief executive, Mr. Letswalo, received top secret clearance from state security agents?
No, Chairperson.
So no, you are not aware that would have. So to the extent then that a Parliament was given that information, it would not be something that you can confirm as being accurate.
Yes, because as soon as he arrived, what I remember is that the manager responsible for vetting sent the Z204 forms to executives to complete and then send back to us. So that was where we were at that point.
All right, but you never received. I just want to be certain for the time that you were there. I just want to get this as a final answer. I'm not saying it didn't happen ever. For the time that you were there, did you receive notification that he had received any security clearance at all, including top secret?
No, Chairperson, we never received any notification from SSA. Thank you.
All right, no, thank you. We'll take it up with the people that answered to that when they arrive here. Thank you very much. So please stay on. We're sorting out your flights, so don't worry. You'll still get home today. Don't worry. So, Mr. Modise, what we going to do, we're going to swear you in. What will happen is that Ms. Ibrahim will just explain the whole procedure and then swear you in, and then we will begin. What I will do is that following your swearing in, I will just deal with some points on the affidavit. Specifically, there are some concepts I want you to explain because we don't work in supply chain. Procedures and so on, the members can read the affidavit, right? And then I'll just ask to just maybe 3 or 4 questions on various aspects just for amplification. And then we will start with the questions from the members because they've got the affidavit that you deposed. And then where relevant, especially on the issue of the security, the 2 gentlemen are here. So the rule is if something is within your personal knowledge or somebody you can identify told you or gave you an instruction, of course you can say that, but something that you had by the by, I'm not recommending that we say that because the committee cannot operate on rumor. We have to operate on things that we can actually follow up and verify. Right. No, thank you so much. Ms. Ibrahim, over to you.
Thank you, Chairperson, and good afternoon, Mr. Modise.
Good afternoon, ma'am.
So you've been invited to appear before the Standing Committee on Public Accounts to provide information in relation to the committee's oversight inquiry into the Road Accident Fund. National Assembly Rule 168 provides you with certain protections and privileges, and I'm going to take you through that before you take your oath.
Thank you.
Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. We had a discussion prior to this, and you indicated that your preference is to take an oath and not an affirmation. So
Yes.
if I could please ask you to raise your right hand and repeat after me. I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, sir. You are now duly sworn in for the duration of the proceedings.
Thank you.
Thank you very much. Just for the 2 gentlemen, you remain sworn in, as Ms. Ibrahim explained. Mr. Modise, do you have the affidavit in front of you?
Yes, sir. I do have, Chair.
You do. Can we just together go to page 25?
I'm there, Chair.
Is that your signature?
Yes, that is my signature.
Thank you very much.
Thank
So
you, sir.
I'm just going to ask you between now and and hopefully 22, not longer than that, or half past, hopefully. Just if you can just give very concise answers so that we can flip through your affidavit. So you joined the Road Accident Fund in 2016 as Senior Manager, Procurement Excellence and Governance. Can you explain what the expectations of your job were? What was your job about? Procurement, Senior Manager, Procurement Excellence and Governance.
Yes. In summary, I was responsible for the contract management at the Road Accident Fund, record management for all the supply chain documents, and the database management.
What is contract management? How does that work?
Contract management is following the procurement of a service provider and entering into a contract. I will be facilitating that process in conjunction with the legal department, with the service provider, and making sure that the valid contract is put in place.
Does that include assessing during the course of the contract whether the contract terms are being adhered to? Who does that?
Indeed, it does, together with the requesting business unit, who we called a contract owner.
Right, thank you. Let's go to paragraph 9 of your affidavit, where you say you reported to the General Manager, SCM, being Supply Chain Management, and ultimately to the CFO. So basically, I just want to be sure of the language there. So you reported to the General Manager, SCM, who then reported to the Chief Financial Officer. Is that what you mean?
Correct.
It doesn't mean you reported directly at some point. Okay. I just want you to explain what the committees that you list there do. Let's start with the Bid Specification Committee, the BSC. What does it do?
Thank you, Chair, and thank you for having me, the honorable members. Let's start with the BSC, which is the Bid Specification Committee. As you will know, before you go out on tender, what you will then have to do in-house is to prepare the specifications for that which you want to procure in public. So the business unit, as the champion or the requester of those services, will then put together the specifications in a draft and in high level to say, this is what I want to procure. And they will then submit that to supply chain management. Supply chain will then look at what they are requesting, look at the budget for those services, and decide if it's going to be an RFQ or it's going to be a public tender. If it's an RFQ, a request for quotation will then be put together with the business unit. You don't need to put a committee together because it's just an RFQ. It's a small transaction, and a supply chain will do that with the requesting business unit, who is the expert in the area. And following that, will then go into the market to send it to the market as an RFQ. If it's a bid, meaning it's above, during that time before I was put at home, it was 500,000, meaning that it was a public tender. You will then have to, as a supply chain, there will be a person who's involved with that bid specification within supply chain, having received a motivation to source from the business unit. And they will then sit together and structure who are the members that they can request to be in the bid specification committee. That committee will then have a cross-functional team from various departments, important ones being one from finance to look at budgetary issues, the other one operations, who will then make sure that the business of the ref is always put in mind when we put the specifications together. And with that cross-functional team, which include all those various people, they'll then look at what we really need from the market, how we're going to evaluate this bid in terms of putting the weight, the evaluation criteria together. Obviously, having checked the market and how it's done, normally what we do in public, you will then engage other public public entities to see if any other entity has ever done that before, so that we can already start using what they've used as a benchmark to put the specifications together. Those specifications are then signed off to go to the PAC, which will then agree with...
Sorry, I just want to make sure that we don't get lost. So the
Yes.
bid specification committee decides what the requirements are. So what are we going to ask? Or
Yes.
going to ask the bidders eventually
Yes,
to provide, but they also do the market testing.
yes.
Okay. Then the bid evaluation committee.
The bid evaluation committee will then use those bid specification committee and the weight or the evaluation criteria that has been put in there to evaluate that proposals after they have been received from the public, to then score the service provider as per their offering and proposals that they've submitted.
So basically, once bidders come, they submit, they drop. I don't know if they still use a box these days.
We still do drop
in a box, and then it's them who do the shortlisting and the evaluation, or is the shortlisting done by somebody else?
The shortlisting is done by the bid evaluation committee.
Also, they do all of that.
Yes.
So they see everything, and then eventually they end up. So they disqualify some
Yes.
at stage one.
Yes.
Then whatever, if there's a next stage, they further evaluate until you've got the ones that go to the final.
Yes.
Right. Okay.
In terms of the criteria, yes.
All right. Tell me about the bid adjudication committee. What do those guys do?
They are the decision makers, but not necessarily decision makers in terms of the DOA. So they adjudicate what the PAC will have given to them as an evaluation report to say, we looked at the specifications, these are the evaluating criteria that were put, these are the bidders that have met those evaluation criteria. We recommend this service provider based on the 90-10 that would have been used for public tender.
So just so I'm not mistaken, so basically the bid adjudication committee is the quality control mechanism. Am I correct? In that the scoring would have been done by the bid evaluation committee.
Yes.
But those guys don't then go and award the tender. It must go to another committee that oversees the work of the bid evaluation committee compared to the specifications initially developed and other criteria to make sure that they've done the right job.
Yes, sir. So the bid adjudication committee is a committee that is put there by the CEO of the company and is chaired by the CFO of the company. So the bid adjudication committee makes recommendation of the award or the cancellation or whatever resolution there is to the CEO to then eventually make. If depending on the value, it might also go up to the board.
Oh, so in other words, the bid adjudication committee may say, guys, none of these guys are good as far as we're concerned, or some such, right? Some, but they've got the power to say you need to start this process from scratch because there is something that some key criteria that's not met or whatever. So are they the committee that's empowered to do that, or they must pick up the recommendation? What happens when they're not happy? Where do their limits end?
I'll say in layman's language is exactly as the word defines adjudication. So they're adjudicating the whole process. So to say the specifications are correct, remember the world have checked the specifications initially. They approved the specifications before we went out. Now they are now checking the evaluation to see that the evaluation went according to the criteria that were put on the specifications, and they will then make recommendations according to the DOA in terms of delegation of authority, in terms of how we then go with that tender.
All right, thank you. Tell me, what happens when the chief executive or the exco, whichever structure is appropriate, is not happy with the process? Let's say they want the process to be redone or whatever the case might be. What is the chain? So we now understand the chain upwards. What is the chain going down? where there is unhappiness, a thing cannot be implemented, something has to be fixed because they're not happy with it as an ultimate authority. That is either CEO, EXCO, or the board. What then happens?
Again, starting with the delegation of authority. The person who's not happy, it must always be in line with the delegation of authority. So if the threshold of that tender is within the CEO's authority, then the CEO will then note what is it that the CEO is not happy with and engage or make comments or remarks back to the BAC. Remember, I indicated that the BAC reports to is a committee that is put there by the acting CEO. In the case of the the executive members, EXCO members were the members of the BAC. So it's people that he engages with. You might find that at the EXCO, they then decided that no, this and that, it's something that they would have discussed. So when it goes back, the owner, let's say that tender is under the COO, for instance, or the chief marketing officer, then the chief marketing officer will obviously engage with the CEO at EXCO level. They'll have a discussion to say maybe this is not what we want or whatever that they decide. And that member will then receive remarks from the CEO and run with it in terms of taking it back or coming to supply chain to say this is what now the new path that we want to take. Can the BAC now reconsider this based on the remarks that have been made, which are supported by the ultimate approver, and then BAC will then interrogate and give response, and then it will then be taken from there.
I just want to be clear then. So once the BAC is done, I mean, just maybe give us a scenario. One, because I'm not sure. So what if the tender needs to be cancelled? What is the process? So in other words, it's gone up the process.
Yes.
Bid specification, bid evaluation, bid adjudication.
Yes.
Right? And or at any other stage, and it now needs to be cancelled. Just describe the process of cancelling.
Okay, thank you, Chair. The process of cancelling is that the business unit, when we initiated this particular tender, the business unit came to supply chain management and said, I have a budget for this work or functions or whatever they want. And supply chain went on tender, invited the market, he put in the bid, the specifications together, put in the bid evaluation together. And at that stage, then the business unit decided that hey, maybe we need to change our track. We no longer need the services. They need to motivate. Why do they no longer need the services? Have there been a change in circumstances, which is one of the allowed reasons that you can put. If there are changes in circumstances, they'll indicate, or if they no longer have funds, they'll indicate, and then they will then come back to supply chain to say, as much as you have helped us up to this far in procuring these services, but we no longer need them. We then look at the reasons as per the National Treasury, which reason will it be falling under, and then it goes to back to the BAC with following the motivation from the business to say we no longer need these services, and then it goes back to the BAC for the BAC to then interrogate in terms of if they agree with business, what is it in place, what have you put, so that we don't cancel and next time, I mean after a month they come and say, oh, we made a mistake, because then we'll have to restart the process.
Oh, in other words, it's possible that a business unit may feel that, no, the thing can be cancelled, but the BAC is expected to ask questions. Are you sure you don't need this service?
Exactly.
If the need still exists, how are you going to address it? What have you got in place, given that we are no longer going to get a service provider for this? What is the option? And then the business unit would then need to explain how they're going to address the need.
Exactly, Chair. As I indicated, the PAC is made up of senior managers in the company, so they know which direction the company need to go. So those are the questions they need to ask, that if you cancel this tender, what are the things that we have in place? Because we're still going to need this kind of services.
All right, thank you very much. So that's a process. It has to go back to the BAC. That's what you're saying.
Correct. And the qualifying thing is as per the threshold of the delegation of authority.
No, I accept that. Thank you very much. Can we then go to, so you say in paragraph 13, there was a new minister, Minister Mbalula, he came to the head office, etc. So that, I'm just indicating that we're moving on. Where SCM was identified as one of 5 priority areas, but I'm assuming that this was a broad statement. The minister did not get into the specific details of what was wrong. He just highlighted that SCM was one of the priority areas.
Correct.
All right, thank you. You then say in paragraph 15, I accordingly initiated a meeting between SCM and the acting CEO. Does this mean you wrote to the acting CEO? Because you said you were reporting to somebody at the time. What does initiated mean?
Following, as per my affidavit, Chair, I indicated there that the minister, the then minister, Mr. Fikile Mbalula, actually had held a media briefing at the Road Accident Fund. So you can imagine if he's in the building, then there's going to be talks about what did the media say. Supply chain is one department that was mentioned in that meeting. We have not had many incidents where the minister comes and mentions supply chain and the fact that there needs to be structural review. So structural review, you'll know when you are in a public space, immediately when you talk about structure, you're talking about positions and all those things. So the team was quite concerned to say, actually, what does it mean? I mean, we just came from, we thought we did well in the previous financial year. So when the minister came with the structural review, specifically mentioning supply chain, we need to engage the CEO to understand. Maybe he would have spoken to the minister to understand what does it mean.
So did you ask your manager? That's what I'm trying to understand. Who communicated with the office of the CEO? Was it you or was it your manager?
I suggested to the minister. I'm
to the minister. Or
to
your
the
manager.
CFO, to the CFO.
To the CFO.
Yes, because my team was on my neck to say. But then, and at that time, I recall the CEO had already met a couple of departments, that legal and all those other departments, but had not met the supply chain team. But we were the only one that were mentioned there. So they were worried that, hey, you need to speak to the CFO and see if we can have that meeting so that the CEO can also have an opportunity to introduce himself and what his views are.
Thank you very much. In paragraph 17, you say, at the meeting, the acting CEO, that's Mr. Litswalo, confirmed that there were problems in SCM and took the team through his expectations. What I want to deal with that, he highlighted the task that must be done within the law, and all units must comply with the PFMA regulations, standard operating procedures, and policies. Can you take us through, what his thoughts? But that seems to be clear that he said everything must follow the regulations as set out in policy and the law.
Correct. Thank you for that, Chair. Indeed, and that's what made us happy in supply chain, because as you will know, supply chain is a highly regulated environment in South Africa. So we wanted to then get from the CEO, introduce the team and engage on things that were also a challenge to us, especially on those bid committees that you were asking earlier about. So when he indicated this, it resonated with exactly what we are meant to do as supply chain, that we're going to then be given our voice in protecting the organization on issues that we need to protect them in as far as procurement regulations are concerned.
All right, thank you very much. In paragraph 20, you say, in respect of these plan changes indicated, we need to do away with the panel of attorneys. We do not need them. We will insource. Just to be said, that's to be sure. So there's a meeting with the minister. You then, because of the pressure from your team, you speak to the CFO to secure the attendance of the chief executive, and then he comes to the meeting, and it is at this meeting where he says that the panel of attorneys needs to be done away with.
Correct.
And then, in respect of the panel of medical experts, the acting CEO stated that they are charging us the RAF excessively for evaluations. This will be changed. We'll bring our own medical tariff, our own pre-authorization. I'm not sure I understand that. The statement about the panel of attorneys is clear. How did you understand that statement? So when he says we'll bring our own medical tariff, what does that mean? And our own pre-authorization? In the context of your procedures, what do you understand that to mean?
Thank you, Chair. Maybe just also to go back to the panel of attorneys, I need to add that we were happy at supply chain, because I think everybody that works for the RAF is not in support of the panel of attorneys, if I might say, largely because of the exorbitant cost that are involved therein. If there was a way that we can vote and say who wants it to be insourced, I'm sure you'll get with many votes from supply chain. Personally, I support the insourcing of it because then it will help to manage the cost thereof. Now, this for me was, when he spoke about it, he was making examples in terms of what changes he needs to bring. On the panel of medical experts, he was also expressing that they charge a lot of money for evaluation reports when they are dealing with claimants. And those are the things that we need to then do away with, so that we can then reduce costs.
All right. No, I get this second part. The only thing I'm asking, so for instance, with the panel of attorneys, he says we will insource the people. With the panel of medical experts, it says we'll bring our own medical tariff. What does it mean? The RAF will then set, basically it will be take it or leave it. This is the RAF rate, you take it or you leave it. Is that what it means?
Yes, I understood it to be put forward the standardized tariffs, because then you'll have the same kind of medical professionals, but then when you then go to do evaluation, they charge different and so forth. So he wanted to then say, that's how I understood it.
No, it kind of makes sense, because also you've got certainty of how much you need to budget in a sense. Yeah.
Correct.
No, thank you so much. I appreciate that. Okay. So the members can read the rest. I just want us to deal with section C. And I'm not going to ask you to go through each chapter and verse. Just narrate the story of what you say in the what happened there. So basically from paragraph 25, I would say up to paragraph 33.
Oh, thank you, Chair. This speaks to the panel of medical experts tender. So here I'm saying that we had incidences at the RAF where we have had a couple of tenders that we have ran, which were not quite successful. You'll understand that with the medical experts, you ideally want all the medical experts in South Africa, because accidents happen everywhere. So we had gone on tender, and you find that at a certain province, let's say for Gauteng, you'll have close to a lot of 100 medical experts saying they're giving you proposals. You go to KZN, you get a good number. You go to all these other provinces, and there is 2, or there is 10, there is 15, and all those things. And it was now becoming an issue, because the panel of attorneys, when they engage medical experts, they want want them to be closer to where the accident happens and so forth. So since the tender was not giving us a good number that is spread around the whole country, where they will then be used, we then sought to engage the National Treasury to say to the National Treasury, we don't seem to be winning with this format that we are using of requesting doctors and professionals to then give us proposals. You'll know doctors are one of those professions that they pride themselves of having gone to school for a long time. So to say to them, give us, fill in this proposal, fill in this document, give us your proposal that you want to be part of, they were not interested. They don't want to fill in a proposal and all those. They just want to say, I'm here, I'm based in this area, and I can give you these services. So we struggled with that. Hence, the decision was that let's engage the National Treasury and request the National Treasury to advise us how do we do it, because in as much as we want proposals from all the service providers, we want them to be available or to be spread across the whole country. So we didn't want to actually limit medical experts, because we want, when there is an accident, there must be quick access to medical experts that are required for whatever injuries that our claimants would have gone through. So National Treasury then advised us to then initiate a request of expression of interest, where we then publish on the public media to say any medical profession that is interested in participating or assisting the ref in whatever profession of medical experts that they are in, they can then log onto this portal. We created the portal where they can log on and put in as the minimum information that we required for regulatory purposes, and also to then sign the service level agreement, which will then they will download from the portal and send back to us for us to then look at and check the validity check if the service provider is on the CSD, which is a central supply database, and when we are okay, the service provider is not blacklisted at the National Treasury, we can then also attest our signature on it and then send it back to the service provider, and we then put that service provider on the VRS vendor rotating system, which was then used by the panel management office to then keep on assigning work to those medical experts.
All right, thank you so much. So basically that's a process that you went through. That with the panel of medical.
With the panel of, I need to add also, when we approached the National Treasury, we also suggested that we use the HPCSA, which is a health, yes, so that we can then use their panel where they have service providers, professionals, medical professionals that are registered with them, so that at least it can also help us with compliance issues to say we got this from a body that is in control of this medical experts, and we're using that database. So we're still negotiating with the HPCSA in using their database.
All right, thank you very much. You then say in... So basically, you then say in your affidavit that we're now at paragraph 26, that it was a large procurement, around over $1 billion, and the contracts, and it's a plural, would exceed 20 million threshold as per delegation of authority and required board approval. The only thing I want to understand here is that they are just a switch off. Yeah, thank you. So what you are saying is that out of all the medical experts, there are some who, for the duration of the contract, the charges would exceed 20 million.
Not.
What does this mean?
Not individual. The budget.
Oh, you mean the budget?
The whole panel of medical experts. That budget on its own, it will be that amount, exceeding that amount.
All right. Can you then, also, when you say it's contracts, you mean taken together, the contracts would exceed 20 million?
Yes,
Right.
transactions of all the panel of
Of all the panels.
Yes.
Okay, then, and this is very important, 27. In November 2018, the SCM department prepared an executive summary for the RAF board, seeking a board resolution to delegate the signing of the resulting medical experts contracts to certain executives, COO, GM medical, GM legal, etc. The aim was to expedite implementation by sharing the authority to sign the service level agreements, right?
Correct.
Why is this step necessary?
As I indicated, we wanted, when the panel of medical experts started responding, there were boxes and boxes of service level agreement that needed to be signed. So after the service provider has put their signatures, we then have to sign as the RAF and give the supplier their copy and keep our copy. So the regions were receiving contracts, sending them to the head office to be signed, and the head office was also directly receiving those contracts to be signed. So there were quite a large amount of SLAs that were being returned.
Okay, so the request therefore was to say, because there is like a huge pile of these contracts that are going to come, could you delegate certain senior people to sign the various contracts, so that it was the purpose to get through the task quickly of signing instead of one individual signing?
Correct, Chair. And this was, as I indicated on 30 there, this has previously been done with the panel of attorneys also, where we then said instead of the one person, because the panel at the Road Accident Fund in terms of the delegation of authority and fall under the board. So the board will delegate to the CEO. So it's a board delegation. So we're requesting the board to say, as the responsible in terms of the threshold of above 20 million, please sign the contract or delegate to an official to sign. But knowing the large volume that were going to be returned by the panel of experts when they were returning, as was evidenced, we wanted to then say the same thing that was done with the panel of medical experts when the board delegated to the legal department to sign. Can the board do the same and delegate the signing of these particular ones to the lower level employees instead of the busyness of the CEO?
Okay, and in this case, the board said no.
The board said no. The acting CEO must sign.
Okay, so in other words, practically, all of those documents, all the boxes, you have to take them to the office of the CEO to initial and sign.
Correct, Chair. There were instances where we had to drive them to the acting CEO so that the CEO can sign them, because the medical experts, some of them were refusing to then take new work because they said, but you have not returned our SLA. So we were trying to fast track and drive them to the CEO to sign, acting CEO to sign, and then they'll be returned back to be loaded on the system.
How long did this take? I just want to be sure. How long did this whole process of trying to get one person to sign all the SLAs? Was it a couple of days, couple of weeks? How long was it?
We are constantly following up with the acting CEO because obviously she was busy at that time. It took a long time. I'm afraid to estimate, but it took. Sometimes contracts will be returned and they'll take 2 weeks before the CEO can have time to sign. And the medical experts were calling to say, when am I receiving my contract?
Okay, that's fine. So then you say in 2020, the acting CFO informed the acting CEO that the COO. Sorry, I'm in paragraph. Sorry, I just need to say this. So, in paragraph 33, you say, absent such a board resolution. In other words, if the board does not authorize all of these executives and managers to sign the SLAs, it means they don't have the authority. So the board has to specifically authorize by delegating authority in this specific instance to certain types of people in the organization or specific people to then sign the SLAs. That right? Am I correct in that understanding?
You are correct, Chair.
Okay, so you are saying until the board, because the board had refused to do what you had done before. So until the board changes its mind and agrees once more, your only option was to send them to the acting CEO, because that's what the board has decided. You're following the board's instruction.
As per the resolution of the board, yes, Chair.
All right, thank you. So then there were these delays. So then in paragraph 35, you say, on 14 February, Valentine's Day, the acting CFO informed the acting CEO that the COO had signed the contracts for medical experts in line with the acting CEO's instruction from the day before. The acting CEO's instruction read. So can you still, so just describe what happened there and then read that email.
Yes, thank you, Chair. So what had happened, there's been discussions outside my information that what I knew was that the medical experts were now knocking on the door to say we need our signed SLAs. They've been lying there for quite some time. So it appeared that since the acting CEO joined the ref in September, he had not signed all the contracts that were now found in his office. So then the acting CEO then said to delegate that signing to the COO. So it is on that basis that then this email was then coming to from the CEO to say actually from the CFO informing the CEO that the COO had signed the contract for medical experts in line with the acting CEO's instruction from the day before, meaning they were already signed. So this is the CEO informing, I mean the acting CFO informing the CEO that they've been signed, and on that email, the email from the CEO instructing that they should be signed by the COO.
Okay. So the instruction to the CFO that kindly finalize and sign the contracts. I hereby give this delegated authority to name withheld, as she is familiar with this contract. Ensure that this contract and SLAs are in line with the new direction, ethics provisions and all. This should be finalized by end of business tomorrow. And then somebody else is named and will ask you those names. I kindly ensure that the medical experts are loaded soonest, all of them to be in the database by Wednesday next week, 19 February 2020. Kindly ensure that they are all on the National Treasury database and that all SCM prescripts are adhered to. So in other words, the chief executive is then delegating the authority that had been conferred on him by the board to the COO.
Correct, Chair.
Okay, that's fine. So can you just explain what you mean in paragraph 36 there?
As indicated, sorry, Chair, as indicated, this was a panel contract worth millions of rands, which was falling under the delegation of the board. So what I'm saying there is that this contract being a multi-million contract and extremely so high, instructing instructing another official to sign that which was delegated to you was going to then be a problem until we then go back to ask for a new delegation.
Okay, so I just want to get the substance because we need to move on. So what you are saying in substance, and tell me if I'm wrong, because we can't go through line by line. Only the board can specify the delegations for a contract of this size, right?
Correct.
So once the CEO gets the delegation or any official from the board, they can't take on the powers of the board and further delegate.
Correct.
The request needs to go back up to the board, explain the problem, and then the board says, okay, big problem, fine, we change our mind, more people can sign these contracts. Is that what you are saying?
That's what I'm saying, Chair, because then we have done this in November, asking the board to delegate. The board said, no, we delegate it to the acting CEO. According to me, the acting CEO is a position, not the person. So if the board said we delegate this to the office of the acting CEO, it must stay in the office of the acting CEO. Until the board then resigned their resolution.
No, thank you very much. So in other words, the fact that the COO had been the acting CEO at some point doesn't mean they took that old delegation with them into their new role, and therefore they can keep signing as if they are the CEO there. That's not allowed.
That is not allowed, Chair.
Okay, thank you very much. Shall we? The members can see the rest of the exchange there and the objection that you raised and so on. We will get to the questions by the members. Can we talk about the panel of attorneys tender and just describe the situation, what happened, and so on. Just give us a brief history of that issue to the point where the decision was taken to then cancel. You don't need to go through chapter and verse. The members can see it. Just explain to us where the old tender was, what decisions were taken, what processes took place, and at the time of the intervention, where were you in the process?
Thank you, Chair. I hope I'll do justice because the honorable members will bear with me. I've been out of office for quite a long time, so my recollection might not be that sharp. But what I recall was that when the CEO then came, after having made verbal sentiments that we need to do away with the panel of attorneys, according to me, even in that meeting of the 13th of December, he was talking about doing away with the panel of attorneys at a stage where we are ready to do so. Because then we needed to be prepared or have a better alternative to say, if we do away with the panel of attorneys, what would we have? But maybe that's not my area. But my area was that there is a tender that is currently running, which had started in 2018. And this tender was now at the adjudication stages. Had the CEO joined, had we been clear in terms of a certain criteria on the tender at that time, you would have found that the CEO, by the time he joined in September, we would have appointed the panel of attorneys. So it was delayed because on the tender, there was a specific criteria which was put there, which said that as a panel of attorney, when you have a law firm, that law firm must have a lead attorney at that office, meaning that if you have 5 offices within this province, you must have 5 lead attorneys. So that was the confusing part for the PAC, because as it's put there on the specifications, but you have majority of the panelists that are proposing or sending their proposals, but they say, okay, I have 1 lead attorney who's responsible for 3 offices, and the other one who's responsible for those 3 offices. But then that will then conflict with the specific criteria, which was saying a law firm office must have 1 lead attorney. So the PAC then said, well, if we are not sure on this, and maybe we can then see how we get about it, but before we make a decision, let's get a legal opinion so that we then guard ourselves if we are not going to be challenged. Because as you'll imagine, since this is a public tender, you might have some firm coming and say, no, but then I also had 1 lead attorney, but you said you wanted lead attorney in all the offices, so I then disqualified myself. But then I see that you are appointing the ones that actually have 1 lead attorney for 3 offices and the other one and so forth. So that was a legal advice that we wanted.
No, thank you very much. I just want to simplify this, hopefully, for myself. So there are law firms that have got offices in various provinces, for example.
Correct.
Right?
Correct.
So what you are saying is that those law firms would then have a lead attorney in their proposal. Others thought that even if you have 5 different offices in different places, you need to have one lead attorney for the whole contract.
Correct.
That was the confusion. That's what the bid adjudication committee asked about, and that's what needed to be clarified. Okay, all right, please carry on.
So with that being the case, then we waited. Hence, I said earlier on, if that criteria did not create that kind of a bottleneck, by September 2019, this tender would have been awarded before the CEO joined in September. So we are now stuck with the PAC. The PAC is still waiting for this legal advice. We've engaged the legal department to fast track that legal advice from an external service provider. The external service provider is still delaying. They want clarity on this, clarity on that. They are engaging with the legal department. At that time, when now I'm the acting general manager, SCM, faced with the issue that the PAC is ceased with adjudication, this particular tender, and now this tender is going to expire on the 20th of February. So if I let it expire, then it means the whole tender process is going to abruptly fall apart. So my issue was that we had already started this contract in 2018. It has taken quite a lot of money and time to be evaluated. We had the bid evaluation committee members going all the offices nationwide, checking the service, the legal firms' offices, if they had a printer. I remember we had those kind of requirements on that they must have a printer, they must have proper offices. There was an incident in the past, just on by the way, where a legal firm was on the panel, but they had an office at the back room. So you can imagine we wanted to then make sure that we appoint, when they propose and they say they have an office at this area, we need to go to that area, verify this is the address, this is the place, this is the printing machine, working telephone, and so forth. So we had the bid evaluation committee members spending accommodation money, flying all over the country to then verify these service providers. Now, with that amount having been expended, we then wanted to make sure before the final leg of award, we are now covered when we then go, yes.
All right, thank you very much. So for the sake of time, so then there is an instruction in fact, let me start here. So what would have happened if the old contract comes to an end, the new one is still not ready? What happens in that gap? What is supposed to happen?
I almost said you will have noticed. This tender started in 2018, meaning that it had been extended a couple of times before. So we will have extended the current one so that we finish the evaluation. The PAC will then say, we are happy, we are ready to go, and then we then appoint and wait for this one to end, to expire, and the new one can then take on.
Okay, that's fine. So then, can you then tell us about the circumstances under which you came to do a further extension, and can you explain what your authority is in that situation? So, in other words, there is now this conversation about not having a panel of attorneys at all. The tender has expired, it's been extended a few times, right?
Correct.
Can you just tell us what happens in that gap and how you come to be extending the the existing tender for one more time.
Can you rephrase that, Chair?
So I'm saying that, in fact, let me go to the specific paragraphs.
Yes.
Okay. So in paragraph 55, so, and perhaps you're correct in saying I must just read it. The validity period of a tender invitation refers to the period in which the proposal bid quotations remain valid. During this validity period, the evaluation and adjudication process must be concluded. If not concluded, the bid validity must be extended. That's what I'm referring to. It's the validity. It's not the contracts themselves. It's the validity of the tender itself, because it remains open. You've been going through this process.
Yes.
Yes. So if you don't finalize the process, it's then going to expire, which means you must start everything from scratch, with all the trouble of still going around and evaluating offices,
exactly.
Right?
So validity then meant that we need to then say to the service providers, you've given us a proposal. Can you keep that proposal as it is, so that suppliers don't come later and say, no, but by the time I gave you a proposal, I was charging this bottle of water 50 cents. Now it has increased to 56. We are saying to them, no, you quoted us for 50 cents. Keep it that amount that way until we finalize our adjudication process. That's what extending the validity means.
All right. Thank you. So you've explained that so he says in paragraph 56, if you can go there, you've explained the first part. The second part you've also explained. So paragraph 57, as the acting GM, SCM at the time, I was overseeing these tender administrative processes which fall within the responsibility of the senior manager, service delivery expert excellence, who manages the tender processes, including extending the validity of a bid. All I just want to say there, I want to ask there, is that, so in other words, even if a tender is this big, right? Because I'm assuming this is a large tender in its totality, right? Extending the bid validity period doesn't need to go up to the board, or who has the authority to extend given where the process is? I just want to be clear there.
Yes, in terms of the RAF standard operating procedure, the general manager, SCM, can extend the validity of a tender.
All right. Can you then just explain in paragraph 60? So I'm, then that validity period was extended. So he said, notwithstanding that, the acting CEO had expressed himself verbally on his intention to do away with the panel of attorneys at the meeting with the SCM. So in other words, you knew from the first time that you were telling us earlier that the acting CEO wanted to do away with the panel of attorneys, right?
Correct.
Did you get any instruction that you must not proceed with the tender formally?
No, Chair, we didn't. And as I indicated, I think the minutes are also attached. The CEO made, it was a general speak. It was not an instruction. It was saying, for instance, I quote, for instance, I might not be quite verbatim in quoting him, but then he was saying, for instance, the panel of attorneys are charging R4 per page for photocopy. We need to control, in-source and do away with a panel of attorneys. To me, there were currently panel of attorneys that was running. So there were two issues. So you want to do away with them? Sure, we agree with you. They are charging us a lot. We must do away with them. My thinking is that there will then be investigation or plan in place to say, okay, what is the alternative? And we will be part of it in terms of the stakeholders in the entity to say, since we are going to do away with this panel, how are we going to then get these services that are being provided for by the panel of attorneys? So that was my understanding. So him saying we need to do away was not an instruction, was that this is my expectation. Like I indicated when I called this, when I initiated this meeting, those are the things that I wanted to understand or to get from the acting CEO. What is your expectation? What is it that you want to take the ref, more especially from supply chain point of view as a support service? What is it that we can support the acting CEO with in getting to that which he needs to get to? So for me, it was that these are the things that I'm planning to do. So at that time, we had not received any formal communication from supply chain to say that the board has resolved to do away with the panel of attorneys. As I indicated earlier, it's a panel, it falls within the purview of the board. So the board had to then put a resolution together to say we are no longer needing these particular services. That will then be drilled down to the COO, or the CEO who will communicate to the COO. The COO, as the person who came and initiated the tender process, will then say, hey, supply chain, I came to you and I said I wanted this tender. I no longer need it because of this and that and that. And then we'll then prepare a submission that will go back to the PAC to say to the PAC, the business unit that requested these services has indicated that they want to cancel because they have an alternative, and the PAC will then process that request, and then will then cancel the tender.
All right, thank you very much. I just want to deal with two aspects. So you say in your affidavit that as a result of this extension of the validity period, you were then put on suspension.
Correct, Chair. So what I was saying there was that despite the fact that there had not been a formal communication from the requesting business unit, who is the chief operating officer, the owner of the tender, who requested supply chain to say go on tender, that person has not said anything to us or sent anything to us. We don't have a resolution from the board or a resolution from that the COO to say I no longer need this tender. So now we are faced with the situation that this tender, if we don't extend it, and maybe the CEO then changes his mind, we would have been found wanting. As a fact, Chairperson, I need to highlight that there was an instance at the REF before I joined, and ironically, it was also dealing with panel of attorneys, and the member of the supply chain who failed to extend the validity period, and it expired when the PAC was ready to appoint. That member was disciplined and sanctioned for that failure, because that failure is regarded as fruitless and wasteful expenditure. So we wanted to then make sure that, and also there is nothing wrong with with extending the validity of a tender, Chair, because you can still extend the validity today, tomorrow cancel it, because it's a non-committal letter. It just says to the service provider, you gave us a proposal, keep it valid as it is without changing it, we'll come back to you. So you can still come back tomorrow and say, okay, I'm coming back now, we no longer need the services. So that's in a nutshell.
All right, thank you. Last couple of questions. Was the tender eventually cancelled?
The tender was eventually cancelled, Chair, on the 28th of February. Actually, the letter was sent to the business unit on the 26th. With the letter was not actually specifically indicating to the service provider why the tender is being cancelled. So it had to be redone and be sent again on the 28th of February to informally inform the service provider in terms of the reasons why we were now cancelling it.
Okay, I'm assuming that you know of the extent of the legal representation requirements. Do you have an idea how many lawyers across the country, in terms of the old panel of attorneys, were representing the RAF roughly in litigation matters? It really doesn't have to be an exact number. This is why I'm asking, so that you know. We asked last week how many state attorneys are representing the RAF right now. We were given a number of 64, right? What I want to know is whether that number is comparable to what the number had been prior to the panel. Sorry, switch on the mic.
Sorry, Chair. I know it was something over 100 service providers, if I'm not...
Service providers?
Yeah, panel.
No, I mean, do you know the lawyers, the number of lawyers that were...
On the panel?
No, I mean the warm bodies. So a law firm would have a number of lawyers inside. Do you know?
I don't know that.
All right,
we're appointing a whole firm.
A whole firm.
How many people they sent there? I wouldn't know.
Okay, no, we will deal with that later on. So, what is your status now? How did your disciplinary conclude?
Oh, Chair. My status is that on the 9th of September last year, I was then given a notice of intent to retrench, actually a retrenchment letter.
So, sorry, before we get there, so
yes.
Were you on suspension until September last year?
Yes, Chair. I've been on suspension from the 2nd of March 2020. And they couldn't find anything. This is what I'm informed. The reason I'm saying that is because as the GM, having signed that letter, which is what I was suspended for, the person who prepared the letter, my colleague who prepared the letter was suspended with me, and he was reinstated in August the same year. And the reasons were that they couldn't find anything wrongful that he has done. But with myself, the suspension went ahead. During the same year, I then got charged for fleet data management, which case then ended up going to CCMA for 2 years. And I was charged with the former acting CFO. And we went to CCMA for 2 years, and the award was given in our favor on the simple basis that when the contract was awarded in 2013, I was not employed at the REF. I joined the REF in 2016. So that charge fell apart on that basis.
Okay, thank you. Can you tell us about the retrenchment?
After the CCMA award, we got a letter, myself and the former acting CFO, to say the REF was intending to review. So the status quo will remain. So I need to add also, when I was at the CCMA with the the former acting CFO, I remember one of the first day, my lawyers argued to say, okay, this is an unrelated matter for which I'm suspended for. So what then remains? What then is the status? Because I remain suspended on the basis of having signed the validity extension letter. No charge has been brought to me up to this stage. Now I'm charged for a contract of fleet data, which was then predating me because I joined in 2016. But then do I remain on suspension because the acting CFO was not suspended during that time? The company, through their lawyers, indicated that no, I must remain on suspension while attending to the CCMA. The CCMA came, we won the case. CCMA found us that we could not have been involved in that contract because it predated our employment at the RAF. And when we inquired then for returning, the RAF said no, they are doing a review. They're going to review that CCMA matter. And we waited for the review. It was not coming until then I got a letter saying I need to give the RAF reasons why they must not retrench me because I've been suspended at home, earning a salary without working. I responded to say, but then you are the one that have put me at home and you have been fighting my reinstatement. So, and in any case, I've not been consulted on retrenchment. I don't even know if there is retrenchment happening at the RAF. Nonetheless, they gave me 24 hours to respond, which is contrary to the disciplinary policy, which allows for 3 days. I then responded within 24 hours and immediately, because I've heard of similar cases that were taking place, that the ref was actually busy retrenching people. So I instructed my lawyers to then say, can you also, as we are responding to them, go to court, interdict them from doing this which I think they're going to do. So as we are busy and their lawyers file papers to the labor court, while we are busy arguing this matter at labor court, the ref went ahead to retrench me on the 9th of September. So the case ended on, I don't know what caused the delay from the labor court, because we only got a judgment on the 3rd of December. And then when we got the judgment, the ref had already retrenched me on the 9th of September. So we then said, okay, let's see, we have a judgment.
What did the judgment say?
The judgment said the ref needed to afford me the requirement of consultation as per the Labor Relations Act, needed to follow the process of consultation, so to say. And they have not done that.
So you are now, so they haven't consulted you. So they haven't consulted you. Were you reinstated?
I was never reinstated. We waited for, after the judgment, the ref did not appeal the judgment. And on the date of the expiry of the appeal period, seeing that they are not appealing, I then went to work to report for duty. And I was informed, they told me that they'll revert back to me. From the ER office, said, no, go and sit at home, we'll come back to you. And they then never came back to me. My lawyer wrote to them. Actually, they came back to me, my lawyer wrote to them, and they responded to the lawyer and said they are receiving instruction from the ref. Those are the lawyers of the ref. They're receiving instruction. After a few days, they responded to say, we have received instruction. By the time the judgment was made on the 3rd of December, you had already been retrenched. So we refer you to the CCMA.
So your matter is with the CCMA now?
No. Because we have a judgment from the labor court which says the ref needs to follow proper process of retrenchment, meaning the retrenchment is illegal. Then when we with that judgment, we go to a ref and say, this is the judgment, you need to reinstate.
No, I get that. So yes. I'm just wanting to know, what's your status now, now?
Oh yes, we took the ref on contempt of that judgment of the 3rd of December, which is going to be on the 29th of this month. The appeal, we have been given that date.
All right, thank you very much. I think that's my that was my last question. Okay, so that's fine. Let's just give you a chance to drink some water. I'm going to start on this side with the members. So can we just give Mr. Modise time to
no, I can listen and drink
to drink some water and so on. So members, it's the same arrangement as last time. It's 10 minutes per member for an exchange. I will not interrupt unless, if I do, I will stop the clock so that I don't eat into your time with my own talking and then continue. Honorable Mente, over to you.
Thank you very much, Chair. Good afternoon, my brother.
Good afternoon, my former chair. Sorry, my honorable member.
Yes. No, we can understand, especially from the leading, we'll say our leading advocate in the team, getting to take us through your affidavit. For me, there's two things that are clear. Is that one, seated here, similarly to your colleagues, there is a clear unfair labor practice That goes without saying. But unfortunately, our platform is not for that. We can deal with it. And we hear how far you have gone in terms of fighting that. And we hope at some point you will have to deal with it and win it. But here is a second thing and second observation I'm making from the entire affidavit. And it's very clear. Also with the statement you made earlier on that when the acting CEO at the time was appointed, he came, he addressed you, he gave you his wishes. Now, here is my problem in your affidavit, in that is how did you reconcile his wishes to the work you have to do? Because remember, here comes a leader now of the institution. And as a leader of the institution, he comes and say, with the normal practice, we're going to have to change certain things. And these certain things, they are going to have to work for the benefit of the people so that we are able to save cost and all of those things. That's fine. Did you then have a session to reconcile the wishes with the environment? As you say, on his arrival, there was this contract which was on the process of being adjudicated with specifics already signed and issued, if I heard you correctly. How did you reconcile his wishes and the current environment?
Honorable Chair, through you, sorry. I took what the CEO indicated to us as a person that is going to help us at the supply chain department. As I indicated earlier on, supply chain is highly regulated. So I took his advice as a person that is going to understand our plight in terms of where we are not getting joy from the business, where they are not seeing supply chain as a person that must assist the business unit. There is one thing that he indicated in his minutes, that supply chain must be a gatekeeper and supply chain must make sure that the RAF is secured. So my role being that of a compliance, a regulatory and all those things. I then took it upon myself that I'm going to support the CEO where there are things that might be happening that he's not aware of. Hence, if you look at my affidavit on the instance of signing of panel medical experts, I took that as my position to then say maybe the executive are not aware that there is actually a motivation or resolution that the board has already made where the CEO is delegating to somebody. I then took it upon myself to raise to the CEO that perhaps this happened before you came, but then this delegation, what you are now delegating, has already been declined by the board. So let me defend my CEO so that I put that to the fore to say, but the CEO, before we do this, let's do this first so that the whole process will be aligned. You won't have to answer questions of compliance and audit at some stage. So to that extent, I was assisting him in doing my work to then advise him to say, let's do things this way so that we are not found wanting at the end. So that was in line with the meeting that he has had of complying with the prescripts and the law and so forth.
Yeah, no, I understand that you have explained it clearly, that what was your role in trying in driving governance in the institution. My question is more in line with, you are here in these prevailing conditions of an ongoing contract that must go out. However, everyone else feels uba irongo le contract because it's too much expensive. As compared to if it was insourced, it would have worked much better and it would have given more people opportunity to participate than paying one person exorbitant amounts. And here he comes, he says exactly that, he addresses exactly that grievance you all had, but quietly because we didn't know where to address it to. Now, my question is on, these things are happening, you have to sign these things, you have to give direction. Or let me put it differently, did you have a one-on-one with him to say, you came, you tell us 1, 2, 3, 4, 5. But there's these things that are contrary, they may be contrary in terms of governance to your wishes. How do we address the two?
Honorable member, my apologies, honorable member. You have to know the CEO and be in the office and understand how unapproachable he is. We used to run to his office. I have my former acting CFO who will come before this committee. He's an old man. He's my boss, who I care about a lot. We used to run to the CEO, and you get there to advise him, it's only him talking. You can't get through him. You'll go to him and say, this is what I think we should do, and he'll tell you that you are not legal. Call legal person here. Call compliance here. You started in the office, the two of you end up being 10. Him talking, telling you how things must be done. It was difficult, honorable member. He was not approachable at all, I'm sorry to say. What you guys see in public is not what actually he is. And I even went to an extent of DMing a honorable member at some stage to then say, this is what the staff is going through. So I was very happy to come here, Chair, because I believe that
Okay, Mr. Modise, please take your time. Can we get Mr. Modise some water? Please take your time. So, all I meant, I'll stop the clock. Yeah. Yeah. Can we take a break for 5 minutes, colleagues? Okay, let's continue. Honorable Mente, I'll grant you 5 minutes. It wasn't 5 minutes left, it was less. So I am allocating, I'm making an allowance. So yes, I don't know if, Mr. Modise had sufficiently answered you or you want to move on to a next question, or you still on that question? Or were you finished, Mr. Modise? Maybe that's the question I should ask.
And I need to apologize to
No, please,
my
please.
apologies.
No, please.
I was cheery because my honourable Mente, the question that he asked brought a lot of memories. We've had colleagues of ours that have been admitted to Vista on depression, and we lost about 3 or 2 colleagues that were also on suspension. And even after winning cases, they were never allowed to go back. We have colleagues that have had their marriages breaking down due to all these issues. So we are talking about the serious mental. I do acknowledge, Chair and Honourable Member, that you said SCOPA is not dealing with labour issues. I acknowledge that, but the opportunity that you have given us is us to just put the picture there, which is truthful and honest, and to help the public, because I believe that as much as the employees are suffering, claimants are even suffering more than us because of the breaking down of systems that should be there to help them at the RAF, which is really, really regrettable.
Thank you very much. Honourable Mente, I'll let you continue.
No, thank you. Because I have less minutes left, I would not ask, maybe when you are answering the next question, you can then add in terms of the contribution of the line managers, because there are people in between you and the CEO that would have rescued the situation or that. But let me add another question. In paragraph 80, you're speaking in paragraph 80 of your affidavit. You are speaking of transparency, and then paragraph 88, you are speaking of stakeholder consultation when you are cancelling a tender or anything. I would like you to just briefly talk to these 2 paragraphs. 80. Yeah, 80. Just talk to these 2 paragraphs in relation to the panel of attorney, and how were they going to rescue a situation where the ultimate goal was that once the term of office that they had at the time ends, we no longer have a relationship, we're starting a new. So these 2 paragraphs, how are they related to that situation?
Thank you, Honourable Mente. Paragraph 80 seems to inform the fact that even the cancellation of the tender has to be done in terms of the Constitution 217, which then calls on public states to conduct themselves or to have a procurement system. If you are involved in supply chain or procurement, you must have a system that is fair, equitable, transparent, competitive, and cost-effective. So this is to say, even the cancellation needs to confine itself with those principles of the Constitution. We need to be open to then say, this is what we are planning to do as a public entity. We no longer need these services. We having a plan of this. For instance, the engaging of the state attorney was well welcomed. I was supporting it personally. Like I said initially, I'm in support of insourcing, because this is where you create jobs and you create security for people. It's something that we need to do. But then what you must not do is to do it in a way that you are now going to let down the same very people that are depending on you, who are the claimants, because those are the ones that are going to suffer if proper controls are not in place. So that's what, for me, I wanted to indicate. Let's do a phase-out approach. I think somewhere on a lighter note, as I was engaging on this to say, and then I watched General Mukwanazi, and then I thought this has some similarity with the PKTT, because in a way that you are wanting to terminate something urgently now, but what is the plan in place? Because at the end of the day, everything that we do and touch at the Road Accident Fund must have the mandate of the Road Accident Fund in mind. How are the claimants going to be assisted by that which I want to do? I want to save money, but saving money must not even cost more, which it has been now, because it's something that should have been phased out properly. Let's cancel this tender. Let's extend the SLA. Let's then say the new tender, let's run it for at least 2 years to give us time to investigate, put proper processes, capacitate, and all those things. Because now...
Honorable members, you are audible, please.
My apologies.
Sorry, no, please. I'm sorry, please.
Yes. So on paragraph 8, that's merely what I was trying to indicate, to say you cannot then say, let's quietly not extend this contract. Let it just die, which is what seemed to have been the intention. Because had I not extended the validity, it was just going to abruptly die. So let's cancel it properly, to take the people into confidence, to say we no longer need it, we're putting this in place. But even when we do that, what is the plan? Let everybody be involved, because we will be in support of that decision. But then let's do it together. All department must be involved, legal must be involved, so that they are part of saying how many, the chair was asking, how many lawyers were at the firm, at the court when matters were attended to. We need to put all those things in line so that we know that when we cancel this one, already this one will then take over, having learned what the panel was actually doing. So that's how I would have preferred to do it in a phase-out approach, which will then not devastate the operations which were already working, because at that time claimants were not being compromised. Now, when you cancel it, claimants are now compromised. You have cost that the same person that you wanted to introduce a system that will benefit them. I'm not sure if I covered your question on 88. While cost saving is a valid pursuit, I've said that before. I'm in support 100%. You can ask me in my sleep. Insourcing is the way to go, because you then have services that are spread nationally, because when government does it, then everybody gets the benefit. I'm in support of insourcing, but it must be done in a way that it won't compromise the mandate of the Road Accident Fund and let the claimants down.
Last one, Honorable Member.
Yeah. Now, the last one, maybe I'll come back on 88 when we do follow-ups. On your most crucial concern out of everything here was the delegation of authority on signing of SLAs.
Yes.
After that delegation was done and all of that, you had the to and from with the CEO and you ultimately gave in, it happened and whatnot. Was there a finding in governance in terms of running the institution and the AG and even internal audit? Was there a finding on those SLAs that they were signed wrongly?
I might get into trouble, but you'll know how audit works. They take a sample and they work with that sample. So if that sample doesn't include certain parts, then it's a problem. I've always mentioned this to my former acting CFO to say, but then as much as there is a sample that you take when you audit, the larger contracts must not have a sample. It must be a given that this big contract, I'm going to audit it, instead of taking a sample. So you might find, I don't know for sure, you might find that the fact that it was not picked up in terms of not having followed the DOA was the fact that it was a sample, therefore it was not part of the things that the audit then focused on auditing.
Your final answer is no, there was no finding.
My final question is that I was not there at that time. There might have been a finding, or there might have been an answer to avoid the finding. I was already at home suspended.
Thank you very much. Thanks very much, Honorable Mhlanga.
Thank you, Chair. I'm going to ask just 2 questions, and then I'll come back later with others. Greetings, Mr. Modise.
Greetings, Honorable Member.
Thank you. I want to first understand, because I think the Chair would have alluded that our interest also borders around systems issues, so that we understand what is happening and what can be done to ensure that it doesn't happen in future. In your understanding, under what circumstances does the board delegate the powers to the departments? I think the affidavit speaks about that contracts over 20 million may be delegated. And I see that in your reference, for an example, there was a panel of attorneys contract that was delegated to be signed by the legal department. So the question is, under what circumstances, but coupled with that, what levels of authority below the board can it go to delegate? So, for example, you have a board, you have a CEO. So the board, in this instance of the legal attorneys contract, delegated the legal department, not even the acting CEO. So what are the guidelines around this delegation of authority? And under what circumstances? Is it a subjective matter of the board, or is it, is there a guiding principle to it, as far as you know, as a former employee and a senior employee in the department? Thank you. That's the first question.
Thank you, Honorable Member. Delegation is something that is discussed by the authority that has the power. It's discussed in a sense that we then say, okay, let's say, for instance, as the chairperson of the board, these contracts have to be signed by the board. How are we going to do it without disrupting operations? So maybe let's delegate it to the CEO. So there can be a number of circumstances. It will be a discussion. But then nothing stops the board from delegating. If it doesn't mean that the board, because it's their delegation power, they cannot delegate to a senior manager jumping the executive. It's based on operational. What will be the best suit that will not disrupt operations? So there's no discretion. As long as the person that has the power says, I'm comfortable with this particular official handling this thing, if that individual does it wrong, the delegator will know that, okay, it's my fault. I delegated to the wrong person. So it's based on a number of considerations, Honorable Member.
All right. Thank you. Thank you for that response. I will formulate our own opinion on it. I think there should be a guiding framework. The board cannot have an endless discretion on who and circumstances. So it can delegate an officer to approve a tender or to sign a contract for 20 million if it wishes to, or delegate a CEO. There needs to be a clarity on the framework. But I've accepted your answer as you've given it. It's not your responsibility.
Yeah, but the DOA will then also assist. Maybe if you can get the DOA, I'm sure it will have a quick guidance on that.
All right, thank you.
Sorry, I've stopped the clock.
Oh.
No, in our bundle of documents, there is both SCM policy and delegation of authority policy. So there actually is a frame, but I will ask the team to just lift it again. It's in the memory stick, but to just lift it and just distribute it on email. But that framework does exist.
Right, no problem. I will also look into it. The second question, and then I'll ask the others later. I just need to confirm the timelines of your suspension. I'm on paragraph 83, read with 85. So it was 2 March 2020 when you were suspended, and then you were then retrenched on the 9th of September 2024, and then you say on paragraph 109, but in the second page, your suspension with full pay was 5 years and 4 months, and it doesn't correlate in terms of the date. I just need the accuracy of details. If you count 2020 March to September 2024 is about 4 years something. 2020 March, you can count together, 2021, 22, 23, 24. It's 4 years, and from March going to about 4 years, 9 months or something. And here on 109, you're saying you were suspended for 5 years and 4 months. I just need the correlation and the accuracy of the detail on those dates, and which one is inaccurate. Thank you.
My apologies for that, honourable member. Let's work on the dates. Maybe, yes, my mind was, yes.
Okay,
yes.
No, for now I'm fine, thank you.
Thank you.
All right, thank you very much. Honorable Isaac, it's your turn. Just to be certain, you've got 10 minutes for an exchange with a witness, uninterrupted by me. Most of the time.
That's all good, Chair. Chair, actually, I'm going to be very, very brief. I am going to pass on most of my minutes to my colleague Atkinson. But Mr. Modise, yeah, great. Thank you so much for your submission.
Thank you, sir.
And via you, Chairperson. I just wanted to check with you because I was covered to a certain extent also by my colleague, Honourable Mende. But I'd like you, just to go to page 20 through you, Chair, of your submission. And having listened to what you have now explained in the last 30, 40 minutes, if you could just read that paragraph right on the top through you, Chair, on page 20, what is it, number 89? Just read it out to us.
Thank you. I will do that.
Thank you.
In fact, the abrupt cancellation led to significant operational disruption. Panel law firms were instructed to hand over thousands of active claim files on short notice, and many claims had to be settled directly with claimants' attorneys in bulk.
Thank you. Okay, so at this state, the impression is created that there seemed to be a pretty chaotic scenario at RAF in terms of the payments, etc., right? Was the board at any point in time, at this point, consulted, spoken to, aware of anything in your opinion?
I don't know, honourable member. I was a junior to executives. I wouldn't know what the board had discussed.
Okay, but surely there were huge discussions transpiring within the offices and in the corridors and amongst other colleagues. But okay, I accept that you were junior and that obviously you had no access to the board.
Right.
Chairperson, I'm going to stop there and I'll allow my colleague Patrick Atkinson to take over from here, and I'll come back hopefully if there's an opportunity. Thanks.
Thank you very much. Honourable Atkinson.
Thanks very much, Chair. And yeah, thank you very much, Mr. Modise, for your evidence. I think one of the really sad things that's come out of this is it's, in a sense, has been a major failure of governance right across the government. that this nightmare should have continued for so long for so many people, because obviously, as you say, so many claimants have been denied their right to proper treatment, to payment of services and all that sort of thing. We saw that on the program on Sunday night on TV as to how badly some people are suffering, and particularly people such as yourselves who should not be going through the nightmare that was visited upon you and many other members of the Road Accident Fund as well. It's the more we hear about it, the more we realise what a complete disgrace it's been, and what you've been through. So yeah, we really are very sorry for what's happened, basically.
Thank you.
Yeah. So the one question I wanted to ask you was, in a previous iteration of the Road Accident Fund, the idea was that these things should actually never really come to legal action, was that they were actually negotiated before they got to court. I think we're talking about 20 years ago, that it was seen as a little bit of a failure, in fact, if something ended up in court. So there was, I suppose, in a sense, a settlement hub that would actually be out there to negotiate with the lawyers and get a settlement before these things ever went to court. So when you talk about insourcing, is that the kind of thing that you would envisage, that you would have legally qualified individuals who would represent the Road Accident Fund and would try and avoid legal expenses, and obviously have I suppose, a list of what people would be paid out for certain events, injuries, how bad the injuries were, and various other things. So I think, when we're talking about insourcing, what we want to try and do is we actually want to avoid court actions. We most certainly want to avoid default judgments as well. But anyway, that was just my initial question is this, is when you talk about insourcing, is that what is envisaged? Is a settlement hub that would actually not only be trying to fight cases, but actually trying to stop cases from going to court in the first place?
Thank you, Honourable Member. That's exactly my understanding. Insource means we're going to capacitate internal resources within the RAF, and which will then help us in engaging the claimants directly, and try to see if we can help them or agree on whatever that the ref needs to pay before we go to court, because it seems to be what then become a big issue with the limited resources that the ref is currently having. So that is my understanding of insourcing. Yes.
Thanks very much for that. In your affidavit, you mentioned the fact that the acting CEO, as he was then, said that he had another plan in mind for when it came to the panel of attorneys. Did he ever discuss that plan with you or with anyone around you?
He had a number of discussions. The fact that he was engaging the state attorneys, the fact that we can use another entity's legal expertise to then do what the panel was doing. So at high level, that's how I understood it to be saying. Actually, when I was there were instances where he will take some of the members in the legal department to go and meet with a certain entity so that they can then see how they're going to then sort of create an alternative. But I was not at that level to know what the outcome would have been.
Were you aware of any situation where, when the default judgments started to come in through thick and fast? Because we know that over the last 2 or 3 years, I think it's been over 5 billion rand in default judgments that have been brought against the Road Accident Fund. Whether it was becoming clear to people in charge that the route that they'd chosen about getting rid of the panel of attorneys had become very expensive for the fund. Was there any realization that it was actually costing a lot more than the decision to get rid of the panel of attorneys?
I wouldn't know about the default judgment. I'm a supply chain expert, but then having read the news, I could pick up that okay, this would have obviously started from the cancellation of the panel of attorneys, because then who will then represent the RAF if there are no capacity of people that will do that function?
Thanks very much for that. And I see in your affidavit you mentioned the fact that you were suspended for a period of 60 days initially in 2020, I think it was. And then what happened between that and your suspension or your attempted retrenchment 4.5 years later? Did they continue to pay you? Did they have much to talk to you about? Or were you effectively just sitting at home waiting for communication from the Road Accident Fund?
I was lucky at hindsight, because when I was suspended, God decided I'm not going to be the only one sitting at home, because COVID hit us. So we are all sitting at home. So I was like, look at God. So during that time, I have been consulted by the FID, Forensic Investigating Unit, which is capacitated with police officers that do investigations on behalf of the RAF, which they called me and requested me to deposit an affidavit, which I did. And I never had anything from them. And the month passed, and I was still waiting to be called because then my colleague had gone back, the one that was suspended with me. I thought, okay, anytime now. But then as I'm waiting, I was then called by a private company. I think it's a OMA. I'm not sure. It's OMA. It must... maybe it's one of the on the documents that indicated to me that they've been contracted by the Road Accident Fund to look at my matter. They also did an interview with me while during COVID. I remember I struggled to then go and borrow a laptop so that we can do this interview. And they also requested me to deposit an affidavit, which I did, and never had anything from them since. Until then, I was then charged with the fleet data contract.
And then I see from your evidence now that that they attempted to retrench you, but obviously didn't follow correct procedure. And so now I see that you've got an appeal coming up at the end of the month as well. Do you receive any salary from the Road Accident Fund or any financial benefit from the Road Accident Fund at the moment? Or
no, I don't. They stopped paying me in September. Yes.
All right. Thank you very much. I think that's
thank
all.
You,
yeah. Thank you.
Thank you very much, Honorable Atkinson. Honorable Maduna. He insists that he's not related to any suppliers of the Road Accident Fund. We spoke about a service provider to the Road Accident Fund who was Maduna. He just wants to place it on record that there is no relationship that he knows of between himself and... He says he's unaware, Mr. Modise. He's not aware.
May I also take this opportunity to put on record that I'm not related to Jacob Modise. I
don't know him.
Okay, noted, Mr. Modise. Noted.
I thought about that. No, thanks, Chair. And I thought about that when I figured that there was a Modise. No, Chair. No, thanks, Chair. I think my questions as well will be quite short. One, I just want to establish. One, who was the user department, or who did the panel of medical experts report to?
The panel of medical experts falls under the Chief Operating Officer, COO. So they are handled in an office at the RAF, which is called the Panel Management Office. So all the panels in that area, not this particular one, the panel of attorneys and the panel of medical experts. So the panel management office reports to the chief operating officer, yes.
So I assume that the current deputy chair of LPC is a former COO of RAF, right?
Don't know who you're talking about, sorry.
The current deputy chair of the legal practice is a former COO of RAF.
You need to read things out. So he's talking about the Legal Practice Council. So he's saying so please, so just be kind to Mr. Modise and maybe just explain your question.
No, I'm saying, Mr. Modise, if you are saying that there is the panel of medical experts, also the panel of attorneys, report to an officer who's handling panels who reports to the COO. I'm asking if the current deputy chair of Legal Practice Council is a former COO of RAF. Is that correct, Chair?
I don't know her name. What is her name?
Please help me, Chair. I just can't recall.
No, so there was okay, maybe just tell Mr. Modise why you're asking. Because the fact is, one of the senior officials at the Legal Practice Council used to work for the Road Accident Fund. I'm not certain what role he played, but he was in senior management at some point. So maybe what will help Honorable Maduna is to tell him why you're asking.
Or the name, because...
Or are you wanting to find out the name? Okay, he's now looking for it on his phone. No, you know what we'll do is the Secretariat can find the list of names of people who appeared at that time and then provide it.
No, it's fine, Chair. We can continue. We'll get back to it later. Okay, thanks. I just want to check. At RAF, you would ordinarily have an annual approved procurement plan.
Correct.
Thank you. And then what would be the process of advertisement after, obviously, the procurement plan has been board approved? What would then be the process from the user departments when they are kickstarting the process of the procuring exercise as per the procurement plan?
Yes, thank you for that. We have a demand, we call it demand management plan, which is linked with the budget of the RAF, where the a business unit will indicate the services that they have and the tenders that they will want to go out on for those services. So that will then inform the demand management plan, which is then sent also to, which is approved by the board and also sent to National Treasury for their records.
Okay, thanks. Then I would assume that after the specification would have said and deliberated on the specifics, then you would issue an advert, right?
Correct, if that is on the DMP, demand management plan.
Would it be correct of me to assume that then the CEO would have to approve that the specification process went accordingly before the advertisement?
I'm not sure how you bring the CEO into specifications, because the specifications are done by the expert department which requires those services. So if the panel of attorneys is under the COO will then have an official within the COO, not the CEO himself or herself, but the official that is managing that panel will then be aware that we need to go on tender on this specific project.
Okay, thanks. My assumption is that you sit a specification, there is a specification committee as per your affidavit. That would then receive the specification as prepared by that user department.
Correct. As I indicated when we started, Chair, the bid specification committee is then put up together after the requesting business unit has given us a request to say we want to source these services. We'll then put a committee together with has cross-functional team members who will then assist the business unit in quantifying, in actually beefing up the specifications to make sure that we are able to evaluate when proposals are received. Yes.
So after this process, I'm asking after this process, before, because my assumption, you might correct me, my assumption is that when the advert is then, when you then advertise the tender, the COO as the CEO, as an accounting officer, would have to sign the advert. Is that correct?
No, it's not correct. Remember, the functions of the COO as an executive don't necessarily have to have the signature of the CEO. The CEO has appointed the COO to be responsible for the functions of the COO. So the COO, being the executive of that unit, knows what is required and will work in terms of the budget, which is in line with their services to say, we're going to need this panel at this date. Then the specifications will then be put together. The COO will have delegated officials that will sit with SCM team, consolidating, having a team consolidating all the inputs to finalize the drafting of specifications. The CEO has nothing to do with that because he appointed the COO to be responsible for that commodity.
No, I get that, Mr. Modise. What I'm asking specifically, when the advert is issued, when I go on a website, I see an advert of a tender, or I go to a newspaper, I see an advert of a tender from RAF, whose signature does that particular tender tend to have?
The tender that appears, that little paper that invites people for...
That's what I'm asking.
Yes.
Who approve it for issue? Who signs?
It's issued by supply chain management.
And signed, not signed by the accounting office?
No.
Okay, thank you.
The value of it depends. The value of it, it's less than the threshold of a DOI.
Well, let's just say in this case it's above 20 million.
No, there is no advert that can be 20 million, my good sir. To advertise on public paper.
Sorry, can I just intervene? I've stopped the clock, Honorable Matun, with 1 minute 22 seconds remaining. But I've stopped the clock. So, Mr. Modise and Mr. I'm just gonna try and make sure we don't talk past each other. So, and Honorable Matuna, if I'm wrong, correct me. So what you are telling, what Mr. Honorable Matuna is asking is, when you've finished drafting the advertisement, walk us through the process. So if I am the procurer in the business, I'm the one who needs the service in legal or IT or whatever the case is. Supply chain draw up the advertisement. Do you just issue it, or do you bring it back to me to say, here is the advertisement, are you happy with it? And then if they're happy with it, then it gets issued. I think that's what Honorable Matuna is asking. Am I correct? Yes, that's what he's asking.
Okay, so sorry, my apologies for misunderstanding you. Say yes, the advert, the drafting of it, in terms of, remember it's a short document. I mean, it's a short pamphlet. It is done in consultation with the requesting business unit in terms of how do we explain these services that we want in a way that the market will understand, and the date of the closing date and all the addresses and all those things. So that is done by the business unit, by SCM in consultation with the business unit.
So, Chair, what I'm asking is, that document, whose signature does it have?
It's not a document, it's a pamphlet. It's one pager that is going to appear on paper. We agree with the business unit to say, is this how we want it to read? Invitation for a tender for the specification of what we need, cleaning services, the date, closing date is this, opening date is this, deposit at this area. It's signed, it's agreed by the parties and published on paper.
I agree with that, Mr. Modise. But what I want to understand is that, Chair, please pardon me. What I would usually understand is that an advert or a document from within the organization, when you are inviting bids, you would then have someone that obviously that advertisement, for it to be legit, we must have someone's signature. I'm asking on the advertisement, when RAF is advertising for anything for that matter, leave alone for the codes that you just source the codes. I'm asking for tenders, your 14 days tenders. Who signs the advert, the actual advert itself?
It will be the SCM, GM SCM.
So I would assume that this GMSCM, but when, oh, sorry, Chair, I know, I'm bad.
You are out of time, and I am worried that you are not getting to the point. So
yes.
My advice is, can you just say to Mr. Modise what you are getting to? Otherwise, I think we will go around to put a proposition to him.
No, Mr. Modise, what I want to understand is that my assumption one would have been that when you put an advert, because it usually has financial implication, it would be either the CEO or a delegated official that would sign. That's one. Two, it then comes down to the appointment letter, Chair. When you're appointing, depending on the value, whether the board chair or a delegated official or the CEO, I wanted to check, because my question wanted to go to a thing that says, when you extend the validity of a tender, maybe with RAF you are doing it differently, because you can go to any department, you would find the signature of a DG in an extension, not of the XM or SCM official. That's where I was going, because I wanted to understand who signs the advert at first. But I think, Chair, I understand it when he says that the GM, the general manager, SCM, is the one that signs a tender advert. I think then it would make sense to me that even when the validity is being extended, it's also being signed by that particular person. That's the point that I wanted to drive. Thank you.
Yeah, so I don't want us to lose the benefit of this conversation. So I am going to try and get us to, and I'm not interrogating you, I'm just now trying to make sure that we are all on the same page, because we are a committee. So what triggers the question in your mind is the fact that the extension of the bid validity period is done by SCM, but the kicking off of the bidding process via the advertisement is approved by the requester of the services, right? And so you are trying to reconcile the two, to say, if at the beginning of the process you need the sign-off of the requester, why is it that you can't go back to the requester to extend the bid validity period? Is that where we are? And maybe, so I don't want to just cut you off for the sake of time. Now that we have reframed it, I am going to give you, Mr. Modise, another opportunity to maybe at least address the issues from Mr. Maduna's perspective.
Thank you for that clarity, Chair. Yeah, we're missing each other, but the tender, the advert, everything that you see from the initiation stage of a business unit coming to supply chain saying, I need these services. From that point on, everything is done by supply chain in consultation with the business unit. So supply chain owns the whole tender process. So the advert, that piece of paper that you see on there, it would have been agreed to with the business unit, signed off by the supply chain. The bid validity period has got nothing to do, it doesn't have a value. Remember, we're just saying, please keep your proposal or quotation as it is. Don't change it. So there is no value, there is nothing. We're just asking you to bear with us since we are busy with the procurement process. Keep the quotation as it is, and then we sign it. You acknowledge, yes, I'll keep the proposal, I won't change it. Thank you very much. And then we continue with the adjudication. I'm not sure if I've answered you.
Are you served now, Honorable Matuna?
I think we'll revisit it later, Chair.
I will make another attempt later on.
If you remember when we spoke with National Treasurer, I did pose this question, and now I know it makes sense. I asked it particularly for this moment. If you remember when I asked them about the validity of a tender and so on, if you remember that conversation.
Is that when you were talking about the TLBs and establishing a site?
Yes, Chair. I asked it for this moment because I wanted to determine who has the responsibility to extend the validity of a tender. And they continuously said the accounting officer is responsible. That is why even now I'm asking who signs the advertisement for RAF to go to advert, because that is the same person that must be responsible for extension.
Okay, now I get you, Honorable Matuna. Mr. Modise, the committee will resolve this issue because because what you were asking then, there was a specific situation that you asked. You said, if the winning bidder, so there's already been a winning bidder, I remember your question. There's already been a winning bidder, and the winning bidder decides they can't do the work. But they'd already done site establishment and so on, and they decide for whatever reason, I'm walking away. What happens then? Do you simply go back to number 2? And there was a whole discussion around that, which is not the same circumstance here. Okay, we'll come back to it. Thank you. No, we'll come back to it. Honorable Bila, Mr. Modise, you will have to bear with us. So, because there were people that came before, we asked some questions last week of the Treasury and the Auditor General and your colleagues at the RAF, because we wanted to understand process and so on. So, there might be one or two of these cases where we're doing this. So, Honorable Matuna is now trying to compare your answers to what we were told last week. So let it percolate in his mind, and then we will come back and make another attempt at it. Honorable Bila.
Thank you, Chair. And greetings to Mr. Modise.
Greetings, Honorable.
Yes. My first question will be on the panel Anthony cancellation, but I think it has been explained enough. But I just want to check the financial implications on that cancellation of panel of Anthony's. What financial impact has the lapsing or cancellation of tenders, such as the panel Anthony's had on the REF? And how is this being mitigated?
I got suspended, my honourable member. So I don't know what has been happening. I thought you were asking about the irregularities in terms of cancelling it after having ran this tender since 2018, and I attempted to address that earlier on in terms of the costs involved that the members have incurred when they were evaluating this tender. That is procurement space. That's all that I can say in terms of that.
So on the issue of accountability and reporting, I know that you were suspended. As the REF board conducted a thorough review of the decision made by the former CEO and other executives that led to irregular expenditure.
I would like to believe if they did, and they did a good job, I wouldn't be here. I'll be at work doing my job.
Okay. No, thanks. On paragraph 90, from 90 to 92, if I'm not mistaken, on your affidavit, where you stated that you received an internal ref communication on your personal email on the 7th of May 2020. And after that paragraph, followed paragraph number 91, where you were called to go and explain why the leakage of your suspension letter. Can you please explain more on that 2 paragraphs or 3?
Thank you, Chair. This was at the time where I was still on suspension on the 7th of May 2020. As indicated, this is the challenge that the panel of attorneys were mounting or were bringing to the RAF in terms of the legality or the manner in which this tender was cancelled. And in their challenge, they had somehow gotten hold of my suspension letter, and they used that in their affidavit in challenging the road accident fund. And they then, after the road accident fund, people got to see that as annexed or as a document attached on the panel's firm's papers. They then contacted me on the 7th of May 2020 and called upon me to explain to them how did my confidential letter reach the attorneys, and under the suspicion that I have leaked it to the panel of attorneys. This actually was the first time I knew that there is such a challenge. So I couldn't know. I didn't know, Sham. I just told them that they need to do an investigation, because if they do an investigation, then it will pinpoint who had leaked that letter, but it was not from me.
Meaning the letter was supposed to be seen by you only, even if you want to take it to your lawyers?
I suppose so.
I'm done, Chair.
Thank you, Honorable Pila. Honorable Nilmay.
No, thank you, Chair, and thank you, Mr. Modise, for coming forward and for sharing your story with us. Your testimony sheds light on serious issues within the Road Accident Fund, issues that speak to a total disregard for workers' rights, human rights, and the abuse of power by the former CEO. We appreciate your courage in speaking out. Chair, I want to go to, it is on page 3. You speak about the minister's visit to the Road Accident Fund. And you also spoke about compliance, and we can see that you really took your compliance very seriously. The minister spoke about 5 priorities. Can you remind us what those 5 priorities were, specifically the one priority that was relating to supply chain management? The CEO also spoke about compliance with the PFMA, if I'm not mistaken.
Thank you, Chair. I also, I think I did forward it to the Parliament people. The media release, is it the media release, Fatima? Where where it summarized these 5 pillars. I don't know them by hand now, but those I'm trying to check on my email to Fatima, where I attached where the minister spoke about these 5 pillars.
Can we just, in the meantime, Honorable Meso, can we just locate that email? I'm not certain now whether that is not in the group of documents sent on email to members.
My apologies, Chair. Let me correct that. It was not. It was actually summarized on a case, on a case that was brought against the ref by, what's this? For FISMA and others. It's a judgment. On the judgment, they summarize also those 5 pillars that the minister had indicated in his media briefing on the 5th of December.
Thank you. Can I follow up? So obviously the extension, when it came to the panel of attorneys, that then was also non-compliant with regards to the cancellation, because the board had not approved that. So it looks as though there was that contradiction of where the minister and everybody was speaking about compliance, yet on the other hand, there was no compliance. I didn't quite remember, how long did you extend that current panel of attorneys for? Because my follow-up question would be related to that.
Just check that. I think I extended it to somewhere in June. I'm trying to...
Was it a few months only? That's what I was trying to see. Was it 1 year? Was it 6 months? Because I can understand, I understand the supply chain management system. So you cannot not have a contract in place. So I do understand that. And from the compliance point of view, I just wanted to check how long did you, in that interim, it was just the extension. How long was the extension for?
You mean the extension of the SLA that was currently in place?
Yes.
Of the current panel? I'm trying to check that. Sorry, Honourable. I don't know if I listed. Can we come back to that, honourable member, while I'm checking it?
Chair, because the follow-up is that why was there such an urgency to cancel that process, noting that the minister and the CEO himself had said that there has to be compliance? And why was there such an urgency to cancel? Because when one has a look at the steps that were followed, and that was that the corporate attorneys firms that were already with the Road Accident Fund were then seconded to the state attorney. My question is, where did the state attorney's office come into this whole picture? At what stage were they brought into this arrangement? And was there a letter to the judiciary requesting, requesting permission? And was National Treasury consulted?
All the extensions that we were doing at that time had to get a National Treasury support. So National Treasury would have given us the support or the approval to extend the contract. I'm just missing the part of how long was it extended for. I can't say it here.
Chair, I'm sorry, I didn't quite hear. Did he say National Treasury did? Yes. So National Treasury did approve that. Then the question that I came back to is, given the challenges with the state attorney model, including delays in settling claims and capacity issues, Did the Road Accident Fund conduct a cost-benefit analysis to evaluate its effectiveness compared to the previous model?
I was not part of that. I'm sorry, ma'am.
Chair, my last question is, in your affidavit, you spoke about the sale and leaseback contract that seemed to have irritated the CEO, if I'm not mistaken, in the way I read this. Can you just enlighten us as to what do you mean about the sale and leaseback contract? Was the Road Accident Fund purchasing vehicles, then leasing it or reselling them to suppliers and then leasing them back? Is that what it was? Or what is this whole issue about leaseback contract?
Thank you, Chair. The leaseback contract, I think SIU spoke about it the other day, is the fleet management data contract, the one that I ended up going on CCMA for. So the way I understand it is that when that contract was put together, RAF already had cars that it owned. And they said they don't want to be, they want to outsource this, maintaining these cars and also adding cars, but not not buying cars. So they were saying to this service provider, we already have, for instance, these 50 cars. You buy them from us, and you lease them back to us, adding other cars that we need in other offices, of course. So that's where they agreed on that 5.2 million to sell those number of cars to this company, for this company to then lease them back to the RAF. If I might add also, Chair, I heard you speaking with the SIU on this. The car had, during my time, the cars had devalued well, I don't know how to put it.
Depreciated.
Depreciated, yes, quite extensively. But we met with the service provider to try and say, okay, for how much have they been depreciated for at one stage, and give us an offer so that we can then look at, because we understand that many officials have done whatever that they did, but what is it that we can recoup from the amount that, because they couldn't give you 5.2 at that time. Then they gave us an offer of about 3 point something million, but the board did not accept it. They wanted their 5.2. So that's how that whole process then disappeared. If we took that 3 point whatever million, by now at least it would have meant something than the whole 5.2 million.
Thank you, Honorable Nilmay. Honorable Beasley.
Thank you, Chair, and greetings.
Greetings to you, Honorable Member.
No, thank you so much. Yeah, so I'm just going to refer to the paragraphs in your affidavit. In 14, the Minister said one of the challenges, or one of the priority areas was SCM. Were there any issues with SCM at that stage, in terms of your own personal performance, SCM division, that you were aware of?
This was quite a worrying factor for me, honourable members, because as you'll record, as you'll see on my affidavit, I have indicated that the REF had achieved clean audit for the year ending 31st March 2020. Now, when the minister comes and say, I want to, maybe we need to look at this broken, a car that is not broken, on how to fix it. It was a worry for us, especially to my supply chain team, because when you talk about a structural review, people are now worried that they're going to lose their job. They say no, but then the CEO has met other departments. He has not met supply chain, but he's talking about restructuring supply chain. Can we have an engagement with the CEO to understand even what the minister was indicating? Why are you reviewing something that has given you such results? Where does this come from? So that's what prompted the meeting of 13 December 2019.
In paragraph 19, the acting CEO refers to difficult decisions were going to be taken. Do you know what those difficult decisions he was referring to? If not, it's fine.
Yes, I don't know. I don't want to assume.
Okay, perfect. Then under paragraph 31, you say the board did not endorse a delegation. Again, you know, I may be putting you in a position of the board, but do you know why, you know, logically, what reason could have they had for not endorsing the delegation when it seems a logical thing to do? Is there any rationale behind them not delegating the authority when they've done it in the past?
I do know, but it's a bit personal. I don't think I need to share it with the public. But it was involving some board members and the current acting CEO at the time.
I appreciate that. Thank you. And then under paragraph 35, the CEO writes there, I hereby give this delegated authority to name withheld. Just want to confirm with you that that is an illegal instruction in terms of the SCM processes.
Say that again, Honourable Member.
Okay, so in his email, he says, I hereby give this delegated authority to X, as she is familiar with this contract. I just want to confirm that that is a illegal instruction.
No, it's not a legal instruction. As a matter of fact, there is a delegation form that you complete at the RAF.
I think there's something is getting lost in translation. I think that the easier term, or more applicable specific term, is lawful or unlawful, because you are saying illegal, he thinks you are saying legal.
I appreciate that. English is not my first language.
Oh,
it's beach slang, yeah. So, Brew, so is it a lawful instruction for the CEO to delegate the authority to X?
Thank you, Chair. Thank you, Honourable Member. I've indicated it. Hence, I then wanted to advise my executives in terms of compliance and governance issues to say we had already engaged the board to request them to delegate to the COO, which the board did not approve. They said the acting CEO must sign. Now, if the board has said that that's where it ends, it means those contracts should have been continued to be signed by the acting CEO, and nowhere in the resolution did it say the acting CEO can sub-delegate. Because if they did that, it wouldn't have made sense, because that's what we asked them to do in the first place. But they said, no, the acting CEO must sign.
And then just in paragraph 45, and this is not a criticism, and I appreciate your honesty when you say you capitulated, and you wrote there, I agree that nowhere it's written that the CEO is not empowered to delegate his powers further. What drove you to that again, English is not my first language, capitulation?
Paragraph what again?
45.
45. Yes, this comes from 43, which then speaks to the email that I then received from the acting CEO. You can imagine on this email, the COO was copied, the CFO was copied, the CS CSC, Chief Strategic Officer, was copied. The GM in the office of the CEO was copied. And I give an advice to say, let's go and ask the board to rescind this so that it can be in line with that which you are now asking, that the CEO must then sign. I'm trying to cover also him to say the resolution from the board didn't give you the right to subdelegate. So let's go to the board and say, since you are not familiar with this contract, let them rescind that a previous resolution and give you a new one to say you can now delegate to the COO. And his response then was that to me, and I read, is there anywhere written, John, that this delegation power cannot be delegated further to any functionary by the acting CEO? I wonder why you take a legal position when you are not in SCM. You seem hell-bent on impeding progress. No wonder it takes forever for SCM to execute anything. I find this rather disturbing. The COO has full knowledge of this contract, and it makes sense that I delegate to her to sign, applying her mind, of course. So my capitulation is based on the fact that here is the CEO, I'm junior staff, and this is the email that I receive. It's on a Friday. Now I need to respond because I seem to have been too forward in trying to assist. Maybe I should have done it the other way, but then this is what costed me to be where we are today.
I appreciate that. Thank you for your honesty. And then I'm just trying to rack my brains behind the rationality to cancel the panel of attorneys the way it was actually done. Because if it was to benefit 63 state attorneys, there's been a huge cost to it. Who do you think the winners in this rash decision actually are? And is there any rationality behind that decision? Because it only seems to be losers in this whole episode. Only people are 63 state attorneys, and so many people have faced huge consequences. So who do you think the winners behind this decision actually were, if any?
I prefer not to answer that. So.
No, I appreciate that. And then the last question, just you reported to the general manager, the SCM, is that correct?
That's correct, Honourable Member.
Is he still employed? Did he defend you in any of these issues? And did you chat to him about your concerns? You know, he seems to be absent in all of this. Thank you.
Thank you for that. And the gentleman that I referred to, which when I was answering Honourable Member Mente, is actually like a father to me. I was actually blessed when he was charged with me through the CCMA case, because then I started understanding how come he then acted, how he did. Even when he gave me a suspension letter, he was actually at pains to give it to me. It was quite painful. So he nonetheless did that, and he has been my support ever since. So, yeah.
Thank you very much, honourable members. Mr. Modise, thank you very much so far. I just want to say that we really appreciate. I do have a couple of questions so that we can link, given your experience in the role that you're in, you can assist us from your own knowledge in terms of some of the issues that we were dealing with Mr. Lehomo and Mr. Mhlanga. But firstly, I just want to say we really appreciate you coming to assist the committee. And I know that in the process of consultation to get to this point, the committee were really at pains, the staff, to say, we know how deeply affected you are by the labor relations issues, but the committee is constrained by its mandate to focus on a particular aspect which relates to the finances of the organization. And we appreciate both you and to you, Mr. Lehomo and Mr. Mhlanga. We really appreciate that. I'm going to ask some questions. Firstly, I will just say for the members, I asked the staff to pull out some documents and distribute to the members which are helpful. One of those is the delegation of authority by the Road Accident Fund document. You might not, it should be familiar to you, Mr. Modise, because it confirms what you're saying. But on page 8 in the documents that you have, it's the delegation of authority, SCM operational delegation of authority. On page 8, item number 14, it's a section 7223.4F of the SCM directive, approval of extension of tender closing date greater than $1 million. That's the HOD SCM. And then it says applicable for tenders only. And that document is signed by the chief executive of the Road Accident Fund. So I'm just saying there are some documents that I've asked the committee to just pull out. They are in your memory stick, but I've asked them to pull out for you to look at. The SCM policy has also been emailed to you. That's for our deliberations in future. So I just want to thank, and also to thank you, Mr. Modise. It does confirm what you said to us earlier.
Thank you, sir.
I just want to ask some final questions. So earlier, I think it's before you got here, what Mr. Lehomo and Mr. Mhlanga said to us was that sometimes it happens that the budget allocated for procurement is not enough. As experts in security, for instance, they could see that to get 3 people to protect the CEO is not going to cover. They suspected that it might not be enough, right? Because when you get the bids and they're higher than, so you don't get a bid that is within the budget allocated. Can you just explain to the committee the process that then takes place in order to make sure that there is a decision either to go ahead or to maybe abandon? I'm assuming that in this case, the directive had come from basically the board set the number and then SCM then procured and so on. I don't know if you've got personal knowledge of this. If you don't, it's okay. We just want guidance on, at the Road Accident Fund, what is the process then? Who gives the ultimate say in terms of increasing that number that had been set? In this case, it's the board. If this had come across your desk, what would have been the process? We just want to understand process. We're not getting into the merits of it.
Thank you, Chair. And if you can also ask that question to the finance people so that they then clarify it better. But then I know that you will then have to go back to in your example, you'll have to go back to the board to then inform them that the service that you require, the market is at this value. And the process will then have to go back. If it was a budget, then they will have to engage finance to then see where money can come from to then increase this particular one for procurement to then continue.
So thank you very much. So I'm hearing you to say the person or body authorized to set the budget must be the one that says, okay, fine, you can take, we can take an extra 100,000, it's okay, we'll cover it. But they need to express themselves. Otherwise, SCM is not allowed to award higher than what the requester or the setter of the limit has decided.
Correct. That's what I'm saying, because what you then have in SCM is that this resolution which says go and procure for 500,000. When you go to the market, this thing is 700,000. You don't have a way of appointing for that amount because that's not what you have. So you have to go back to the board to say you approved 500 and the market is saying this thing is 700. So we need to then change your approval so that we can then be able to proceed with the procurement process. But you can't just continue with the procurement when the budget doesn't allow.
Thank you very much, Mr. Modise. So I'm going to jump around a bit, but we are almost done, I promise.
No problem.
So on the panel of medical experts, I'm just going to ask a couple of stupid questions, right? To just see how they measure up against what we were told last week. And these are not trick questions. The way we understood was that the Road Accident Fund retains its own panel of experts, because a claimant will come and say, my back specialist says I will never be able to run again, and in my job I'm supposed to run, and therefore I can't earn future income. The Road Accident Fund wants to make its own assessment of the same claimant so that it can see whether it must challenge this quantity, this conclusion and this quantity. Is that correct?
That is correct, because you can't take what you are given. You have to check if it's still market related.
All right. Thank you so much. So what I'm just wanting to establish, and if you are no longer there, then you must just let us know. So one of the people that will come to the inquiry basically says that in this time that you are talking about, where the previous panel, I think, it also expired, you don't yet have a new one. A lot fell between the cracks. Some medical experts were performing the work and then saying, I hope you guys are going to pay me. Others would be told that at a later stage that you are on the panel, but they wouldn't get the contract yet. I think you've enlightened us on the fact that they kept pushing, some of them kept pushing to say, well, when are you signing my thing? And they were piling up and so on, right? Can you just give us a sense of the operational impact of that period when there was no decision? Contracts were not being, were not being signed because only one person can sign and so on. Can you just give us a brief explanation, if you know, from an SCM perspective, what were you seeing as symptoms of this uncertainty?
Like I said, when we did the invited the medical expert professionals, we wanted to cover the whole country so that we don't have instances where claimants who suffer from or want a medical report on certain body parts cannot be assisted. So that was the aim. And it's something that maybe I'd like to ask the SCOPA to assist the Road Accident Fund with in terms of your recommendation, to then see how we can actually achieve that, because I've seen that the tender process for medical experts is not working, because these are people that think that they don't have to fill in a proposal to be on the panel. They just want to be in the panel and you need them. So in answering your question, it was that with the delays that were happening, it means the panel of attorneys could not use those panel of medical experts at that area. Or if they use them, then they want a guarantee that they were going to be paid. And if they are not paid, then they'll send emails to say, hey, I sent my SLA 2 months ago, it's still not returned. So the impact would have been the delay that the claimants will then suffer, because then the reports are not coming in time to then give to the attorneys, for the attorneys to be able to go to court and argue. So that's what I can...
Oh, so in other words, if the expert isn't paid, they then don't give the report to the attorney, which means the attorney doesn't have the information they need to defend the claim in court, in some cases.
That's what I yes.
Okay, no, I really appreciate that. That, and then the last point that I'd like to ask pertains to to the panel of attorneys, when the list of attorneys from the GEPF, and if this is not in your personal knowledge, you can just say, so please feel no obligation to answer something you don't know about, right? So what we understand is that initially when the RAF decided that it's not going to have a panel of attorneys for claims, right? It then asked the GEPF for a list of attorneys. According to the SIU, there were 19 on that panel. It eventually took on 14 or 15, if I remember. Let me just ask the following. How does that process ordinarily work, where one state entity is wanting to use a service such as this one that is available from another state entity? Can you just educate us on how that is done, what is put in place, who reaches out to whom, and so on? Can you do that if you know?
Thank you, Chair. We have done that before, actually, but not on the panel of attorneys. We did that with, I forget the entity. Okay, I'll remember the entity.
Yeah,
but what,
let's just say entity X.
Yes. So what we do is to engage that entity. Supply chain will do that. Engage the supply chain office of that entity to say, we are aware that you have these services which you procured through a public tender. Can we please ask that we participate in the services that you are inquiring from the same service provider? They call it transversal contract from another state entity. So you are saying, since they did a tender, and they came up with the panel of these experts, you want to use the same panel so that you can then allow yourself time while you are still planning to go out on tender. So what you require from them is the process that they followed. They need to exchange with you the documents of their tender process, that everything was on par. You need to satisfy yourself that they procured properly and there are no irregularities, and they will then share that with you, share the contracts of the service providers, not the contracts, share the list of those service providers with you. You'll then engage those service providers and sign contracts with those service providers.
Thank you so much. I think this is important for our purposes. So in other words, this entity that is wanting to use another one's services, you would then look at the bid specification as an example.
Correct.
Look at the bid evaluation.
Correct.
And then look at the bid adjudication.
Correct.
Satisfy yourself that it is something that you would have agreed with. So in other words, as far as we can see, when we look at the spec, we look at the evaluation, the scoring, and so on, these people are not going to give us problems once they start doing the work, because it's the process that would have followed. The requirements align, technical, pricing, and so on. We are happy, and therefore, on that basis, we are satisfied that we can participate.
You wouldn't want to participate in a contract and later find out that it was irregular appointed.
No, thank you very much. We will ask for that kind of information where this is concerned. I just want to ask one final question. So what are the approval processes if in the end, and the panel of attorneys would be something that would be over 20 million, right? Would that need to be approved by the board? At which level at the Road Accident Fund would that need to be approved? Anything over 20 million?
In terms of the DOA of the Road Accident Fund, it has to be approved by the board.
Okay, so the board would have then needed to approve the transversal part. Okay, thank you.
DOA looks at the value, the threshold. So if the threshold is the board level, the board must then approve that level.
All right, thank you so much. That's exceptionally useful. Can I ask, and I'll ask each of you one by one, which law firm represented the Road Accident Fund in your hearing, Mr. Modise?
I was actually laughing when you asked the SIU on the words that were used a lot, and I think it's Malachi is the one that was handling my CCMA case.
All right, thank you very much. Mr. Mhlanga, in your case, which law firm was it?
The same. Malachi.
Mr. Lehomo?
With mine, they were changing from hearing to, I can't even remember the name, but it was not Malachi, it was different firms.
May I ask, at the CCMA, was the road accident fund represented by attorneys, or was it represented by its own HR staff?
In my case, at some stage, my attorneys had to actually fight with the firm because we were going to that legal firm's offices for almost the whole year. And until we then said, you know what, we need to go to CCMA offices because they were getting paid for us using their offices. So we argued that we need to save funds of the fund and go to CCMA offices. We can't be using your offices for such a long time.
Are you telling me that the road accident fund so were you having the hearings and the meetings at the law firm's offices?
Correct.
Okay, so in other words, they were charging both for the actual legal work as well as the use of the premises.
Correct, and they had an advocate, an attorney.
Is this, at which stage? Is this a disciplinary stage?
It's a CCMA inquiry.
Okay, so the CCMA would go to the premises of the law firm of the road accident fund.
The commissioner used to be there with us every day.
Oh dear.
Not every day, on scheduled dates.
And the level of representation for the road accident fund, would there be an advocate or was it just an attorney? So more specifically, was a road accident fund represented by an employee of the road accident fund? In most companies, it's an HR person who goes.
In my case, it was the advocate and attorney. The ER person was just observer.
All right, thank you. Mr. Mhlanga, do you know in your case were your circumstances different in any way?
Almost similar, Chairperson.
Okay, you said almost, but tell us that bit that was different.
Okay. The only difference was every session happened at the CCMA except during disciplinary hearing. But during disciplinary hearing, it was a different attorney. I might not recall the name. But at CCMA, definitely it was Malachi.
Thank you. Mr. Lehomo, in your case?
They brought advocate for me at the CCMA, but we held the hearings at the CCMA offices.
All right, thank you very much. Okay. I want to know when you would receive the letters from suspension onwards, at which point did you start getting lawyers' letters? So your letter of suspension, who drafted that for you? Was it from the attorneys or is it from your manager?
The rough letter of suspension, I think they drafted it internally. We only started engaging them when they were putting together a chart sheet and deciding to combine my issue with that of the former acting CFO because they said it's the same matter, so they joined us.
Thank you. In the hearing itself, who was prosecuting the case? Was it an employee of the road accident fund or was it an attorney from outside? Because in most workplaces, basically the whole thing is conducted by staff, but at different levels. In this case, who was the prosecutor of the case?
In my case, it was the advocate and his or her attorney.
Mr. Mhlanga, in your case?
The same.
Thank you, Chair. Yeah, it's the same with me as well. It was attorneys.
All right. So what I'm understanding then is that notwithstanding the fact that from the very beginning of the process, the Road Accident Fund brought counsel and they were still not able to succeed with the cases, as it were. Because from what I hear from all your evidence, at least your evidence, Mr. Modise, it was first the suspension for one thing and then the other, and then it was the retrenchment. But basically, the Road Accident Fund, apart from its refusal to adhere with the court decision or with the decision of the CCMA, has not actually won in the real sense.
Mine was even more painful because at the beginning of the case, we tried to advise them that this thing that you are charging us with, awarding a fleet data contract, has nothing to do with us. We were not employed at the time, but they proceeded for 2 years.
How much has this cost you? Are you able to quantify the amount of money that you've so far spent on attorneys and on representation? Let me put it like that.
I used to pay my lawyers at least to try and throw 10,000 a month here and there. Sometimes I can't. But then after they gave me my package, I then tried to settle them. I think I paid them about 140,000. And I still owe because that was for the CCMA and all that. So it means for the labor case, I still have to pay. So I've lost all that I have.
Thank you very much. And I'm sorry. Mr. Mhlanga?
In terms of cost, from the hearing to arbitration and to this review, for the arbitration and the DC, I'll calculate around 150,000. And then when it comes to the review, because from time to time when you consult with the attorneys, they will tell you that the funds that we have deposited, they've depleted. So you need to add. From time to time, I will deposit maybe 25,000 with the help from the family. Luckily, for now, but at the end of the day, they will get tired.
Thank you. Mr. Lehomo?
Chair, mine is also in the region of 120 that I've spent, and I know that with the labor court review is gonna still go up and higher and higher and higher. So per session, you find that your attorneys will want something like 30,000 grant at a go, just to meet and then prepare something. And yeah, it's about 120. Chair.
All right. No, thank you very much. I must say, yeah, it's not easy listening to these experiences. It's not. It must be even worse for you and your families. And once again, I'm sorry that you've had to go through this. I want to thank you for assisting. I don't know if the members have any further questions. Honorable Maduna?
No, thanks, Chair. Just before you close, I just wanted to provide clarity, Chair, in terms of what I was speaking about. I managed to pull an advert of RAF, and I see that it doesn't have anyone's signature. To my surprise, I even sent you from departments and how an advert usually is, because now I'm questioning myself. How do we then determine whether it's a fake advert or whether it's a true advert if it's not signed by anyone? Yeah, and I also see I think it's 23 point 1 and it's 20.1. Sorry, it's 23.1 and so on. I see in the delegation in terms of how the responsibilities are delegated, and I think I make a conclusion that there's a problem of control environment at RAF. Thank you.
Thank you. No, we will canvass that with the senior people when they come later on. Can I just ask any of you if you've got any final comments you have for the committee, and please feel free. Let's start with Mr. Lehomo, and then it will be Mr. Mhlanga, and then we'll close off with Mr. Modise.
Thank you, Chair. I just want to thank you, Mr. Chairperson, for your leadership and the members of the committee for their deliberations. And I think had it not been for the Transport Ministry who intervened at the RAF, things might not have taken the turn that it has taken for us to come and sit here. So I would like to thank the Minister of Transport, Barbara Chris, and the Deputy Minister, Mr. Mhlanga. And I would like to thank all the people who supported me and Mr. Mhlanga during this difficult time, and the colleagues who are, some of whom were compromised and some of whom are victims, some are still sitting at home, and some are at work. So I would like to thank them as well, and thank you, Chair.
You don't have to say anything if you don't want, so it's not an obligation, it's an opportunity that I'm making available for you to make closing remarks.
Thank you very much, Chair, for the opportunity, and to the committee at large for affording us this opportunity, more especially to show accountability, because in these organizations or in government, in the public entities, it's public money that is being used. If it's not used correctly, some people must account. And then again, I would like to thank even my family for the support that they've given me. My colleague Matume, since day one, when we were suspended together, we have been in this journey. We have moved. So we have moved to the level where it became even a joke, this thing, though it's painful, but we ended up turning it to a joke to say sometimes whatever that has happened, it might have been a blessing in disguise, because we might have finding ourselves being muddied by whatever that has happened in the organization. Thank you very much, Chair.
Thank you. Mr. Modise, final comments?
Yes, I concur. I wouldn't want to repeat what my colleagues are saying. And I do appreciate, again, I repeat, that the SCOPA is not here to look at labor issues, but at least just to look at the human part of it, because all those people, the employees especially, are the ones that have been assisting the RAF to be driven the way it was. We really did our best until we started in this accident collision that started in 2019. But then in terms of giving my thanks, I'd like to start with you for giving us a chance. I know you received hundreds of submissions, but you chose ours. And I always told my wife that, no, God is using me. So thank you for that to him, that I'm here today to share with the public. And also from supply chain point of view, we are at pains in many state entities when people that are not really principled are given so much power without being checked, because they then end up destroying people's lives. I've had to lose about 3 interviews, because every time they call me, I feel obliged to indicate to them my position. And as you will know, as a manager, when you hear somebody saying, I'm going through this, you don't want to be tainted with that. So, and supply chain being an area of reputation, it's really, even now, without a second plan, it's going to be difficult because it's not something that I want to talk about. I've never been involved in any disciplinary process. I've always been God-fearing, but here I am. But I'd like to thank you for this opportunity. And I hope that this will assist a lot of employees that have gone through this, especially the ones that have passed. May their soul rest in peace. And that we pray that at least something positive comes out of this and people are assisted so that the ref can be brought back to what it's supposed to do, to assist the claimants, not to be dealing with labor issues when people are trying to do their work. I mean, I have experience. I have 22 years in supply chain, but that has been brought to nothing outside of just somebody just being vile and evil. But let me end it there before I cry again. Thank you very much.
No, thank you, Mr. Modise. And honorable members, thank you very much. Tomorrow, so can you please take note, honorable members, of the email sent? There is a briefing document. There won't be a presentation. We're looking at the 2 media contracts for 500 million rand each. We'll have Mr. Macintosh Polela here. The team have looked at both contracts and they've written a briefing document. I really won't do what I was doing. It's not an affidavit, so I won't lead through 2 contracts. They're too long. So we will, I'll just ask Mr. Polela to just take us through his job function, how the contracts came about. That's it. And then we'll go to questions. We won't lead through the questions. So if you can please just pay attention to that. I will also ask the committee staff to just, for some of the conversation today, for ease of reference for you, and I'm sorry to burden you, some of the documents referred to, the issues referred to, just to pull out those documents. We'll do the work in the evening. Just pull out some of those documents and email them so the members can find them, but they really are in the memory stick and on the shared drive. Thank you very much. We'll convene tomorrow. Sis Ndombi, do we have transport tomorrow? Yeah, please, let's just see if we can make a plan so the members can get here on time. Thank you very much, colleagues. And once again, thank you so much.
Thank you, Chair.